filed an application for extension of arbitrator mandate. Huh? I'm sorry.
Yes.
Question matters, list number 1, serial number 1, Virupakshaya, PX.
The petitioner has sought for a writ of mandamus, my lord, to the second respondent authority, my lord. As per Annexure A, my lord, page 12, my lord. As per Panchayat Parikat, my lord, the petitioner acquired, my lord, the property which is situated, my lord, as per the Panchayat Parikat, my lord.
Khata.
For effecting Kata, my lords, in the name of the petitioner. My lords, as per Annexure A, page 12, my lord, in terms of the Panchayat Parikat, my lord, the property in question, my lords, has fallen to
The AGA takes notice for respondent number 1. Learned Counsel Shri MS Devaraju is requested to take notice for respondent number 2. Learned Counsel for petitioner is directed to serve copies of the petition along with annexures on the learned AGA and learned Counsel Shri MS Devaraju. Yes.
Serial number 2,
may I request for
Gopala
me.
Krishna.
May I request for
For the petitioner, my lord. Petitioner is awarded a LOI from the Indian Oil Corporation Limited
Huh?
for establishing the retail outlet, my lord.
Huh?
For establishing the retail outlet at Venkatamnalli village.
Huh?
And the PDO has been asked to give the NOC. PDO, in spite of the letters given by the Indian Oil Corporation Limited and by the petitioner under Sakala, while annexure C and D, and though he acknowledges till date he has not taken any action, therefore I have filed the writ of mandamus, my lord. And Rule 144 of the Petroleum Rules is the district magistrate who has the authority to give the NOC. He refers to all the authorities, PWD, fire and all. They have to submit in turn their reports. His PDO has not submitted his report.
Where is the communication that has gone from the deputy commissioner?
Deputy Commissioner, that is internal, they have, IOC has given the communication to the Deputy Commissioner.
If there is no information on record, how can we direct them, sir?
There are letters,
Huh?
my lord, to the PDO,
Huh?
annexure C and annexure D may kindly be looked at, my lord. Annexure D, NOC for the proposed retail outlet at survey number 148 of Kathgaran Challi village, Pavada, Tumkur district. It is dated 12/12/2002.
Plan for further processing.
Please, my lord.
We are attaching plans for further processing. No objection certificate at your end.
A plan is also along with the NOC drawing is also sent, my lord, to all the authorities. And it is received by him at annexure F, my lord. Annexure F, page 38. PDO receives. Nallur Ram Panchayati Vaptiya, Kathgaram Challu Gramada, Bhuparvatita Jameen Astili, Indian Oil Corporation Petrol Bunk Karjidaru.
Learned Counsel Shri MS Devaraju is requested to take notice for respondent number 1. Learned AGA takes notice for respondent number 2. Learned Counsel for petitioner is directed to serve copies of the petition along with annexures on the Learned Counsel for respondent number 1 and the Learned AGA. Full stop. Next para. Release this matter on 26th of June.
Much obliged.
Please serve a copy.
I will, sir.
Serial number 3, Vasant Kumar HT. Vasant Kumar HT. Serial number 3.
Learned AGA takes notice for respondent number 1. Learned Counsel Shri A.V. Gangadharappa is requested to take notice for response number 2 and 3. Learned Counsel for the petitioner is directed to serve copies of the petition along with annexures on the Learned AGA and Learned Counsel Shri A.V. Gangadharappa.
Serial number 4. Rakshit Kumar.
Was appearing for petitioner, my lords. Here the petitioner is challenging the election being held for post of the president, my lords. My lords, one of the director who has been appointed through elections, my lords, he was a president who passed away on 12/2/2024, my lords. It's about 4 months back, my lords. My lords, as per provision of Cooperative Societies Act 29F, my lords.
Who passed away?
It's the president, my lords.
Of the third respondent society.
Please, my lords.
Ah,
As per the provisions, my lords, the corporate 29F6, my lords. 29E and 29F, relying upon, my lords. 29E is filling up of casual vacancy in the office members of the board. Any vacancy in the office of members of the board of a cooperative society by reason of death, resignation, removal, or otherwise shall be filled up in such manner as may be specified in the bylaws of the such society, my lords. Here, the law says, my lords, what provisions, it's, the present committee has constituted in 2020 January, my lords, 20th January 2020. So it will expire on 2025 January. So it's 8 months. This one is pending, my lords. Term is pending. Here,
only less than half the term.
half a term. So either they can co-opt if there is any option for the, they co-opt the member as a board of director, or they can go for an election also, if there is no co-option, my lords. Or if that is not done, then the registrar has to appoint someone as a director. That's the procedure, my lords.
To fill up the casual vacancy.
To fill up the casual vacancy.
Yes.
Either death or any other,
Yes.
for any reasons.
Hmm.
Here, even after death of 4 months, my lords, they have not done anything. Now, without filling up the casual vacancy, my lords, they are going for the election of the president.
Hmm.
So one post is still vacant.
Hmm.
And is one of the petitioner is one of the aspirant for that post, my lords. So if it is election conducted, even for a co-option, my lords. But now, without that being the post is vacant, my lords, they are going for election today. Hence, the petitioner has approached this honorable court to stay the election procedure.
No question of staying any election process.
My lords, here, the provision itself, because his right will be
No,
contained,
no,
my
no.
lords, because
No question of staying any election process, sir. Learned AG, HCGP takes notice for respondent number 1, 4 and 5. Learned Counsel Shri TL Kiran Kumar is requested to take notice for respondent number 2. Issue notice to respondent number 3. Learned Counsel for petitioner is directed to serve copies of the writ petition along with annexures on the learned AGA and learned Counsel Shri TL Kiran Kumar. Full stop. Next para. Since it is the contention of the petitioner that the impugned election for which calendar of events have been issued on 11/6/2024, fixing the date of election as
19/6.
19/6/2024 is in violation of the provisions of the Karnataka Cooperative Societies Act, the election and the results of the election shall be subject to the final outcome of this writ petition. Yes.
May I request for hand summons to this
Then it can.
respond number
Huh?
hand summons to respond number 3 and 4, my lords. So that I can next week itself file
3A, the society.
society and 4 returning officer.
Returning officer is taken notice.
Returning officer.
Society ಏನಿದೆ ಏನಿಲ್ಲ role. Let us see. Yes.
May I
Number
request for
5.
a date, my lords? Date on next.
Yes.
Arnav V. Bagalwadi. Number 5.
Hearing for the petitioner. This petition is challenging the notice at annexure A, page 14, for alleged encroachment that is based on a complaint that is filed by one private citizen, one Mr. CJ Alberts, who's using the office of the respondent to settle private scores, my lords.
Why have you not made him a party?
Lords, I'll take steps, my lords. The only reason, my lords, we will go to.
When you know someone has complained against you,
I'll take.
you don't want to become a party.
I'll take steps. My lords, may kindly look to page number 78, annexure N. This is the letter that is, although not directed to us, it was sent to us to the petitioner. My lords will see at page 67, the address of the petitioner. My lords, this letter is captioned fraud by Ponaya family to take away Christ Church property, false trust and impostor bishop. My lords will come to page 81. Options available. All the offenders of fraud and beneficiaries of crime should return 8,746 square feet of land to Christ Church. This entails demolishing illegal constructed apartment on the said land of church, face recovery proceedings, simultaneously face criminal proceedings under forgery.
Oh, all right. What is the notice that is sent to you?
My lords, notice is sent that we are encroaching lands belonging to the corporation. When the genesis of this notice is based on a complaint by this CJM Albert, my lords.
What is the allegation in the notice, sir?
My lords, notice says that I have
Where is the notice?
notice at page number 14, annexure A,
Yes.
which it clearly says, my lords, that based on the complaint, 13-5 complaint, 13-5-2024, there is a complaint that has been sent to respond number 2.
ಪಾಲಿಕೆಯ ಓಣಿ ಜಾಗವನ್ನು ಒತ್ತುವರಿ ಮಾಡಿಕೊಂಡು ಅಪಾರ್ಟ್ಮೆಂಟ್ ನಿರ್ಮಿಸುವುದಾಗಿ ಜಂಟಿ ತಪಾಸಣೆ ನಿರ್ಣಯದಂತೆ ವಸತಿ ಸಮುಚ್ಚಯ ಕಟ್ಟಡಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟ ದಾಖಲಾತಿಗಳನ್ನು ಪರಿಶೀಲಿಸಲು ಉದ್ದೇಶಿಸಲಾಗುತ್ತದೆ. 12-6.
My lords, what is important, my lords, is that
They have called upon you to produce all the documents.
please, my lords, but this,
You didn't go and participate in.
my lords, I have sent a notice, my lords, a reply to the notice, my lords will get at page number 77. I have sought for the complaint. That is the genesis of this notice. That is at page number 77, annexure M.
You are required to go and produce the documents to show that you are not committed any illegality.
Please, my
Instead
lord.
of doing that, you are asking for a copy of the complaint. What is the use?
My lords, I have produced before
And
this
you have
court.
not even made him a party here.
My lords, I'll take steps to make him a party, my
You
lords.
file up necessary application, we'll see.
My lords, may I for a moment, my lords, may I for a moment take my lords to page number
In the court, takes notice for response number 1 and 2. Learned counsel for petitioner is directed to serve copies of the petition along with annexures on the learned counsel for the respondent BVM.
annexure P may be taken for a moment, my lords.
No, sir.
Yes.
Yes.
With kind of
Number 6.
previous matter, number 3, Milord. I sought for stay, Milord, that because in the view of the Kata affected in his favor is trying to alienate the properties. Previous matter, serial number 3, Milord. Sorry, I've ended up in a traffic, Milord. In view of the Kata affected in his favor, the Vinay, he's trying to alienate the properties, Milord. That's what I sought for stay, Milord.
Then you will go to civil court. Yes.
Number 6, Chandrakant Tariga ke.
Petitioner. May I please, your lordship. My lord, the petitioner is a trust and running educational institutions on charitable considerations. A demand is raised by the panchayat and to pay the property tax. There is an exemption from payment of tax under Rule 6 of the taxation rules. And similar matters, my lord, this honorable court has dealt with.
That was pertaining to the BBMP.
That is under the Municipalities Act and the
Corporations Act.
Corporations Act. And that is placed before the court, and similar in respect of panchayats also, it is applicable. I don't have.
If there is a decided case, please give it.
No, I don't have that. Now, the case before this honorable court is when a demand was raised and appeal was filed before the appellate authority, the appellate authority insists that the institution should pay 50%, without which appeal cannot be heard. The appellant petitioner tried to convince the appellate authority that there is a similar matters in which the demand was quashed. Even then, it is not heard.
The provision.
Provision is the taxation rules mechanism.
ಇದರಲ್ಲಿ ಇಲ್ಲ ಅಂತ ಕಾಣುತ್ತೆ ಟ್ಯಾಕ್ಸೇಷನ್ ರೂಲ್ಸ್ ಇದೆಯಾ
ಇದೆ.
ಇದರಲ್ಲಿ ಇದೆಯಾ
And it requires the panchayat to pass a resolution. That is also not done. Rule 6. Karnataka Panchayat Raj Gram Panchayat Taxes and Fees Rules. Rule 3 provides first to pass a resolution to levy the tax. That is not there. They have not 3A. And it should be published in the
ಯಾವ್ದು ತರ್ಸಿಟ್ಕೊಳ್ರಿ ಬುಕ್ಕು ಹೋದ್ಸರಿ ನಾವು ಬಂದಿತ್ತು ನೋಟ್ ಮಾಡ್ಕೊಂಡು ತರ್ಸಕ್ಕಾಗ ಬುಕ್ಕು. Yes.
And rule.
I don't have the provision here.
Lord, I shall get the copy. Tomorrow you should
Release this matter tomorrow.
Yes.
For preliminary hearing.
Please.
And if possible, get a copy of that judgment.
Order. Yes. Yes.
Preliminary hearing, serial number 7.
Petitioner in this
Abhijay.
case, my lordship. The petitioner has purchased the property from its previous owner, my lordship, Virulal Sharma. Dated through CH-8 dated 29/9/2022, which is annexure D, page number 49, my lordship.
Only mandamus.
Mandamus, my lordship. My lordship, thereafter, Kata has been
Partial
transferred.
ಕೇಳಿದಾರಲ್ರಿ.
Yes, my lordship, the BBMP has passed an order directing the petitioner to demolish the residential building, my lordship. That all the notice sent to my previous owner, my lordship. Kindly see page number 73. All the notice issued to my previous owner, I am
When did you purchase the property?
2022, my lordship, 29/9/22. The order has been passed in the year 2023. Order passed in the year 2023. All the notice sent to my previous owner, my lordship. I never.
Have you got the Kata transferred in your name?
Yes, my lordship. Annexure, my lordship, may I kindly see annexure E, page number 62. At the time of transferring the Kata, we have produced the sale deed before the BBMP authorities, but no notice issued to the present petitioner.
Kata has been transferred in your favor.
Yes, my lordship. Annexure E, page number 62. Sampath Kumar. But notice issued in favor of my previous owner, my lordship. No notice is served on me. All the notice has been issued to my previous owner. I don't have knowledge about this proceedings, my lordship.
Learned HCGP takes notice for respondent number 1. Learned counsel Sri Pawan Kumar, who is present in the court, takes notice for response number 2 and 3. Learned counsel for petitioner is directed to serve copies of the petition along with annexures on the learned HCGP and learned counsel for the respondent BBM. We'll stop. Next para. Learned counsel for the petitioner submits that after the petitioner purchased the property in question under a registered sale deed
Annexure
dated
D.
29/9/2022 at annexure D, the Khata was transferred in favor of the petitioner in the records of the BBMP. comma, as could be seen from annexure E. Full stop. Nevertheless, it appears that the third respondent has issued notices to the previous owner
Payroll also.
under the provisions of section 248 of the BBMP Act, 2020. Full stop. Learned counsel submits that such action cannot be sustained since the notices were not issued to the petitioner and the petitioner had no opportunity of hearing. Full stop. Next para. Consequently, there shall be an ad interim order of stay of all further proceedings pursuant to the impugned notices issued by the third respondent, Assistant Executive Engineer, comma, till the next date of hearing. Stop. Next para. Learned counsel for the respondent BBMP is directed to secure instructions and make submissions. You'll have to set it aside and permit you to issue a fresh notice. Huh?
Yes, sir. Short date may be given.
Release this matter on 26th of June.
Yes.
Serial number 8, Manjunath BR.
Madam, I represent the petitioner, my lord. The petitioner is the owner of the property, my lord. The respondent BBMP authorities, without giving him opportunity of present at the time of inspection of the property, my lord, they have issued show cause notice, my lord, as per annexure D1 to D7, which are at page number 23, my lord. But I was not present, my lord. They themselves have calculated and they have issued me show cause notice, asking me to pay the tax, my lord. But I have challenged annexure D1 to D7, my lord.
Learned counsel Sri Pawan Kumar present in the court takes notice for both the respondents. Learned counsel for petitioner is directed to serve 2 sets of copies of the writ petition along with annexures on the learned counsel for the respondent BBMP. Full stop. Next para. Learned counsel for the petitioner submits that the notice of reassessment, impugned notice of reassessment have been issued on the basis of an inspection said to have been held by the second respondent, Assistant Revenue Officer of the BBMP, comma, without notice to the petitioner. Full stop. Learned counsel submits that under such circumstances, this court has directed the concerned revenue inspector to hold a spot inspection in the presence of the petitioner and submit a report. Stop. Next para. Consequently, the concerned revenue inspector is directed to conduct a spot inspection in the presence of the petitioner on 24th of June 2024 at 10:30 AM. Full stop. The petitioner shall also be present at the spot on the date and time as directed by this court. Full stop. Next para. Release this matter on 28th of June 2024 to enable the concerned revenue officer to submit the inspection report. Full stop. Next para. Needless to observe that no precipitative action shall be taken till the next date of hearing.
Please, madam.
Serial number 9, Harish HV.
Some for petitioner. Writ of mandamus lordships. Allotment of CH-8 process commenced in 2021. And also there is a press release regarding allotment of site to the petitioner trust. Way back in 2023, March. Not till date, my lord, they are not done.
AGA takes notice for respondent number 1. Learned counsel Sri. Adenta person are RV person. PR person is requested to take notice for response number 2 to 4. Learned counsel for petitioner is directed to serve copies of the petition along with annexures on the learned AGA and learned counsel for the respondent Muda. Next para, release this matter on 26th of June.
Number 10, Mahabaleshwar Rao KN.
ISA for the third respondent, pray for 2 weeks time to file the statement of.
Really, notification, annexure F, page 34, issued declaring a area as a planning area. But they have to prepare a master plan within
On conversion,
Approval.
conversion, they have to put a blanket ban on conversion of the land. In view of the notification issued declaring the planning area under the Town and Country Planning Act. Now this planning area, they have to implement the master plan as well as under that within 2 years from the date of notification. That is on 5/7/22 is the notification, page number 34, Mr. F.
the master plan has been notified or revised master plan has been
No,
notified.
no, the firstly declared as a planning area, subsequently they have to
ಯಾವ್ದು ಶಿವಮೊಗ್ಗನ
Sagar.
ಸಾಗರ
Sir, the provisional notification of the master plan has been, it has been submitted, my lord, to the Director of Town and Country Planning, Shumaga, and it has to be finalized, my lord. Thereafter, my lord, the final master plan will be prepared, and that has to be sent to the government for its approval. But after the approval, my lord, it will be published in the official gazette. There, then only, my lord, the final master plan will come into effect. Till such time, my lord, as per annexure F, the condition number 1.
Now, under this notification,
ವಿಸ್ತರಿಸಲಾದ ಸ್ಥಳೀಯ ಯೋಜನಾ ಪ್ರದೇಶವನ್ನು ವ್ಯವಸಾಯ ವಲಯವೆಂದು ಪರಿಗಣಿಸಿ ಅನುಮೋದಿತ ಮಹಾಯೋಜನೆಯ ವ್ಯವಸಾಯ ವಲಯಕ್ಕೆ ಅನ್ವಯವಾಗುವ ವಲಯ ನಿಯಮಾವಳಿಗಳ ಅವಕಾಶಗಳಂತೆ ಅಭಿವೃದ್ಧಿಗಳನ್ನು ಅನುಮತಿಸುವುದು.
they have shown it as a
As per annexure F, my lord,
green zone.
certain villages have been came within the jurisdiction of the planning authority. As per this notification, my lord, until the final master plan has been approved by the state government, this condition number 1 will apply. Because my lord, these villages, in these villages, my lord, major portion of the property will be in agricultural land.
ವಿಸ್ತರಿಸಲಾದ ಸ್ಥಳೀಯ ಯೋಜನಾ ಪ್ರದೇಶವನ್ನು
ವ್ಯವಸಾಯ ವಲಯವೆಂದು ಪರಿಗಣಿಸಿ ಅನುಮೋದಿತ ಮಹಾಯೋಜನೆಯ ವ್ಯವಸಾಯ ವಲಯಕ್ಕೆ ಅನ್ವಯವಾಗುವ ವಲಯ ನಿಯಮಾವಳಿಗಳ ಅವಕಾಶಗಳಂತೆ ಅಭಿವೃದ್ಧಿಗಳನ್ನು ಅನುಮತಿಸುವುದು. Planning authority will not be knowing as to which of the portion of the master plan will come within the definition of agricultural property or residential property. The petitioners are seeking for the conversion of the land for the purpose of residential layout.
It's going to be 2 years after issuing the
notification, my lord.
If you are going to take so much of time.
The notification, my lord. Notification of the provisional notification of the master, it has been issued, and my lord, it has to be approved by the Director of Town and Country Planning, Shumaga. Then my lord, the government will finalize the master plan. After the finalization of the master plan, and after the approval of the master plan by the government, it will be published in the official gazette. Then, my lord, the master plan will come into effect. This notification is issued in the year 2022. And very recently, my lord, the planning authority very recently, my lord, the planning authority came into existence. My lord, for the purpose of Lok Sabha election, the assistant commissioner, who is the ex officio chairman of the planning authority, but he was busy with the election duty. But now, my lord, the steps will be taken for sending the final master plan to the government.
July 2022 notification was issued. What are you talking of the present election?
My lord, I'll get the instructions, my lord. That's why.
In the section 9,
2 weeks
the
time.
26 Town and Country Planning Act, section 9, clearly bar that shall not later than 2 years from the date of declaration. They don't have any authority to issue any master plan after expiry of 2 years. Therefore, you can see the order dated 19/4 order sheet. The matter was posted before vacation. And the respondent submit that they may take action to issue some preliminary steps to issue planning declaration. Therefore, court has posted after expiry of 2 years. Now the 2 years has expired. Now section 9 is 9(1).
9(2), my lord, 9(2).
Every planning authority shall. You know, the total ban has been imposed for conversion of the land, clause 3, and that has been sought to be declared as invalid.
Sir, which one?
Section 9(1). Every planning authority shall, as soon as may be, carry out a survey of the area within its jurisdiction and shall not later than 2 years from the date of declaration of the local planning area, prepare and publish in the prescribed manner a master plan for such area and submit to the state government through the director for provisional approval. So now the 2 years has already been expired.
Please read further, sir. Please read further.
Now, if the master plan is prepared,
Not prepared.
published
Not
and
prepared.
the state government by planning authority within the period prescribed subsection 1, state government may authorize the director to prepare and publish such plan in the prescribed manner and direct the cost thereof to be recovered from the planning authority out of its fund, notwithstanding anything containing in law relating to the said fund.
So there's still provision.
But the government has to pass now clause B.
Not net for munde odi. Subsection 3.
Notwithstanding anything contained in subsection 2, if any planning authority is converted into or amalgamated with any other planning authority or is subdivided into 2 or more planning authorities, the master plan prepared for the area by the planning authority so converted, amalgamated or subdivided shall. Idu namaga apply agalla. Idralli this is we are aggrieved by the clause 3 of the notification says ವಿಸ್ತರಿತ ಸ್ಥಳೀಯ ಯೋಜನಾ ಪ್ರದೇಶಗಳ ವ್ಯಾಪ್ತಿಯ ಮಹಾಯೋಜನೆಗೆ ಸರ್ಕಾರದಿಂದ ಅಂತಿಮ ಅನುಮೋದನೆ ನೀಡುವವರಿಗೆ ಭೂ ಪರಿವರ್ತನೆ ಅಭಿಪ್ರಾಯ ನೀಡತಕ್ಕದ್ದಲ್ಲ. Now, in relying upon this, planning authority opined that no conversion shall be granted. Accordingly, Deputy Commissioner has rejected the application.
Yes.
My submission to your is now the conversion of the land is governed by under the Land Revenue Act. Use of land is under the Town and Country Planning Act.
Not like that, sir. Once the plan is prepared.
Plan is prepared, certainly. If the
Please
plan is
understand.
prepared, that is there.
See, if there is a plan
Yes.
to develop the lands in a systematic manner, and in between everyone wants to do whatever they want,
So once the planning,
very purpose of planning will go.
the master.
Therefore,
Yes,
certain provisions are made in the act.
that is
They
correct.
know, they visualize that it's going to take some time.
But master plan will override the use of the conversion of the land for the purpose.
Section 95 also very clearly says the conversion, if the land falls within a planning area, will be converted only for the purpose for which it is designated.
That is correct. If as of today, there is no such planning master
Correct.
plan.
So therefore, they are saying this one is a proposal is already forwarded to the government.
Right, the provisional notification of the master plan, that has been, it has been issued, and in consultation of the Director of Town and Country Planning, the government has to finalize.
Yes.
I'll get the instructions.
But if you are going to take so much of time, it's very difficult. People will not be able to wait for you for years together.
Right, but for the condition
You will
number
have to
1,
get all the requisite information.
but for the condition number 1.
When the draft plan was made ready, when it was forwarded to the government, why it has taken so much of time, all these things you'll have to answer. Berkeley. ಆ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿದಾರಾ?
ನೋಟಿಸ್ ಆಗಿದೆ ಅವರು ಆಲ್ರೆಡಿ ಲಕ್ಷ್ಮಿ ಸಿ ದ ಆರ್ಡರ್ ಸೀಟ್ ಡೇಟೆಡ್ 5/4/19
4 is government.
ಓನ್ಲಿ ಗವರ್ಮೆಂಟ್ಗೆ, ಇವ್ರಿಗೆ
ಇವರಿಗೂ ಎಲ್ಲರಿಗೂ ನೋಟಿಸ್ ಅಪಿಯರ್ಡ್ ಆಗಿದೆ.
ಆಗಿದೆಯಾ?
ಹೌದು. ಇಟ್ ವಾಸ್ ಆಲ್ರೆಡಿ ಪೋಸ್ಟೆಡ್ 2 times.
Date notice ಆಗಿದೆ.
ಆಗಿದೆಯಾ?
ಅಪಿಯರ್ ಆಗಿದ್ರಲ್ಲ ವಕಾಲತ್
ಅದೇ
ಹಾಕಿದ್ರೆ.
ಹಾಕಿದೆ.
ಆಲ್ರೆಡಿ
5/4.
ಅಪಿಯರ್ಡ್.
5/4.
5/4 ಗೆ
Wakalat is filed on 15/4 minute before. The earlier
15/4.
dates, Art minute.
File ವಕಾಲತ್ on 15/4.
15/4.
ಹೌದು.
Please.
Within 2 weeks time, if you don't file statement of objections, we'll proceed to consider the matter. Workers. Although notice was directed and the learned AGA took notice for the respondent state on 5/4/2024 and learned counsel Shri A.V. Gangadharappa has filed wakalat on 15/4/2024, statement of objections have not been filed. Full stop. Next para. At the request of the learned AGA and learned counsel Shri A.V. Gangadharappa, finally 2 weeks time is granted to the respondents to file statement of objections, failing which this court will proceed to consider the grievance of the petitioner, taking that there is no objections from the side of the respondents. You can't go on waiting like this, sir. Still number
Date.
Release this matter on 5th of July. 5th of July.
Number 11, Divya A. Jain.
According to the respondent, we filed the inspection reports.
You have filed.
We have filed, my lords.
You served a copy.
I have served a copy. It's in your files, my lord.
Yes.
No objection to the inspection report, your lordship.
Ah,
Revised notice may be issued according to the inspection.
there is some discrepancy.
Yes.
Yes, my lords, if your lordships could have a look at page number 2 of my memo, my lords.
Hmm.
There's a change in the square footage. Memo dated 13th of June, my lord.
Ah,
Page number 2, there is a change in the square footage
hmm.
from 3905 to 3524. That is in view of which we be granted some liberty to issue fresh notification in terms of this.
As per return file measurement 0. As per the report of the revenue inspector,
Please, my lords, and as per the joint
3905.
inspection.
as per the joint inspection, Mazar,
Mazar.
it is little lesser.
Yes, my lords.
Hmm.
So in view of which we seek liberty to issue fresh notice. ma'am.
Percolate. The petitioners are aggrieved of the impugned demand notice for payment of taxes, property tax.
For several assessment years.
Huh?
For different assessment years, starting from 2017 onwards. (2017 to 2023).
Full stop. In fact, show cause notice for revision of demand were issued by the respondent assistant revenue officer from a Mattikere subdivision of the BBMP, seeking to revise the assessment commencing from the year 2017-18 to
22-23, my lord.
2022-23. Full stop. It was contended on behalf of the petitioners that the assessment of the constructed portion made by the respondents were factually incorrect. Full stop. This court therefore directed a joint spot inspection to be held, and accordingly a joint spot inspection was held
10/4/2024.
on 10/4/2024 in the presence of the petitioners, and thereafter
Your Lordship,
the respondents have filed the spot inspection report along with a memo dated 12/6/2024. Yes.
Your Lordship, it may be noted that the liability to the extent of 4,73,000 is extinguished. Because earlier during the interim stage, Your Lordship directed to pay 3,13,000. However, the respondent weren't taking the instrument which was provided by us. So online, we have paid it to the extent of 4,73,000. If there is any adjustment, then
Yes.
it can be.
Next para. Learned counsel for the respondent BBMP fairly submits that even in terms of the joint inspection report dated 17/5/2024, there appears to be a reduction in the area of construction.
Square footage.
Full stop. In terms of the show cause notice, the non-residential building was shown as 3,905 square feet, whereas, after the joint inspection report, as per the joint inspection report, the non-residential area is 3,524 square feet. Full stop. In that view of the matter, learned counsel for the respondent BBMP submits that the impugned show cause notices may be set aside while reserving liberty to the respondent ARO
Please,
to
respondent 2 and 3.
issue
Fresh.
fresh notices
In
to
terms of
the
the
petitioner.
joint
in terms of the
inspection.
joint inspection report.
Please.
Full stop. Next para. On the other hand, learned counsel for the petitioner submits that in terms of the directions issued by this court, the petitioner has deposited a sum of rupees
4,73,571.
570 with the respondent BBMP,
Yes, sir.
and the same has to be taken into consideration by the respondents. Full stop. Next para. Having regard to the facts stated herein above, the writ petition is partly allowed. The impugned show cause notices and demand notice at annexure H dated 11/3/2024 are hereby quashed and set aside. Full stop. Liberty is reserved to the respondent BBMP to issue a fresh show cause notice
For the assessment years from 2017 to 2020.
calling upon the petitioner to pay the arrears of property tax in terms of the fresh assessment made by the respondents. Full stop. Liberty is also reserved to the petitioner to raise any objection that is available to the petitioner in accordance with law, and the respondents shall also adjust the amount already paid by the petitioner in terms of the directions issued by this court. Full stop, ordered accordingly.
Gratefully.
Student 12, Baswaraju.
It's a petition. Writ of mandamus.
Huh?
Issue notice to respond number 2 and 3 and 4.
Angal agadilla. Why should we issue notice?
My lord, the petitioner is seeking livelihood, is holding a small tea shop in as own premises Chamarajanagar town. My lord.
Hmm.
He had obtained a license for running such a tea shop with the respondent. License ಕೊಟ್ಟಿದ್ದೀರಾ my lord. Our parking ಮತ್ತೆ ಒಂದು tea license ಗೆ.
Annexure A.
Annexure A and B, C and 4 D, my lord. Already previous one suit filed by the petitioner, annexure J, my lord.
ಯಾರ ಮೇಲೆ?
Your men, same parties.
ಏನಕ್ಕೆ ಸೂಟು?
ಇವ್ರಿಗೆ ರನ್ನಿಂಗ್ ಕಂಟಿನ್ಯೂ ಆಗ್ಲಿ ಅಂತ ಅಂದ್ಬಿಟ್ಟು ರಿಲೀಫ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಮಾಡಿ. Where the petition is a liberty to make a fresh representation.
Petition re suit alla. Earlier you had filed a writ petition.
My lord.
Huh?
Writ petition, my lord.
For what?
For what, my lord, ಇವರು ಸ್ವಂತ ಸೈಟ್ ಅಲ್ಲಿ ಒಂದು ಲೈಸೆನ್ಸ್ ಮತ್ತೆ ಟೀ ಶಾಪ್ ಇಟ್ಕೊಂಡಿದ್ದಾರೆ. ಲೈಸೆನ್ಸ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 2 ಅವ್ರಿಗೆ ಲೈಸೆನ್ಸ್ ಕೊಟ್ಟು ಅದು ಪಾರ್ಕಿಂಗ್ ಮಾಡ್ಕೊಂಡು ಜೀವನ ಮಾಡ್ಕೊಳ್ತಾ ಇದ್ದಾರೆ. ಪ್ರೀವಿಯಸ್ 2019 ಅಲ್ಲಿ ಒಂದು ಸೂಟ್ ಫೈಲ್ ಮಾಡಿದ್ರು. ಇವ್ರು ಇಂಟರ್ಫಿಯರ್ ಆಗಿ ತೊಂದರೆ ಕೊಟ್ಟು ಅವ್ರನ್ನ ಖಾಲಿ ಮಾಡಿ ಅಂತ. ಅದಕ್ಕೆ ಒಂದು ರಿಟ್ ಪಿಟಿಷನ್ ಫೈಲ್ ಮಾಡಿ.
2-wheeler ಪಾರ್ಕಿಂಗ್ ಲೈಸೆನ್ಸ್ ಅಂತ ಇದೆಯಲ್ರಿ ಲಾಸ್ಟ್.
ಹೌದು.
ಇವಾಗೇನೋ ಟೀ ಸ್ಟಾಲ್ ಅಂತ ಹೇಳ್ತಾ ಇದೀರಾ?
ಟೀ ಸ್ಟಾಲ್ ಜೊತೆಗೆ ಇಟ್ಕೊಂಡಿದ್ದಾರೆ. ಅದು ಲೈಸೆನ್ಸ್ ತಗೊಂಡಿರೋ ಪಾರ್ಕಿಂಗ್ಗೋಸ್ಕರ ಲೈಸೆನ್ಸ್. ಅನ್ನೆಕ್ಚರ್ ಇವ್ರು ಆನ್ಲೈನ್
ಆಗಿದೆ. ಎಕ್ಸ್ಪೈರಿ ಆಗಿದೆ ಸರ್ 31/3/2024. Page 12 euros.
2024-25 ಗೆ ಒಂದು ಲೈಸೆನ್ಸ್
expired. Now you have given one representation.
ಅನ್ನೆಕ್ಚರ್ F ಅಲ್ಲಿ ಆನ್ಲೈನ್ ಅಲ್ಲಿ ಲೈಸೆನ್ಸ್ ಟ್ರೇಡ್ ತಗೊಂಡಿದ್ದಾರೆ, ಅಪ್ಲೈ ಮಾಡಿದ್ದಾರೆ. ಬಟ್ ಅವರು ಅನ್ನೆಕ್ಚರ್ ಎಸ್ ಅಲ್ಲಿ ಚೆಕ್ ಸ್ಟೇಟಸ್ ಅಲ್ಲಿ my lord, your application is in cancelled ಅಂತ ಬಂತು. Annexure S, my lord, page number 23. ಹಿಂದೆ ಒಂದು ರಿಟ್ ಪಿಟಿಷನ್ ಫೈಲ್ ಮಾಡಿದ್ರು. ಅದ್ರ ಲಿಬರ್ಟಿ ಇವ್ರಿಗೆ press liberty to make a press representation seeking license, and if he found eligible, respond number 2 may be consider issuing license in accordance with law. Our license ಕೊಟ್ಟು 2023 and 24 ಲೈಸೆನ್ಸ್ ಕೊಟ್ಟಿದ್ರು. ಈಗ ಅದನ್ನ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿದ್ದಾರೆ. ಮತ್ತೆ ಇವರ ಜೀವನೋಪಾಯಕ್ಕೆ ಇದೇ ಆಧಾರ ಆಗಿರೋದ್ರಿಂದ ಲೈಸೆನ್ಸ್ ಕಂಟಿನ್ಯೂ ಮಾಡೋಕ್ಕೋಸ್ಕರ ಇವರು ಇದು ರಿಟ್ ಪಿಟಿಷನ್ ಫೈಲ್ ಮಾಡಿ. 2014 ಅಲ್ಲಿಂದನೂ ಇವರು ಲೈಸೆನ್ಸ್ ರೆಸ್ಪಾಂಡ್ 2 ಲೈಸೆನ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದಕ್ಕೆ
petitioner is at liberty to make a fresh representation seeking license, and if he is found eligible, respondent number 2 may consider issuing license. ಏನಾಯ್ತು ಅದಾದ್ಮೇಲೆ?
ಅದು ಕೊಟ್ಟಿದ್ದಾರೆ ಲೈಸೆನ್ಸ್ 2020. ಅದೇ 2000 annexure B, my lord. 2023 and 24 ಲೈಸೆನ್ಸ್ ಕೊಟ್ಟಿದ್ರು. ಈಗ ಮತ್ತೆ ಅದು ಕ್ಯಾನ್ಸಲ್ ಸ್ಟೇಟಸ್ ಅಲ್ಲಿ ಕ್ಯಾನ್ಸಲ್ ಅಂತ ಆನ್ಲೈನ್ ಅಲ್ಲಿ ಬಿಟ್ಟಿದ್ರು. ಅದನ್ನ ಮತ್ತೆ ಸೂಟ್ ಫೈಲ್ ಮಾಡಿ ರಿಟ್ ಪಿಟಿಷನ್.
From 1/4/2022 to 31/3/2023.
Yes.
ಮುಗ್ದೋಗಿದ್ಯಲ್ರಿ?
ಮುಗ್ದೋಗಿದೆ my lord. ಈಗಲೇ ರಿಟ್ ಪಿಟಿಷನ್ ಫೈಲ್ ಮಾಡ್ಕೊಂಡ್ಬಂದು ಅದಕ್ಕೋಸ್ಕರ ಅವ್ರ ಆನ್ಲೈನ್ ಅಪ್ಲಿಕೇಶನ್ ಕನ್ಸಿಡರ್ ಮಾಡಿಲ್ಲ ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಇದು ರಿಟ್ ಪಿಟಿಷನ್ ಕೊಡು. ಅನ್ನೆಕ್ಚರ್ F, my lord. ಅವ್ರ ಆನ್ಲೈನ್ ಮತ್ತೆ ಅಪ್ಲೈ ಮಾಡಿ
ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಏನಂತಾರ? ನಿಮ್ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಅಲ್ಲಿ ಏನ್ ಕೇಳ್ತಾ ಇದೀರ ಈಗ?
ನಾವು ಮತ್ತೆ ಲೈಸೆನ್ಸ್ ಕೊಡಿ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀವಿ. ಓವರಾಲ್ ಆಗಿ ಅದು ರೈಟಿಂಗ್ ಅಲ್ಲಿ ಒಂದು ಕೊಟ್ಟಿದಾಗ ಆನ್ಲೈನ್ ಬಿಟ್ಟು ಅನ್ನೆಕ್ಚರ್ G ಮಾಡಿ.
ದ್ವಿಚಕ್ರ ವಾಹನ ಲೀಡಿಗಳಿಗೆ ರಹದಾರಿಯನ್ನು ಇರುವುದಕ್ಕೆ ಬರಾನೆ.
Mr. A. Nagarajappa appeared for the municipality, is it?
There was a violation earlier, lordship, the license was cancelled.
ಅದಾಯ್ತ್ರಿ, ಇಶ್ಯೂ ಮಾಡಿದಾರಲ್ಲ.
ಪುನಃ ಈಗ ಅದು ಎಕ್ಸ್ಪೈರ್ ಆಗ್ಬಿಟ್ಟಿದೆ ಸ್ವಾಮಿ, ಕ್ಯಾನ್ಸಲ್ ಆಗಿದೆ. ಆ ಕ್ಯಾನ್ಸಲ್ ಆರ್ಡರ್ ನ ಚಾಲೆಂಜ್ ಮಾಡಬೇಕು.
ನಾವು ಅದಕ್ಕಿಂತ ಮೊದಲೇ ನಾವು ಅಪ್ಲೈ ಮಾಡ್ತೀವಿ.
ಅವರೇ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಕ್ಯಾನ್ಸಲ್ ಆಗಿದೆ ಆನ್ಲೈನ್ ನಲ್ಲಿ.
He is requesting for further renewal.
ರಿಕ್ವೆಸ್ಟಿಂಗ್
Annexure G ಪ್ರಕಾರ he is asking for further renewal. Learned AGA takes notice for response number 1 and 3. Learned Counsel Sri A. Nagarajappa is requested to take notice for respond number 2. Iವರು respond number 4.
ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 4 ಅವರು ರೈಲ್ವೆ ಸ್ಟೇಷನ್ ನಿಯರ್ ಇದೆ ಮೇಡಮ್. ಅವ್ರು ಅಲ್ಲಿ ಲೈಸೆನ್ಸ್ ತಗೊಂಡು ಅವರು ಇಂಟರ್ಫಿಯರ್ ಆಗಿ ಇವ್ರಿಗೆಲ್ಲ ತೊಂದರೆ ಕೊಡ್ತಾ ಇದೆ. ಇವ್ರು ತೆಗೆದಾಕಲ್ಲ ನಾನು
ಸ್ವಾಮಿ, one of the ground is respondent number has not afforded any
ರೈಲ್ವೆ ಸ್ಟೇಷನ್
valid and cogent reason for cancelling the license issued to the petitioner ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
No question of cancelling.
Cancellation.
ಈಗ ಅಲ್ಲ, ಅವ್ರು ಏನೇ ಹೇಳಿರ್ಬೋದು, ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಅಲ್ಲಿ ದೇ ಆರ್ ಆಸ್ಕಿಂಗ್ ಫಾರ್ ರಿನ್ಯೂವಲ್. Annexure G ಅಲ್ಲಿ
ಹೌದು ಮೇಡಮ್.
ಯು ಆರ್ ಆಸ್ಕಿಂಗ್ ಫಾರ್ ರಿನ್ಯೂವಲ್ ತಾನೆ?
ರಿನ್ಯೂವಲ್ ಅದು
ಅಲ್ಲ, ಕ್ಯಾನ್ಸಲ್ ಆದ್ಮೇಲೆ ರಿನ್ಯೂವಲ್ ಕೇಳ್ತಾ ಇದ್ದಾರೆ.
ಹೌದು,
ಕ್ಯಾನ್ಸಲ್ ಆಗ್ಬಿಟ್ಟಿದೆ.
ಕ್ಯಾನ್ಸಲ್ ಅದಕ್ಕಿಂತ ಮೊದಲೇ ನಾವು ಆನ್ಲೈನ್ ಅಲ್ಲಿ ಅಪ್ಲೈ ಅವ್ರು ಏನು ರಿಪ್ಲೈ ಕೊಡ್ತಾ ಇದ್ದಕ್ಕೆ ನಾವು ಮತ್ತೆ ಅದನ್ನು ಅನೆಕ್ಸ್ಚರ್ ಜಿ ಕೊಟ್ಟು
2019 ಅಲ್ಲೇ it had expired. Order has been passed on 29th of October 2022, directing them to consider whether he can be given the license once again. Issue notice to respond number 4. Issue emergent notice to respond number 4. Learned Counsel for petitioner is directed to serve 2 sets of copies of the writ petition along with annexures on Learned Counsel for the respondent CMC and a copy on the Learned AGA.
ಈ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 2 and 3 ತೊಂದರೆ ಕೊಡ್ತಾ ಇದೆ. ಮೈಟ್ ಕೈಂಡ್ಲಿ ರಿಲೀಫ್
ರೀ, ನಿಮ್ಗೆ ಲೈಸೆನ್ಸ್ ಇಲ್ಲ ಕಣ್ರಿ, ನಡ್ಸಕ್ ಬರೋದಿಲ್ಲ ನೀವು ಇವಾಗ. Release this matter on 26th of June.
Number 13, Mr. Prakash.
Petitioner, that is the owner of a Karnataka property in Karnataka number 62 and 64. My lord, it was a property purchased by his father, my lord, in the year 1942-43. My lord, upon his death, the father's death, his brother, my lord, petitioner brother, sold this Karnataka number to second respondent Gram Panchayat under a sale deed of the year 1994. Then, my lord, he filed a suit for partition and also sought for a prayer that the sale deed executed by his brother, who was second defendant in the suit, in favor of the Gram Panchayat is not binding. State is also made a party to the suit. My lord, that ended, my lord, in a decree, my lord, page, annexure A, page, my lord, 21, my lord, 21, page 21. My lord, second respondent is the brother of the petitioner, page 21. Chief Secretary and my lord Tahsildar and they have made party. Then, my lord, this page, my lord, internal page 5, running page.
Sale deed was executed?
My lord, executed, my lord, in the year 94.
Conveying the property to?
To the, my lord, the second respondent. Second.
Gram Panchayat.
Gram Panchayat.
Then Gram Panchayat is not a party to the suit.
My lord, that is, my lord, Tahsildar. Sorry.
Tahsildar is not the.
My lord, page 4, page 2.
Sir, Gram Panchayat cannot be represented by Tahsildar.
Sorry, I made a mistake. To the Tahsildar, he paid.
Copy the sale deed though.
Yeah, sale deed illi.
Athwa if there is any discussion.
Yes, page,
please show
internal
from
page
the-
5, internal page 5.
Of the
Judgment.
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 Yes.
Issue number 2. whether plaintiff further proves that the sale deed dated 24/8/94.
In favor of respondent number 4,
Four, that is Tahsil.
Tahsildar.
Yes,
Ah.
is not binding upon the
Ah.
defendant number one. The answer, your lordship, get it, my lord. Next page. Issue number 2 in the affirmative. Issue number 2. This is.
ಏನ್ ಅವ್ರೇನ್ ಬಂದು ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡಿದ್ರ ತಹಸೀಲ್ದಾರ್?
ಮಾಡಿದ್ದಾರೆ. APP, my lord. Defend number 2, 3 and 4 by Sri AGP. Then there no appeal is filed against this, my lord, judgment. It is of the year, my lord, it is dated 19 April 2022. It attained finality. Then FDP was filed. My lord, it was ended in compromise among the plaintiff, the petitioner, his sister also a defendant, my lord, in the suit, and the brother. That is, my lord, FDP, your lordship would get annexure B, page 39.
Learned AGA
Pata is not, my lord.
takes notice for response number 1 and 3. Issue notice to respond number 2. Learned counsel for petitioner is directed to serve copies of the writ petition along with annexures on the learned AGA. Stop. Release this matter on 3rd of July.
Number 14, Sudhakar GB. Ground rent.
Ground rent.
It's not pertaining ground rent, my lordship.
Huh?
This demand is notice issued by the Gram Panchayat for
Gram Panchayat.
demanding the similar demands made by the BBMP, labor cess and license fee. That only we are challenging. Page number 38, my lordship, demand notice. In the column ಅಲ್ಲಿ ಶೇಕಡ 1% ಕಾರ್ಮಿಕರ ಸೆಸ್ಸು ಕಟ್ಟರು. Similar demands some for stayed subject 50 deposit 50% of
Gram Panchayat.
Gram Panchayat BBMP ಗೆ ಮಾಡಿ. ಇದು Gram Panchayat ಗೆ ಆಗಿದೆ. Is the first matter. But similar demands they made.
So you are directed to pay 50%.
50% of license fee and labor cess is as and when met with in terms of this interim one, say subject to. Table ಅಲ್ಲಿ column number 16 ಇದೆ sir, labor cess. Last page. Seal number 16, labor cess. Says subject to a condition that the said demand would be met as and when the obligation to make payment arise in terms of the.
No, you are concerned only with column number 2 and 3. 1% labor cess.
Labor cess and kattara parwanigi shulka.
Kattara parwanigi shulka you have to pay.
It's idರಲ್ಲಿ 50% at mal BBMP demands subject to payment of 50% license fee.
Why?
So they're linking to the guidelines value for the demanding the license fee. That's why.
And how are you saying that this is also done in the same way?
We did not get the details.
What is the total extent of land?
So 4 acres.
Huh?
4 acres.
Construction entry ಮಾಡ್ತಾ ಇದೀರಾ?
Rows construction.
ಅದಕ್ಕೆ 9 ಲಕ್ಷ ಕೊಡೋದು ಕಷ್ಟನಾ ನಿಮ್ಗೆ?
ಅಲ್ಲ ನಾವು ಆಲ್ರೆಡಿ ಟೌನ್ ಪ್ಲಾನಿಂಗ್ ಅಥಾರಿಟಿ ಕಟ್ಟಿದ್ವಿ annexure C ಮಾಡಿಸುತ್ತೆ.
Annexure
C ಇದ್ರ ಪ್ಲಾನ್ ಡೆವಲಪ್ಮೆಂಟ್ ಪ್ಲಾನ್ ತಗೊಂಡು annexure C ಪೇಜ್ ನಂಬರ್ 34. ಅದು ಆಲ್ರೆಡಿ ಪೇ ಮಾಡಿದ್ವಿ, ಸ್ಕ್ರೂಟ್ನಿ ಫೀ ಪೇ ಮಾಡಿದ್ವಿ, ಬೆಟರ್ಮೆಂಟ್ ಚಾರ್ಜ್ ಕಟ್ಟಿದ್ವಿ. Now when you applied for building license, they have issued a demand again. The Panchayat has issued a demand. ಈ ಚಾರ್ಜಸ್ ಎಲ್ಲ ಕಟ್ಟಿದ್ದೀವಿ.
ಬಿಲ್ಡಿಂಗ್ ಲೈಸೆನ್ಸ್ ಚಾರ್ಜ್ ಅವ್ರು ತಗೊಳ್ಳೋರಿ, ಪ್ಲಾನಿಂಗ್ ಅಥಾರಿಟಿ ಅವ್ರು ತಗೊಳ್ಳೋದಿಲ್ಲ. ಪ್ಲಾನಿಂಗ್ ಅಥಾರಿಟಿ ಅವರು ಬಿಲ್ಡಿಂಗ್ ಲೈಸೆನ್ಸ್ ತಗೊಳ್ಳೋದಿಲ್ಲ.
They have collected scrutiny fee, security deposit, betterment charges they have collected. Planning authority.
ಅದೆಲ್ಲ ಇರ್ಬೋದು.
ಉಸ್ತುವಾರಿ ಶುಲ್ಕ ಅಂತ ಕಲೆಕ್ಟ್ ಮಾಡಿದ್ರು.
ಅದೆಲ್ಲ ಫಾರ್ ದಿ ಎಂಟೈರ್ ಲೇಔಟ್ 4 acres.
Please.
Purple. Learned AGA takes notice for response number 1 and 2. Learned Counsel Sri MS Devraju is requested to take notice for response number 3. Learned Counsel for petitioner is directed to serve copies of the writ petition along with annexures on the learned AGA and learned counsel for response number 3. Full stop. Next para. Learned counsel for the petitioner submits that the petitioner is aggrieved of the impugned demand at annexure D raised by the third respondent Gram Panchayat, calling upon the petitioner to pay 1% of labor cess amounting to rupees 22 lakhs and building license fee of rupees 9,94,057.58. Full stop. Learned counsel submits that under similar circumstances, in respect of such demands raised by the BBMP, this court has issued interim directions permitting the petitioners to pay only 50% of the demanded amount and has issued directions to the competent authority to issue the building license subject to the final outcome of the writ petition. Full stop. Learned counsel prays for similar orders. ಮಾಡ್ಕೊಂಡು ಬರೀ 2 ಮಾತ್ರ 50% 2 1% ಸೆಸ್ ಲೇಬರ್ ಸೆಸ್ ಇನ್ನೊಂದು ಬಿಲ್ಡಿಂಗ್ ಲೈಸೆನ್ಸ್ ಫೀ
ಲೇಬರ್ ಸೆಸ್ 50% ತರಲ್ಲ ಆಸ್ ಇನ್ ಸ್ಟ್ರೇಟ್ ನಾವು ಯಾವಾಗ ಅದು ಬರ್ತದೆ
ನೋಡ್ಕೊಂಡು ಅದನ್ನ ಮಾಡಮ್ಮ ಲೇಬರ್ ಸೆಸ್ ನಾವು ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದೀವಿ ಅರ್ಧ ನೋ ಸ್ಟೇ ಅಂತ ಮಾಡಿದ್ದಾರೆ 1% ಸರ್ವಿಸ್ ಚಾರ್ಜಸ್ ಆನ್ ಲೇಬರ್ ಸೆಸ್ ನೋ ಸ್ಟೇ ಅಂತಿದೆ.
ಇಲ್ಲ ಅದು ಸರ್ವಿಸ್ ಚಾರ್ಜಸ್ ಇದೆ. ಲೇಬರ್ ಸೆಸ್ ಸೀರಿಯಲ್ ನಂಬರ್ 16 ಇದೆ ಲೇಬರ್ ಸೆಸ್
16 ಸೀರಿಯಲ್ ನಂಬರ್ 16 ಅಲ್ಲಿ ಇದೆ ನೋಡಿ. Yes.
Serial number 15. Rajesh Chandra Guru.
I appeal for the petitioners, my lord. My lord's petition is filed against the impugned order at annexure R and R1, which is before your lordships at page 100 to 103 minutes. Annexure R and R1 minutes are possession notices issued by the respondent number 1, 2, 3 in favor of respondent number 4 in pursuance of the auction sale of the petitioner's property minutes. The petitioner was a borrower of the first respondent Cooperative Bank, my lords. This action of the respondents 1, 2, 3 is assailed on mainly 3 grounds, my lords. 1, my lords, the petitioners were not heard by the respondents. Number 2, my lords, this auction sale and all proceedings has taken place during the absence of the petitioner from India, my lords. In fact, at annexure N, page...
What can they do, sir, if you go away from India? You know you have borrowed.
Yes.
You know you have defaulted.
Yes, my lords.
Then,
my lords, this I had made a representation during July, and there was also...
Tell us how much you're going to pay.
My lords, if some reasonable time is given, I am ready to pay the full amount.
What is the demanded amount?
My lords, the outstanding is around 17 lakhs, my lords. With the full amount, the petitioner is willing to repay, provided some time is given, my lords. My lords, and third important point, my lords, is...
Where is the award?
My lords, the property is grossly undervalued. I'll come to your lordship's point in. Please.
Where is the award, sir?
Please.
What is the award passed against you?
Annexure N, my lords, please. That's the official memorandum at page 96. I'm sorry, my lords. Amount is 19 lakhs 58,625. In the last para, third line, my lords.
Annexure N.
Annexure N, my lords. Page 96. Last para, my lords, third line.
ಬರಬೇಕಾಗಿತ್ತು ಮೌಲ್ಯಮಾಪನ ಮಾಡಿಸಿದ್ದು 20 ಲಕ್ಷಕ್ಕೆ ಏಲಾಂ ಪ್ರಾರಂಭಿಸಲು ಕೋರಿರುತ್ತಾರೆ 19,58,000.
Yes, 625. The petitioners are ready to pay the full amount bills. All I'm seeking is a reasonable time.
How much are you going to deposit now, sir?
My lords, 50% in 2 weeks, my lords,
Perfect.
please.
Learned HCGP takes notice for response number 2 and 3. Issue notice to respond number 1. This respond number 4 is a guarantor.
No, my lords, she is the auction sale purchaser.
Oh, auction has already taken place.
Auction has taken place. They have issued the possession notice at R and R1, but they have not issued the sale certificate to us. Regarding the details of the auction, they are dodging all the queries of the petitioners, my lords. But I have learned it has been a success. She is the successful bidder.
Confirmation also is done.
No, my lords, no, auction sale certificate is not issued, my lords. I have obtained the EC, which is at annexure Q, my lords, page 98 to 99. It does not reflect any sale deed. Annexure Q, your lordship, page 98, please. My lords, one important point which I would like to place before your lordship is the mortgage property has been grossly undervalued, my lords. They got the valuation done for rupees 20 lakhs. Whereas, my lords, the borrower purchases the property during 2017 for 25 lakhs. And the guidance value for the same is 22 lakhs. I'm told the market value for the same is around 50 lakhs today, my lords. 6 years back, it was 25 lakhs, your lordship, as per the sale deed. What is noted in the sale deed is 25 lakhs. The sale deed is also before your lordships at annexure A, my lords.
Response number 1 and 4. Learned counsel for the petitioners is directed to serve copies of the petition along with annexures of the learned HCGP. Full stop. Next para. Learned counsel for the petitioners submits that the petitioners are not disputing the fact that they had borrowed money from the first respondent, Cooperative Society. Full stop. However, it is submitted that the petitioners were not in India when the recovery proceedings were initiated, and such fact is in fact found in the impugned award. Where is that page number?
96, your lordship. Annexure N, please. Second para, my lords.
At annexure N. Full stop. Further, comma, it is submitted that the property is grossly undervalued, comma, since the petitioners have themselves paid a sum of rupees
25 lakhs.
25 lakhs.
Yes.
When they purchased the property under registered sale deed dated
27/09/2017, my lords.
2017.
Yes.
And the property is now valued at rupees 20 lakhs.
Yes, as per the valuation report.
Full stop. The learned counsel would further submit if reasonable time is given to the petitioners will repay the entire outstanding loan amount along with the accrued interest.
Yes.
Full stop. To show the bona fides of the petitioners, comma, it is submitted that the petitioners will deposit rupees 10 lakhs.
Yes.
Within a period of 2 weeks.
2 weeks.
From today.
Yes.
Full stop. Next para. Consequently, the third respondent, Assistant Commissioner, not Commissioner, Assistant Registrar of Cooperative Societies and Recovery Officer, Mangalore Subdivision, is directed not to proceed to execute the sale certificate in favor of the fourth respondent.
Yes.
Till the next date of hearing, comma, subject to the petitioners depositing rupees 10 lakhs with the first respondent society within a period of 2 weeks from today. Full stop. Next para, relief this matter. On 8th of July. Yes.
Admission. Serial number 16. Venkatesh Prahlad Kulkarni.
Lord, I appear for the petition. Lord, the contract entered with the railways for the supply of washing and ironing of linens. My lord, the period was 1 year and it was completed. However, wrongly they have deducted huge amount.
They have not shown the name of the central government council.
Shivakumar, it seems. Shivakumar.
Shivakumar. And in terms of the contract, their own officer is to be appointed.
Yes, my lord, sole arbitrator was supposed to be appointed.
From their side.
From there, only one.
Allala. Where is the arbitration clause?
Kindly page number 58, my lord. Clause number 17.1.
58.
Yes. Fourth line, my lord. The same shall be referred to sole arbitration of a gazetted railway officer appointed.
That is what I am saying.
Yes, my lord. From their side, only one. From our side, there is no.
It also cannot be done.
That's.
You are not aware of the latest.
Yes, my lord. That is the reason, my lord. And we start for appointment.
7th schedule.
Yes, my lord.
No such officer can be appointed.
Kindly pass over, my lord. May kindly pass over this.
Pass over. Please get him.
Obliged.
ಅದು ತೆಗೆದಿಟ್ಕೊಳ್ರಿ ಅದು ಜಡ್ಜ್ಮೆಂಟ್ ನಾನು ಮಾಡ್ತೀನಿ ರೀಸೆಂಟ್ ಆಗಿ.
Serial number 881. Serial number 17.
7th schedule ಪ್ರಕಾರ any employee of the respondent cannot be appointed ಅಂತ ಮಾಡಿದಂತೆ. Yes.
Your lordship, I appear for the petitioner in the matter. Your lordship, there was a lease agreement that was entered into between the petitioner and the respondent for leasing his land.
Yes, Mr. Sridhar.
I appear for respondent.
Yes. Any objection?
Main objection is it's unregistered, my lords. Unregistered, 6-year lease deed unregistered.
Where it has to be considered? Well, it has to be considered before this court or before the arbitrator?
Registration may have to be considered here, my lord. Stamping Supreme Court decision is there that it can be considered before arbitrator. Registration affects the validity.
Where is the judgment?
This is the Stamp Duty Act.
There is the judgment, sir.
Insofar as registration is concerned, there is no specific this thing.
Why don't you come with the judgment? If you are raising this objection, should you not come with the relevant judgment?
My lords, I am only stating that as per Transfer of Property Act 107, lease of more than 1 year should be only by a registered instrument.
Did not an issue considered by the Supreme Court?
No, my lords. That was on stamping, my lords. The NM Global judgment, my lords, is referring to was on the issue of stamp duty payable.
You are raising an objection regarding registration.
Yes, ma'am.
Is it not a decided case or not?
Not registration, my lords. That's all. I will produce a citation, my lords, that NM Global deals with stamp duty, my lords.
Have any judgment with you?
Your lordships, it is,
You should come with preparation, madam.
yes,
Only a short question to be answered.
yes, your
Perfectly.
lordships.
Learned counsels are requested to come along with decided cases regarding the issue sought to be raised by the respondent. Namely, that if the contract is not registered in accordance with law, this case, this court has to consider even at the time of consideration of a petition under section 11, the said question, and the same cannot be left to the consideration of the arbitrator. So, release this matter on 26th of June.
Apart from that, my lords, R2 and R3 are not party to the agreement. That is also another objection raised.
Yes.
Serial number 18. Manisha.
We have filed the memo of retirement for respondent, my lord. HP Praveen.
This case,
Huh?
For
Lords.
respondent, we have filed a memo of retirement.
in this case,
Yes,
I undertake to file the wakalat for the respondent.
you are filing.
I'll file it in the office. She has collected the no objection wakalat. It is yet to be handed over. A week's time may be granted. We'll file the wakalat under
Learned counsel Shri
R. Shashidhar,
R. Shashidhar
please,
undertakes to file NOC wakalat on behalf of the respondent.
please.
Full stop. A week's time is granted to do the needful.
Please.
The date may be fixed. Release this matter on 26th of June.
Much people.
Yes.
Serial number 19. Kumara Naganath.
Appear for the petitioner, my lord.
Yes,
This is a petition seeking appointment of an arbitrator.
yes. Municipal Corp Commissioner,
Yes.
CMC. Yes, Mr.
My lord, that-
Kiralgi.
yes, my lord, there is a award, my lord, made, work order was issued to the contractor. This,
Any objection?
my lord, the contract contains, my lord, clause with regard to that.
We are only considering appointment for the arbitrators. Everything will be left to all other contentions will be kept.
Your lordship kept.
Huh?
Any
What is the
arbit-
what is the demand amount?
More than 100 crores.
Then
May I suggest Justice A.V. Chandrasekhar?
don't take any name.
Yes, my lord.
Should we appoint a retired Supreme Court judge
High
or a
Court
High
judge.
Court judge is the question. That's all.
Lordship may appoint a retired judge of this honorable court.
This-
Yes. Any,
My request, my lord, is can it be ad hoc arbitration?
Huh?
Ad hoc arbitration instead of center.
Why?
Centrally, they're overburdened at the date sigot kashta
Eh.
agತ್ತೆ.
And you are taking a name of a retired judge who has got so many cases where you'll have to stand in the queue. You leave it to us.
Yes, ma'am.
Yes.
The clause is at page 52, my lords, of the petition.
We will appoint Justice P. Krishna Bhatt,
Yes, ma'am.
former judge of this court. Second paragraph. After issuance of notice, the respondent has appeared and is represented by a learned counsel. So, learned counsel for the respondent fairly submits that this court may proceed to appoint an arbitrator to resolve the dispute between the parties. Stop. Third paragraph regarding compliance. Amele Justice P. Krishna Bhatt, former judge of this court. Yes.
Number 20, B.S. Mahendra.
Therefore, the petition in this case, my lord, it is for seeking appointment of arbitrator.
Make one submission, ma'am. My lord, my statement of objections are ready, my lord. I will file the statement of objection. Kindly have it next week, my lord.
Learned counsel for the respondent submits that the statement of objections are ready. And the same will be filed by tomorrow.
Tomorrow.
Huh? Full stop. Please have a copy.
I have received the, please issue the copy.
Learned counsel for the petitioner submits that he has received a copy of the statement of objections. Full stop. Release this matter on 26th of June. Yes.
27th, ma'am.
All right.
27th. Please, ma'am.
Orders. Serial number 21. Anupam Agarwal.
Taken up in the next week, please, my lords.
Huh?
The matter be taken up in the next week, please, my lords. It is section 29A though. On the last occasion, my lordship suggested me about the Supreme Court.
Suggested Allah. There is a
Please,
judgment
my
of
lords, I have-
Supreme Court. Please go before the
My lords, one kind
court
submission.
of original jurisdiction.
Please, my lords, I've gone through the same. My senior wants to make few submissions,
No,
my
no
lords, for
submission.
this court.
No submission. Perkle ಅದ್ಯಾವ್ದು 29A ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿದೇನಲ್ಲ ಸೇಮ್ ಆರ್ಡರ್ you go before the court of original jurisdiction. 29A. Yes. Yes.
Serial number 22. Aki Manjunath Godake, FEF.
Finally, a week's time is granted to the petitioner for taking steps for service of notice on the respondents.
Serial number 23.
Appearing for the
KP
respondent.
Jayasimha.
Appear for the respondent. This matter, my lords, RT wants to engage services
Huh?
of the senior advocate. In fact, what has happened is, if my lords could kindly recollect, in respect of 4 sites, my lord asked me to consult the clients, my lord, whether
Matter, my lords, wherein the name of the petitioner to be entered
not
in
to
the
restore the
RTC.
RTCs,
For
name of
being-
the RTC. Now that, my lord, it has come in the municipality area and the suit being pending. For that reason, my lord, it may be taken up on 25th or 26th, my lord, because party wants to engage the services of the senior advocate in this matter, because
No. If that is the case, I will you'll have to go before the regular court.
please,
matter.
I can understand. Yes,
I don't want to keep parted matters like this.
please, because larger interest is involved. That- for
Yes.
that.
Release from parted.
Please.
Great for me.
24. Yes, Ramamurthy. Non-reporting
Petition.
and director.
Yes.
For the respondents, 1 to 3, wakalat has to be filed, fresh wakalat, because for the
Report by
BBM.
assistant director of town planning.
Which the earlier report was filed by ADTP.
What?
But as per the report, there was no sanction plan for the building. Then AWE was directed to take action. Now provisional order has been issued. As per my instruction to this provisional order, respondent number 4 has given a reply. That is to be considered now.
Petitioner is a complainant.
Petitioner is a complaint.
Let's, I'll file the statement of objections. We have,
ಏನು objection?
ಮುಂಚೆನೆ ಅವರು plan for getting the plan sanctioned, my lords, they have submitted a representation on all. I'll file the objections, my lord, in detail, I'll file the objections.
What objection, sir? You will have to produce the document if you have got a sanction plan. What objections are you going to file?
For sanctioning the plan, we had submitted a representation.
So
prior.
what?
And also under Akrama Sakrama also, we have submitted a representation after the construction, my lords, and I'll
What
file the
you do, file an appeal before the chief commissioner, you do it. That is the only option that is left to you.
So I request only 1 day time, my
For
lords.
what? ಇದು ಕನ್ಫರ್ಮೇಶನ್ ಆರ್ಡರ್ ಇಶ್ಯೂ ಆಗಿದೆಯಾ?
That they have
Only
filed a reply,
provisional
my
order.
lord.
Huh?
They have filed a reply to provisional order that is
Ah.
under consideration.
You consider that one and take action in accordance with law.
Yes,
Huh?
yes,
We'll have it
One-
next week.
yes,
1+4.
By next week it is possible?
yes, sir.
All you need 2 weeks.
27th or
My
28th.
lords, I request only 2 days time, my lords, on submission.
Namgallappa, you will have to give reply to the notice. They will proceed in accordance with law. If you are aggrieved, then you will have to go, there is an appeal provision before the chief commissioner. Go there. Nothing can be done here. Whatever documents you have to show, you place it before the authority. Let them consider and pass orders. Berkeley.
Without, there is it is an illegal construction without license and 1+4, my lord.
Learned counsel for the respondent BPMP has filed an action taken report. Full stop. In terms of the said report, it is clear that the respondent BPMP authorities have issued a provisional order under section 248(1) and (2) dated 14/5/2024 to respond number 4. Full stop. Learned counsel for respond number 4 submits that respond number 4 ಆಗ್ಲೇ ಕೊಟ್ಟಿದ್ದೀರಾ ಅಥವಾ you want to
No, reply is filed. Reply.
has filed a reply to the said provisional orders. Full stop. The authorities are required to proceed in accordance with law. Full stop. Learned counsel for the BBMP seeks for some time to report as to the further action taken by the authorities. Full stop. Release this matter on 1st of July 2024. Yes.
Seal number 25, KV Narasimhan.
Appearing for petition, my lord.
Yes.
My lord, writ is for seeking mandamus, my lord. The respondent number 5 herein has put up illegal
I'm
construction.
referring for respondent number 5. There is an office objection IA 2 of 23. Kindly
For
grant
vacate-
one. Please,
Vacating.
please, my lord. 1 week time may be granted, my lord.
You are the complainant.
I am the complainant.
You are the person, owner of the property.
Please, ma'am.
Who has put up construction against, without getting a sanction plan and,
No sanction plan.
no sanction plan. Hence, this, petition has been filed. my lord.
Yeah, same thing, what I said now earlier. Same thing has to happen, nothing else. If they have issued notice, you will have to give a reply. They will proceed in accordance with law. You have one option of appeal to go before the assistant, chief commissioner. Nothing else can be done. How can we vacate the order already passed? We have only directed them to take action in accordance with law. If you are able to satisfy them, saying that I have obtained a sanction plan, I am putting construction only in accordance with the sanction plan, only then you can succeed. Nothing else can be done.
Kindly pass over, my lord.
Yes. Pass over.
Number 26,
Applying for the petitioner.
Srinivasa SB.
This matter, my lord, petitioner is the license holder of the laying the flex boards, my lord, in the limit of the Sajjapura MRA Gram Panchayat, your lordship. Here, my lord, he has the license grantee, my lord.
Who has filed the application for
I filed the IA for direction.
direction?
Yes, your lordship.
Your
Because
direction?
in similar circumstances, my lord, one order was passed in repetition number. I have produced in annexure P 22849.
This case kindly weeks accommodation.
ಅಲ್ಲ ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಡೈರೆಕ್ಷನ್ ಬಿಕಾಸ್ ಮೇಲೆ ಇನ್ ದಿ ಸಿಮಿಲರ್ ಸರ್ಕಮ್ಸ್ಟಾನ್ಸ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ಸರ್ಜಾಪುರ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಮೇಲೆ ಆರ್ಡರ್ ವಾಸ್ ಪಾಸ್ಡ್ ಮೇಲೆ ಫೈನಲ್ ಆರ್ಡರ್ ವಾಸ್ ಪಾಸ್ಡ್ ಮೇಲೆ
Annexure P na?
Annexure P in IA for IA two ಅಲ್ಲಿ sir, IA two for directional. ಅಲ್ಲ annexure P is the order dated in writ petition number 22849 of 2023, your lordship. The same was passed on 1st April 2024 in respect of Sarjapura Gram Panchayat.
Yes.
This is malad in respect of MRA Gram Panchayat malad. Keeping this order, malad, holding this order, malad, PWD is removing our holdings also, malad, in respect of MRA Gram Panchayat also. Because both are the same, malad, petitioner is, malad. Here, malad, illegal, I have the license holder, malad, he is covered by the judgment also in Annexure E. E is the judgment in petition, writ petition, malad, Annexure E is the earlier judgment, malad. Annexure E, page number 26, your lordship. Just malad, in the last para, malad, in that malad, para 5 of the judgment, malad. Till the consideration of the application to be submitted by the petitioner, the respondent 4 shall not take any prospective action against the petitioner by removing the hoardings erected, and the petitioner is also restrained from erecting new hoardings or replacing the hoardings till the consideration of the application by the respondent number 4. Immediately, I have given the representation on 22/9/2022 in Annexure F, your lordship. The same was for
File application for renewal of license.
renewal ಗೆ ಅಲ್ಲಿವರೆಗೆ ನಂಗೆ ಲೈಸೆನ್ಸ್ ಇತ್ತು ಅಂತ ಹೇಳಿ I have completed my license period ಮೇಲೆ they have given my permission to file an application ಮೇಲೆ. In Annexure F, I have given the application for renewal of my license ಮೇಲೆ.
22/9/2022.
ಹೌದು ಸರ್. ಆಮೇಲೆ thereafter Annexure G is there. ಅಲ್ಲಿಂದ renewal ಆಗಿದೆ ಸ್ವಾಮಿ, I have paid the tax also ಮೇಲೆ. Annexure G is the letter dated 22/12/2022. Every year, my lord, I raising the demand notice, I am giving the demand notice ಕೊಡ್ತಾ ಇದ್ದಾರೆ ಸ್ವಾಮಿ, I have paying the tax, your lordship. In Annexure G, 22/12/2022, Gram Panchayat has written the letter to the executive officer, my lord. Thereafter, my lord, in Annexure H is the executive officer also given the endorsement that, my lord, page number 34.
Annexure G does not say anything about.
Annexure H is there, madam. H, that is the communication letter to the executive officer, madam. Annexure H is passed by the executive officer to the Gram Panchayat, madam. ಕಾನೂನಿನ ಸಲಹೆ ಏನ್ಪಡ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಸಾಮಾನ್ಯ ಸಭೆಯಲ್ಲಿ ಚರ್ಚಿಸಿ ಕ್ರಮ ವಹಿಸಲು ತಿಳಿಸಿದೆ, madam. Till the final consideration of the decision, madam, they could not remove my holdings, madam. That is the judgment of this honorable court in earlier vacation, madam. Thereafter, my lord, I raised the demand, this one, my lord.
How can you be permitted to exhibit the advertisements without there being a license?
I have not exhibiting the only the hoardings were standing, my lord. Here, what happened, my lord, in between, my lord, third respondent, he is the private respondent, he is laid the foundation of the new advertisement boards. So far as I came before this honorable court, my lord, in earlier occasion in this application, my lord. When the, my lord, order, when these proceedings are pending, on that time, my lord, third respondent, one name is Rohit Kumar. He come and he is laying the foundation for the new hoardings in that area. On that time, my lord, I approached this court, my lord, because if anything is happened, any accident is happened, my lord, this is responsible of the petitioner only. So far as he come before this honorable court to not to put any hoardings or now our time you have come approach this. Allah Swami, I have approached this court because he's third respondent Rohit Kumar. He is the private respondent. He is laying the foundation for new without license. Without license, he don't have any license, my lord. He admitted that he don't have any license in other application.
That has got nothing to do with your renewal of your license.
That application is pending, my lord. They are not considered at all. They have.
ಅದಕ್ಕೂ ಇದಕ್ಕೆ ಯಾಕಮ್ಮ ತಾಳೆ ಹಾಕ್ತೀರಾ?
ಅಲ್ಲ ಸ್ವಾಮಿ, ಅಲ್ಲಿ direction is.
Some other person has done something illegal.
Yes.
They will take action in accordance with law. How are you concerned with him?
Because, my lord, that MRA Gram Panchayat is license is with me, my lord. Because as per the direction, my lord, they are not removed.
That is what I am asking. Monopoly na.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಅವರು
only it has to be given only to you ಅಂತ. ಯಾವ ಕಾನೂನು ಇದೆ? Please.
Annexure A, my lord, in proceedings.
There is the provision which enables only you to be given. Then
not that, my lord. Annexure A is the permission letter they have given, my lord.
ಅದಮ್ಮ ನಿಮ್ದಾಯ್ತು. How are you saying that no other person should be given the license to exhibit the advertisements?
They have not given in Annexure P. They have.
Are you concerned with that?
Because, my lord, now.
You are only concerned with your advertising boards.
Yes, your lord.
And there is no license is not renewed.
License
You
renewal
are
pending,
asking for renewal of the license.
that pending.
You are only
consideration.
concerned about that.
In
You are not
annexure
concerned-
P, your lordship, in that matter, they are laying the foundation without license, they have admitted in
How
that.
are you concerned with that?
In my matter, annexure E ಅಲ್ಲಿ ಸ್ವಾಮಿ earlier direction.
Property ಅಲ್ಲಿ ಮಾಡಿದಾರಾ?
ಅವ್ರು ನಾಟ್ ಪ್ರಿಸಿ ನಮ್ ತೆಗಿಬಾರ್ದು ಅಂತ ಡೈರೆಕ್ಷನ್ ಇದೆ ಸ್ವಾಮಿ earlier. They are very clear.
ಯಾರ ಮತ್ತೆ ತೆಗಿತಾ ಇದಾರೆ? Who is removing your?
They removing that only I have told the
You
direction.
are only concerned with that one.
PWD ಅವರು they remove.
Not the action of the third respondent who is.
Our concern is,
Another construction.
our concern is
You
only,
are not concerned with that.
only
Unless you point out that the
PWD.
provision enables only one advertisement company to be given all the advertisements and no other person should be given the license. Please show that.
Now my grievance is matter PWD is removed by my holdings matter.
So
That is,
please confine your argument only in respect of your advertisement boards.
yes, matter, because based on that annexure P matter,
So you are not putting up any advertisements.
no, I have not putting up, already it was there. That one they have removed matter based on this order matter.
Directions have already been given them not to precipitate the matter.
ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಇಲ್ಲ ಸ್ವಾಮಿ, ಇದ್ರಲ್ಲಿ ಕೊಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ, ಇದ್ರಲ್ಲಿ ಕೊಟ್ಟಿಲ್ಲ. ಅದ್ರ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 3 ಮಾಡಬಾರ್ದು ಅಂತ ಕೊಟ್ಟಿದ್ರು, PWD ಗೆ ಕೊಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ. Here matter PWD is removing the holdings. Initially ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 3 has not put any ಇದು ಅಂತ ಕೊಟ್ಟಿದ್ರು ಸ್ವಾಮಿ ಡೈರೆಕ್ಷನ್. Now matter PWD is
Who is appearing for respond number 3?
3 ಗೆ ವಿಶ್ವನಾಥ್ ಭಟ್ ಅಂತ ಹೇಳಿ ವಕಾಲತ್ ಹಾಕಿತ್ತು A ವಿಶ್ವನಾಥ್ ಭಟ್ ಅಂತ.
To ensure that respond number 3 does not direct, does not install any advertisement hoardings there.
ಅಂತ ಹೇಳಿದ್ದಾರೆ ಸ್ವಾಮಿ.
Huh?
Because they have come before the court and they admitted that we don't have any license, we have not put any ಅಂತ ಹೇಳಿದ್ರು. ಅದಕ್ಕೆ court has direct.
How can you have any grievance against respond number 3?
Because in MRA melody, MRA Gram Panchayat, that is melody.
Do you understand what I am trying to say?
We have given the letter.
The vast extent of land under the jurisdiction of the Gram Panchayat. Many people will come and ask for issuance of license. They can give.
Yes, my contention
You
because.
are only concerned with your board.
Yes, sir. But in between, there is a
Or
place,
you are asking for action to be taken against respond number 3.
because in 100 meters place is there, one board to one board, as per the act, you have to leave the 100 meters difference.
ಅದನ್ನ
In the
ತೋರ್ಸಿ
between, in the between, he has laid the foundation. So far as we can, here, I have produced the photographs in the annex IA 1 of directional lesson. I have produced the photographs. Annexure M series ಅಲ್ಲಿ. ಅದರಲ್ಲಿ ಸ್ವಾಮಿ photographs ಅಲ್ಲಿ ಈ ಬೋರ್ಡಿಂಗ್ಸ್ ಅವರು ನಮ್ದು 100 meters in between ಅಲ್ಲಿ they have laid that boards ಮೇಲೆ.
ಯಾವ ಬೋರ್ಡ್?
Annexure M series ಅಲ್ಲಿ.
ಹೌದು, ನೋಡ್ತಾ ಇದೀನಿ.
ಆ ಬೋರ್ಡ್ ಅಲ್ಲಿ ಸ್ವಾಮಿ. He has the lady boardings in between our boardings ಮೇಲೆ.
ಯಾವುದು ನಿಮ್ದಲ್ಲಿದೆ?
ನಾವು ನಮ್ಮದು ಹಾಕಿಲ್ಲ, ಅವ್ರದ್ದು ಮಾತ್ರ ಸರ್. ಅವ್ರು ಯಾವ್ದನ್ನ ಹಾಕಿದಾರೆ ಅದನ್ನ ಮಾತ್ರ ಹಾಕಿದೀವಿ ಸ್ವಾಮಿ.
So how can court come to a conclusion it is within 100 meters distance?
My concern, let the Gram Panchayati may take action against that melody. ಅದ್ರ ಬಗ್ಗೆ ಅವ್ರು ತಗೋಬೇಕು ಸ್ವಾಮಿ ಅದ್ರಲ್ಲಿ. It's my conclusion.
IA 1 for direction.
Yes.
What direction do you want? To remove the hoardings and
In IA 2 is the direction. Now I am seeking IA 2 is against the PWD. They are removing my hoardings so far as for that.
That is not your prayer. Please read your prayer in the application.
IA 2 of direction. It is prayed that this honorable court may please to direct the respondent not to remove the hoardings and advertisement directed by the petitioner. That is the respondent. Krishna Temple, Sorapur and Dhamma Sadra Circle to the me.
Yes, what do you say?
PWD is not made party in this spirit petition. PWD is not made party.
How PWD is concerned in these
because
matters?
Now I am, that is only matter because in other, they are keeping the other order ತಗೊಂಡ್ ಬಂದು ಅವರು they
ಯಾವ order?
in the annexure P melad, that is in the similar circumstances in repetition number 22849. That is in respect of the Sarjapura Gram Panchayat.
How is the PWD concerned with these matters?
In this case, yesterday I received the copy, the instruction from the PDO, Malashu. Kindly 1 week time, Malashu.
And permit me to amend that.
Send the letter to the yesterday PDO.
Plead the PWD as a party.
In this case, that made the party of PWD. Malashu.
Is there anything in the order
Yes.
to show
Yes.
why PWD is a necessary party to the proceedings?
Because they are claiming, Miller State Highway until this coming under the PWD. Now they are claiming, Miller. We have given the representation. So far as we have taken the NOC from PWD also.
If you are putting any advertisements on the road,
Yes.
across the road,
Across the road, so far as I have taken the NOC from the PWD also, Miller. I have the letter of that, Miller, NOC from the PWD also. Though so far as, Miller, they have removed my holdings. So far I asked them. They are stating that this is the state highway.
If IA is concerned, filing the objection, get from the instruction from the PDO, Malashu.
they have filed an application in the year 2022. You are still to consider. And in the meanwhile, you want to remove. You want other person to put up a board. What is this?
Next week, Malashu, 1 week, Malashu. I get instruction from the PDO.
At the oral request of the Learned Counsel for petitioner, the Public Works Department of the state government is permitted to be impleaded as a party respondent to the proceedings. Is it the department itself or the executive engineer or the assistant executive engineer?
Executive engineer, KG Road.
ಯಾವ್ದಾದ್ರು ಡಾಕ್ಯುಮೆಂಟ್ ಇದೆಯಾ ಇಲ್ಲಿ?
ಹಾ ಸ್ವಾಮಿ, NOC.
ಯಾವ್ದದು?
In annexure B, NOC dated 5/2/2019 in the petition, Your Lordship. Page number 20.
Executive engineer. Executive engineer. Bangalore division, BBMP. Learned Counsel shall carry out the amendment in the cost title forthwith. Next para, Learned HCDP takes notice for the newly implemented respond number 4. Next para. Although the matter is coming up for hearing on IA number 2 of 2024, which is filed by the petitioner seeking interim directions to the respondent Gram Panchayat not to remove the hoardings and advertisements during the pendency of the petition. Nevertheless, Learned Counsel for the second respondent Gram Panchayat seeks for a short accommodation to secure instructions and make submissions. Full stop. Next para. I released this matter on 26th of June 2024. Full stop.
Serial number 46.
Till the next date, the second respondent is directed not to precipitate the matter any further.
Second and fourth, Your Lordship, that PWD also, Your Lordship.
Our action ತಗೊಂತಾ ಇರೋದು PW ಎಲ್ಲ
PWD ತಗೊಂತಾ ಇದ್ದಾರೆ ಸ್ವಾಮಿ
Let
ಅವರು.
us see.
Kindly, Your Lordship, fourth.
Badri Vishal.
My lord, serial number 46. 46 are same one.
46 same.
46 is here. That is in respect of the Domsandra Gram Panchayat. In that matter, I have the license. Renewal agide.
License.
Renewal agide ಸ್ವಾಮಿ ಅದರ license ಇದೆ. I have paid the taxes also. In between also they are removing my lord. PWD is going to remove my hoardings my lord.
ಅದರಲ್ಲಿ PW ಪಾರ್ಟಿ ಮಾಡಿದ್ದೀರಾ?
ಅದ್ರಲ್ಲೂ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ ಅದು initially third respondent is interrupted my lord. Afterwards my lord he came before the because we have a
ಅದರಲ್ಲೂ 46 ಅಲ್ಲೂ same order. Yes.
till that my lord not to precipitate
Yes.
by the fourth respondent.
ಆಯ್ತು ಅವ್ರನ್ನು ಸೇರ್ಬಿಟ್ಟು.
Fourth
Yes.
respondent.
Serial number 27, Badri
Krishna,
Vishal.
my lord.
IP of respondents.
Yes.
Let's praying for an adjournment, my lords. I have informed the other side in the morning.
Kindly list next week, my lords.
Stormwater drain.
Yes, my lords.
You don't know what is the matter about?
My lord, the respondents have illegally demolished the construction that we have built over the storm water, my lord. The permission was granted by them as per Annexure K. Subsequent to that, they have demolished it. We have filed the present writ petition seeking for a declaration that it is illegal, my lord, in violation to Annexure K.
My lords, we have filed a statement of objections and they have also placed a memo with certain documents. So we are securing instructions, my lords.
There were no interim directions?
There is, my lord. The interim prayer is for construction of the to reconstruct the entire covering, my lord.
By which order, which date?
My lord. Annexure K, my lord.
No, by which order that interim directions have been given? Because nothing is stated in the previous orders regarding extension of the interim order.
There is no interim, my lord.
No interim order.
No, my lord. No.
They have demolished it
Yes, my lord, they have demolished it.
at the request of learned counsel for the respondent BBMP. Release this matter
Next week, my lord.
on 26th of June.
Yes, ma'am.
Yes.
Serial number 28, Lata Shetty.
Lord, I prepare for the,
Affidavit.
this court, my lord, had directed me to file an affidavit. My lord, bringing to the notice, my lord, which association wants to take over the possession of CA sites and the parks. My lord, I am filing affidavit now, my lord, saying jointly, my lord, we will take possession, my lord, of the parks. Court. This is a case where, my lord, R9, who's the developer, my lord, in the plan, if I may submit, my lord.
Yes.
My lord, in the plan which was, my lord, approved in favor of the respondent number 9, my lord, who is the developer. My lord, there are 6 towers. Now, my lord, as far as 4 towers, my lord, the association is informed and we have filed affidavit, my lord, saying that jointly we will take over the CS sites and parks, my lord, as per the revised master plan, my lord, 7.1 and 7.2. As far as the other 2, my lord, the associations are not yet formed, my lord, by the developer. My lord, we undertake that, my lord, whenever it is formed, my lord, it will be for the benefit of everyone. It is not only the benefit form of the 4 towers. Now, my lord, the developer has relinquished the parks and the open spaces, my lord, as per the relinquishment deed, annexure R. If your lordship may kindly see, my lord, annexure R. Annexure R. Page 318, my lord. Page 318. Now, my lord, if your lordship may kindly, this is, my lord, rectification of the relinquishment deed. In this, my lord, the next page, 320. If I may read, my lord. Previously, the first party has relinquished the rights in Schedule B property in favor of the second party free of cost and handed over parks and road area as per the residential development plan on so and so. Relinquishment deed registered in sub-registrar office so and so. In view of the sanction of the remodified plan and open spaces, area relinquished earlier through relinquishment deed has to be rectified as below. Now, my lord, Park 1, Park 2, 3, 4, next page, my lord, Park 5. Total area of relinquished area, now it shall be rectified to so and so. Next, whereas the first party agrees that as per the draft of the residential development plan, the area reserved for park and roads are situated in Schedule A property, more fully described in Schedule B to this deed, and hereinafter referred to the schedule shall vest with the second party. Second party, my lord, is the BDA. So, my lord, the entire park and open spaces, my lord, as on today, is vested with the BDA, not with the, because, my lord, my learned friend, that is the developer's contention is, they are not able to hand over park number 3, 4, and 5. And only park 1 and 2, they are ready to hand over. That cannot be the case, is my submission, my lord, before your lordship, because they have already executed a relinquishment deed and park 1 to 5 have already been relinquished. Next, accordingly, first party on this day has relinquished the rights in Schedule B property in favor of second party free of cost and hereby handed over parks and road area as per the draft residential development plan now submitted, which more fully described.
Yes.
Now, my lord, in view of the fact that they have already relinquished the park areas and open spaces to the Bangalore Development Authority, the developer now cannot, my lord, come before this court and say, we will just hand over park number 1 and 2. Is my humble submission before your lordship. Now, your lordship may kindly turn to 7.1 and 7.2 of the revised master plan, my lord, which your lordships have on the last occasion looked into it. Lordship may kindly turn to 7.1, my lord. Revised master plan 2015, man. Revised master plan 2015. May I pass or man? Pass it.
Yes.
My lord, firstly, my lord, may I request your lordship may kindly turn to page 43, my lord, that is 6.1 in the revised master plan, in the revised master plan 2015. My lord, in respect of layouts as concerned, my lord, layout is, my lord, plotted development. As your lordships, my lord, on the last occasion, my lord, querying whether the civic community sites could be handed over to the association or not. My lord, as far as that is concerned, my lord, your lordships are absolutely correct. As far as the plotted development is concerned, it has to be, my lord, park and civic community site will go to the planning authority and they will be in possession of it. That, my lord, is seen in, my lord, chapter 6, in the chapter 6 clause D. 6 clause D, my lord.
Yes.
6, my lord, deals with subdivision regulations. My lord, this is, my lord, road with area of residential parks, open space, how much it is there? 6 point D. After making provision for park and roads in the layout, the balance portion of the land shall be earmarked for civic community site only. Such CS site shall be relinquished to the BDA free of cost, free of encumbrance. That is, my lord, in respect of plotted developments. Now, my lord, in respect of my lord, residential development, that is apartment more than 20,000 square meters. Your lordship may kindly to 7.1 regulation. Regulation, my lord, 7 deals with regulation for residential development plans and non-residential development plans. That has also been, my lord, defined, my lord, in the definition. What is a residential development? It is there, my lord, in the definitions also. Now, my lord, regulation for residential development plan. 10% of the land reserved for park and open spaces. The open space park shall be relinquished to the authority free of cost, and the same may be allowed to be maintained by the So, my lord, we are not seeking, my lord, them to transfer the title. It is just for maintenance, what we are seeking. The same may be allowed to be maintained by the local resident association, registered if the authority so desires. It is only for maintenance, my lord, we are seeking. Next, my lord. A minimum 5% of the total plot area shall be provided for civic community, and the owner or developer shall develop such civic community, which finally shall be handed over to the local resident association for maintenance. So, my lord, as far as parks, my lord, now I submitted, my lord, they have already done a relinquishment deed. As far as CS sites are concerned, there are 2 CS sites, civic community site number 1 and 2. Now that has already been developed. My lord, clubhouses are there. Clubhouses, in the sense, my lord, there are sports facilities, my lord, in that civic community sites which they have constructed. That, my lord, has to be, as per 7.1 clause 2, shall develop such civic community, which finally shall be handed over to the local resident association for maintenance. The mode of such handing over shall be decided by the authority. That is for the BDA. We have no objection to that. So my humble prayer to your lordship now is, now since, my lord, civic community site is also been developed, and the roads and parks have also been relinquished, as per 7.1 and 7.12, they have to, my lord, hand it over to the association. My lord, now they cannot say that 2 associations are not formed. My lord, we undertake before this court, whenever it is formed, it will be for the benefit of all the residents of that community. It is not that, my lord, we want to take over and maintain it. My lord, it is for the benefit of everyone, including the residents where association is not formed in 2 towers. That is our case. That is, my lord, in respect of the CS sites and park is concerned. Now, my lord, my one more prayer is, after the sale deed has been executed, they are, my lord, going on modifying the plan, which is not permissible, my lord, according to the petitioner's hearing. My lord, the RERA Act clearly says the ongoing project also will be, my lord, under the RERA. Now, my lord, if they want to modify the plan, 2/3 of the residents, the owners, have to give their approval. My lord, my instructions are, pending this writ petition, the BDA has once again, my lord, in the last 1 month, my lord, modified the plan, which I am not, my lord, which they have to, my lord, bring it to the notice of this court, whether they have modified again or not. Because, my lord, here, I am challenged the modification of the plan done in 2016 itself, saying that, my lord, the plan of 2011 and 12 has to continue, and they cannot modify it. My lord, instructions are, when this matter is pending, they have again modified the plan, which is not permissible.
What are they trying to do by modifying?
My lord, they are trying to add extra areas and get 2 more towers. And what they try to say before this court is, this is an ongoing project. Until these 2 towers come up, we will not hand over the civic community which is developed. And this clubhouse which is run, they charge us money to use it. They have given it to a third party. They collect external, bar and restaurants are there. And sports activities, if we have to use the sports activities also, they charge us money. My lord, that cannot be done. Because, my lord, once a plan is sanctioned, once the act clearly says modification is not permissible unless 2/3 gives their consent. Therefore, my lord, we are before this court. Therefore, this court, my lord, on earlier occasion, directed the BDA to file an affidavit, bringing to the notice of this court what has happened to the park areas, and also directed, my lord, BBMP to file a report with whether illegal constructions are going on or not. BDA has filed a report, but as on today, my lord, BBMP has not filed a report. If your lordship may kindly see the first order, my lord, passed by this honorable court.
What is the stand of the BDA?
BDA says, my lord, your lordship may kindly see their affidavit, my lord, which was filed pursuant to direction of this court. They, my lord, they say they have gone and done a spot inspection. They say relinquishment deed has been done, but they say only Park 1 and Park 2 Park 1 ಅಲ್ಲಿ cricket net ಇದೆ. Park 2 ಅಲ್ಲಿ it can be handed over. Park 3 and 4 are with the custody of the developer. Illegal buildings are there. Now, if it is there also, it is a duty of the BDA, my lord, to see that parks which are already been relinquished to them are maintained as a park. The second question of handing over, my lord, is subject to your lordship's direction.
What construction they have put up?
My lord, they say in the report, if your lordship may kindly see the report, my lord, which was filed on 3/4/2024.
Huh.
Three, 4/24, my lord, CA. My lord, they talk about the relinquishment deed. Then CA ನಿವೇಶನ ಒಂದರಲ್ಲಿ ಸದರಿ ಶಿವೇಶ ನಿವೇಶನ ಅನುಮೋದಿಸಿದ ಒಂದು ಅಭಿವೃದ್ಧಿ ನಕ್ಷೆಯಲ್ಲಿ ಸ್ಪೋರ್ಟ್ಸ್ ಹಾಲ್ ಅನ್ನು ಡೆವಲಪರ್ ಅವರು ನಿರ್ಮಾಣ ಮಾಡಿ ಅವರೇ ನಿರ್ಮಾಣ ಮಾಡುತ್ತಿರುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಸದರಿ ಸ್ಪೋರ್ಟ್ಸ್ ಹಾಲ್ ಅನ್ನು ರೆಸಿಡೆನ್ಸ್ ವೆಲ್ಫೇರ್ ಅಸೋಸಿಯೇಷನ್ ಅವರಿಗೆ ಹಸ್ತಾಂತರಿಸಿರುವುದಿಲ್ಲ. ಬದಲಾಗಿ ಸದರಿ ಸ್ಪೋರ್ಟ್ಸ್ ಹಾಲ್ ಅನ್ನು ಅಪಾರ್ಟ್ಮೆಂಟ್ ನಿವಾಸಿಗಳು ಉಪಯೋಗಿಸಲು ಪ್ರತಿ ತಿಂಗಳು 40,000 ಶುಲ್ಕವನ್ನು ಭರಿಸಿ ಉಪಯೋಗಿಸಲು ಡೆವಲಪರ್ ಅವರು ತಿಳಿಸುತ್ತಾರೆ ಎಂದು ಅಪಾರ್ಟ್ಮೆಂಟ್ ನಿವಾಸಿಗಳು ತಿಳಿಸುತ್ತಾರೆ. Next, my lord. In respect of CA2 also, my lord, the same thing. Park 1 ನಲ್ಲಿ, they say, my lord, there is a cricket pitch. For that also, my lord, the residents have to pay. Park 3 ಅಲ್ಲಿ, Park 2 ಅಲ್ಲಿ, they are agreeable for transferring. Park 3, my lord, your lordship may kindly see, there is a bar and restaurants which is being run. What has happened, my lord? There is a civic community site. Next to the civic community site is the park. So in the civic community site, there is a bar and restaurant which is being run. So they have.
Why should this court under Article 226 enter into all these disputes?
My lord, what I'm.
It is a dispute between you and your developer.
Yes, my lord.
Go before the civil.
They have filed a suit.
My lord, civil court. Yes, my lord. Now, what I am trying to, my lord, establish before your lordship is only this. The regulation clearly says that parks and say, I will not even go into the question who is doing it. Now, BDA gives a report before this court saying that, my lord, the parks are in their custody.
It is nothing but high-handed action according to you.
Yes, my lord.
Isn't it?
My lord, it is not.
It is nothing but encroaching upon the property belonging to the residents of the building. So you'll have to take action in accordance with law under Article 226.
My lord,
how do you expect this court to get into the litigation between two private parties?
It is not a litigation, my lord. What I'm trying to say is the statutory authority which says.
Correct, sir.
The rule clearly says.
You are pointing out to the provisions.
Yes, my lord.
In the zonal regulation.
Yes, my lord.
And according to that.
Yes, my lord.
Relinquishment deed has been executed.
Yes, my lord.
In spite of that.
Yes, my lord.
They claim to be in possession of the property.
My lord, my submission is my lord, my submission is the BDA has the possession. Now they have to act according to the regulation. I am not even going to further, my lord, I am just trying to say the regulation 7.1 and 7.2 has to be acted by the BDA because the BDA is the plan sanctioning authority. That is one. Second is, my lord, I have sought for, my lord, quashing of the plan which has been remodified plan which has been given by the BDA in violation of the RERA Act. My lord, my prayer is to quash the modified plan as well as direction, my lord, to hand over as per 7.1 and 7.2.
I appear for, I appear for response.
If this is the kind of allegations that are being made by the purchasers, that this is what you are doing after putting up part of the construction, what should happen to your reputation?
My lords, I'll make a statement.
These are all very say only available only to the creamy layer of the society.
My lords, the contention.
And we know what is the amount that they pay for all this.
My lords, the contention, my lords, we have filed a detailed statement of objections. My lords, this is an area, my lords, the larger area is about 33 acres. 6 towers, my lords, have already been put up. The development plan, my lords, is with respect to 8 towers. 2 other towers, my lords, have to be put up. 8 towers of residential building, 5 parks and 2 civic community sites. In so far as Park 1 and Park 2, my lords, it is completely developed.
In respect of the entire 33 acres.
Please.
There are only 5 parks.
5 parks and 2 civic community sites. That's the developed plan, which is sanctioned by the BDA. We have relinquished it. Then, insofar as 5 parks, my lords, we have no objection. BDA can take over possession. Insofar as park number 3 is concerned, one, my lords, Nikos Hospitality Private Limited, they have put up temporary structure, which is in contravention to the leave and license agreement which they had entered into with us. We have terminated that agreement. They have gone to the commercial court. They have obtained an order of injunction. I have also made a statement before this honorable court on 16/4/2023 that even if BDA demolishes that, I have no objection. I have made that statement. It is not at our instance they have put up those temporary structures. Insofar as the park is concerned, my lords, we are in agreement that it has to be maintained and all the structures need to come down. Even if they don't want the cricket pitch, which is on the Park 1, that also can be demolished. They are using that cricket pitch. We have no objection to that. 2 civic amenity sites, my lords, we have developed it. 8 associations have to be formed. In terms of the covenants made in the sale deed by the developer to the purchasers, apex body has to be formed overlooking these 8 associations. Apex body will take over the management of the civic community sites. They cannot say that we will take it over now, and tomorrow if they have a dispute with the other 2 associations where the towers are yet to come up, then I cannot solve it. And with respect to the very same prayers which they have made in this present writ petition, a suit is filed, my lords, that also I have brought it to the notice of this court. OS 49 of 2021, they have filed the very same association. They have also filed a consumer complaint.
The prayer there?
There, my lords, the prayer in my statement of objections at page 42 is the suit.
That is, my lord, in respect of open space where they're trying to put a gate. My lord, now the entire plan is for entire extent. They in the middle, my lord, they cannot put a gate. My lord, restricting us, my lord, to entry into park 2, 3, 4. What they do is they put a gate and say yours is only this tower. You cannot go to this tower. In respect of that, a suit has been filed. Now, my lord, I am not on that ground at all. I am now before your lordships, only on the limited ground, my lord, to deal with 7.1, 7.2 and whether the modification plan is in accordance with law or not. Modified, whether after the sale deed is executed, whether a plan can be modified without the consent of the owners of the apartment is a question, my lord, before your lordship. As far as the suit, my lord, the condition in the plan itself, I will not go into that question. Conditions in the plan itself, it declares that open spaces has to be left for the enjoyment of the residents. They cannot, my lord, fix gates and say, you cannot go there. That, my lord, my remedy is there. I will, my lord, look into it if, my lord, they have objected it. Now, my lord, before this honorable court, my prayer before your lordship is whether, my lord, plan can be changed on 3 occasions, 4 occasions without the consent of the residents or the owners. My lord, and my lord, because when we have purchased it, we know this is the CS site, this is the park. Here my family members can enjoy it.
All this arises only out of the contract between the parties.
My lord, it cannot be a contract, my lord. It is, my lord, the plan sanction we have to look into. Whether the plan sanction clearly says what are the terms and conditions of the plans. Now, contract, there might be a contract, illegal contract, void contracts, where, my lord, the builder is in the upper hand when we purchase it, there may be terms and conditions. Whether the plan sanction has been adhered to, whether the RERA Act says that it can be done, is the question, my lord, before you.
Let us see the sanction plan.
Yes. My lord, if the BDA can point out, I will, my lord, show the plan sanction. Point out whether now pending this writ petition, whether they have, my lord, approved one more plan or not, my lord, that will be relevant to this case also.
Page 227, my lord, says the sanctioned plan, Annexure K.
My lord, Annexure K, my lord. Page 227 is the first plan, my lord, which was done on 15/9/2011. Lord, the same builder, my lord, in Madras, the same points for consideration came up before this court, but in my lord, in division bench, my lord, of the Honorable Chennai High Court. Against the same builder, same modus operandi. The Chennai court, my lord, has come down heavily on the builder and has said that, my lord, the plan cannot be modified without the consent. And my lord, further, in respect of CH-8 parks, my lord, identical facts, my lord, and identical builder, respondent number 9. My lord, if lordship permits, my lord, I will just, my lord, pass on the order also, my lord. Now, my lord, as your lordship wanted, my lord, annexure K, my lord, is the first plan, my lord, dated 15/9/2011. Now, my lord, subsequently, in this plan, if your lordship kindly sees, there is this plan, my lord, was sanctioned for 19 acres, 28 guntas. My lord, your lordship will get it, my lord, on the top column, residential development plan area. It is, my lord, for 19 acres, 28 guntas. And here, my lord, there are 6 blocks. My lord, there are 6 blocks, my lord.
There are only 4 here.
4. My lord, there are 4 towers.
Towers.
Block anta haki. If your lordship kindly sees, my lord, this is block number 1. Block number 1. This is my.
What about block 3?
My lord, block 3. My lord, block 2, block 1 is the. My lord, it is called as Club Meadows. Block 2 is, my lord, shown as Sports Hall. Block 2 is shown as Sports Hall. Block 3, my lord, is Hillcrest, my lord, that is the petitioner herein. The association, the Tower of Hill petitioners. Block 4, my lord, is also one more tower. Block 5 is also tower, my lord, which is here, block 5. Block 6 is, my lord, shown as clubhouse area. Block 6, my lord, is shown as clubhouse area. And block 7, my lord, are the 2, 7B and 7C.
Ordinarily, this is a plan for 19 acres and
yes,
28 guntas.
Yes, my lord.
What about the proposed modified plan?
Yes, my lord. That I have produced, my lord.
Yes.
That is at
That includes other area?
33 acres.
That is for 33 acres.
That is for the additional area.
That is for 33 acres. Now, your lordship may kindly see, my lord, the next plan which they have obtained in 2015. Additional area separate plan ಮಾಡ್ಕೊಳ್ಳಿ ನಮ್ಗೇನಿಲ್ಲ. ನಮ್ದು first plan was for 19 acres. We have no objection, my lord, for the other extra land. Separate plan they can do, my lord, and they can construct. We are not even bothered about that. Now what they do is they change the entire plan. ಈಗ ಇರೋದು block 1, block 2 ಅಲ್ಲಿ club house ಇರೋದು CS sites, it all been changed. Now, my lord, the second plan. Dated, my lord, is in 2015. On 2/6/2015.
229, man.
The next page, alva.
Annexure M.
Next alla Swami. 229. Annexure M.
229, man.
M.
M.
Annexure N.
M. Here, my lord, plan is for 33 acres. 33 acres, 29 guntas.
MIN,
M.
page number 230.
229.
229.
229.
And iದೇನಾ ಅದರಲ್ಲಿದಾ? 229 my lord, M, annexure M.
ಇಲ್ಲಿ ಬಾಟಮ್ ಅಲ್ಲಿ ಬಂದಿದೆ.
I'm sorry, my lord.
ಕೆಳಗಡೆ ಬಾಟಮ್ ಅಲ್ಲಿ ಬಂದಿದೆ ಎಕ್ಸ್ಟೆನ್ಷನ್.
Yes, my lord.
ಹಾ?
Bottom extension.
Ah.
And this entire area, my lord, is extension now.
Ah.
This area, my lord.
ಅದೇ ಕೆಳಗಡೆ.
Yes, my lord.
ಹಾ.
ಕೆಳಗಡೆ.
ಹಾ.
Is the extension.
ಆಯ್ತು.
Now, my lord, again, the blocks which was in the first plan, my lord, have been changed. Block 1, 2, 3 ಅಲ್ಲಿ ಏನ್ ಬರುತ್ತೆ ಅದನ್ನ ಸ್ವಲ್ಪ ಚೇಂಜ್ ಮಾಡಿದ್ದಾರೆ. And my lord.
No, that my lords may not be right. The towers are exactly the same place.
No, towers are same. Towers are same.
The buildings which were constructed, that is the 8 towers, will remain in the same place. The civic amenity sites or the parks would have changed. The constructed area, my lords, is not at all changed. I am making this statement.
My lord, in the first plan, there is only 6 towers. In the first plan.
ಹೌದು,
6 towers.
pertains to 19 acres and odd.
Yes, my lord, 6 towers. Now, my lord,
additional area.
Additional area, they are coming out with the plan. Now, my submission is this.
And you were not aware of this.
We were not aware of
At
this.
that point of time, you
We
were not aware of this.
No, we were not aware.
Further development.
Further development. Now, my lord, we are, my lord, on the basis of the plan which was submitted to us at the time of registration, we have, my lord, registered the property. Now, subsequently, this plan has been modified. Now, my lord, I have learned, now when this matter is pending, one more plan, my lord, modification has been done by the Bangalore Development Authority at the instance of respondent number 9, which, my lord, we have filed an application under the RTI Act, which we have not yet received. But, my lord, my instructions are, now the plan has already been modified. Again, this plan has been modified. Therefore, my lord, my first prayer before your lordship would be, let the BDA come out, my lord, and make a stand whether this plan also has been modified or not. Because if this is also modified, then, my lord, I will have to, my lord, change my prayer, my lord, to include that plan also.
You should be able to make a statement.
My lords, this is a statement which is now made across the bar, my lords. I'll take instructions. But, my lords, what the Residents Welfare Association, this petitioner association wants is, they want 33 acres of land, but with only 6 towers. They want the other place to remain as open space. That is what they want to contend.
No, yeah, that is not our.
That is ultimately.
We
my
do
lords,
not
they are
want
trying
them
do
to
that.
build another 2 towers for next 10 years. And we are there, my lord, and they do not even give us the park and civic community side. That is our. Now, my lord, they want to construct 2, my lord. We have, in fact, my lord, no objection also to that. My lord, that on instruction, my lord, I will submit. Our intention is not to, my lord, spoil this business. We are, my lord, staying there. They do not even ask us. Then they change, my lord, the parking areas have been changed. My instructions are parking area, 2-wheeler parking areas have been changed in the modified plan. So wherever we were given parking, that has now been constructed as commercial complex.
No.
Commercial, yes, my lord, this is my instruction. Then shops are coming there. Now, my lord, this tower, another 2 towers which they want to construct will take, my lord, another 3-4 years.
They are all.
So what they're trying to say is, till that time, we will have the civic community site. We will charge you 40,000 rupees per month. My lord, there are more than 1,000 residents. 1,000 into 40,000, my lord, per family. It's a huge amount which, my lord, we have to pay to use the civic community site. Or a park. Park also, my lord, they do not permit us. Therefore, my lord, we had filed a suit. Because, my lord, they are putting up gates, which is not permissible. However, my lord, that is before the civil court. It is not my intention, my lord, to disrupt him or his business. My lord, they have to stick to the plan which was submitted. And they cannot collect money, my lord, for utilizing the civic community.
40,000 which they are claiming, my lords, is a statement.
That again becomes a dispute that.
Yes, my lord. Therefore.
Dispute that has to be solved before the consumer.
Yes, my lord. Therefore, my limited prayer before this honorable court is, let the, my lord, bylaws be complied with, because, my lord, this honorable court, the division bench has also held 7.1 and 7.2 has to be complied with, which I'll, my lord, substantiate with the judgments. Second is whether the plan can be modified subsequent to the sale deed without the 2/3 majorities consensus. Is, my lord, a limited, my lord, I will look into.
No, see, 6 towers were there.
Yes, my lord.
19
All the
acres.
6 towers,
In 19 acres.
19 acres.
19
All the
acres.
6 towers are constructed.
Constructed. For my lord, association is formed.
What modification are they trying to do?
Now, my lord, they have included extra land and they are doing 2 more.
Don't bring in that additional piece of land, sir.
Yes, my lord.
In the land, 19 acres and odd.
Yes, my lord.
Where 6 towers are already constructed.
Yes, my
We
lord.
haven't.
What other modification
My
they
lord,
are trying to do?
my lord, I will file an affidavit with the details of the modification, my lord.
No, even in
The
terms of the.
towers,
plan,
my
you
lords,
should be
have
able
not
to point-
touched. I am
My lord, I
making
can-
this statement.
Possible also. I don't think they would have.
We have not touched
proposed,
the towers.
My lord,
It cannot be, sir. Construction is already over.
My lord, when they are taking a plan for the next 30 acres, the area which was marked as parking areas for 2-wheelers, 4-wheelers have been changed, and where they have shown it as commercial buildings will come up. Commercial it says for the use of residents. So that has been modified. Now, my lord, I buy a house here in this tower, thinking there is a parking down. Now, my lord, this parking area which was shown in the first plan as a parking area. Now, my lord, it has been converted and shown as a commercial area.
It is not a commercial area, my lords. It's a convenience store which is
Whatever
made for the
convenience store-
purpose of the residents there. It's a convenience store which they are using it day in and day out.
That cannot be
It's
done.
not a
That is my
commercial
case.
business, commercial establishment which is there. It's a convenience store. And with respect to the very same prayer, they have filed another suit. The suit is pending. They basically do not want me to put up 2 other towers there because that is in that additional 12 or 13 acres of land which I own.
My lord, we have no objection.
The
Let him, my lord.
towers, my lords, have not been touched at all. All these statements, my lords, are made across the bar. There's nothing in writing.
My lord, therefore, my lord, this honorable court directed the BBMP.
Within this 19 acres and 28 guntas.
Yes, ma'am.
If there is any change proposed,
Yes, ma'am.
please point out.
My lord, I will file, my lord, with the details, my lord. I'll take instruction.
Point out from this.
My lord, with the comparison, after taking instruction, my lord, I will file an affidavit showing, my lord, what is the difference, my lord, in respect of 19 acres and 30 acres. In respect of only 19 acres, I will point.
Correct.
Yes.
Only in respect of
19
19 acres,
yes,
28 guntas.
Yes,
You
ma'am.
should be able to point out.
Yes, ma'am.
What is the change that is proposed?
Yes, I will point out.
And if already approved.
Yes, ma'am.
You say this is approved.
Yes, ma'am.
Without taking into consideration that.
I will.
6 towers are already built.
Yes, my lord. I will, my lord.
The relinquishment deed is already executed.
Yes, my lord. I will do it, my lord. Therefore, my lord, I will do that, my lord, as your lordship director. I will file an affidavit to that effect with the changes. My lord, the very purpose of rectification of relinquishment deed clearly shows why it was done. Now, my lord, relinquishment deed was done earlier. Then they, my lord, rectify the relinquishment deed, which I pointed out. That was a rectification. That was done pursuant to this plan modified. If there was no changes, the rectification deed would not have been done. Lord, annexure R, which is the rectification deed, my lord. Rectification relinquishment deed.
My lords, the rectification is done for the purpose, the larger project area is included. The main property, my lords, is 33 acres. Earlier, the relinquishment deed was done with respect to 19 acres, 28 guntas. Therefore, the area in the parks have gone up.
I can understand if you had gone before the BDA saying we have got totally 33 acres of land.
Please.
But this first phase, we are developing only 19 acres and odd. The next phase, we will come before you for seeking a sanction in respect of the second phase. And you cannot show any modification in respect of the original plan insofar as the 19 acres is concerned. If that is your contention, then
yes,
they will not succeed.
Please. I understand, my lords.
Insofar as the
6 towers which have already been
attack sought to be made in respect of the modified plan.
Please.
You will succeed only if you are able to point out
that the 6 towers have remained untouched.
Yeah, that entire extent of 19
Please.
acres, 28 guntas, we have not done anything.
Please.
We have only joined this one so that it will be one developed
Composite property.
Composite property, and no rights of the residents who have already purchased property here is affected.
Please. I will be able to point out.
And what is the position in this case?
My lord, that is also a case where, my lord, same developer, respondent number 9, had, my lords, modified the plan subsequent to the sale deeds being executed. The learned single judge, my lord, dismissed the writ petition. Writ appeal was filed. My lord, in the writ appeal, my lord, the findings, my lord, there's no page number. I'm sorry, my lord.
Illa ಕೆಳಗಡೆ ಇದೆ bottom ಅಲ್ಲಿ.
Yes, my lord. 19, your lord, 19 the submissions. And the findings at page 27. Page 27. Discussion and findings. I read, my lord. We have considered the rival submissions made on either side and perused the material records of the case. Firstly, it is admitted that the brochure which is produced at page number so and so of the appeal paper book is the brochure prepared by the third respondent for marketing the apartments in township. It contains master plan for development of entire township. As per the master plan, building number 17 is shown as a clubhouse and sports hall for phase 1, and building number 18 is shown as a clubhouse for phase 2. However, upon consideration of the detailed floors-wise plan of the building number 18 of phase 2, it can be seen that only 2 floors of the said building are proposed as clubhouse, and the rest of the floor built-up area are saleable commercial areas as shops and retail places. The construction agreement are accepted as pari materia and uniform with respect to the clauses and convenience between the parties. Now, my lord, next, my lord. 6.7, my lord, 32. If you lost, may kindly turn to 32. The cause of action on the present writ petition is that after the sale of many of the blocks, the third respondent unilaterally decided to modify the original plan. In the location in which a clubhouse commercial area was to be situated, they decided to build a new 2 towers, which are residential complexes of 107 and 178 units among 2 basement, steel floor, 18 floors, namely so and so. After declaring that it had completed phase 1 and phase 2 in the year 2020, the third respondent made an application on 28/7/20, based on which the impugned proceedings of the second respondent dated 19/11/20 was passed, thereby granting revised plan approval. The details of the blocks that are already built, blocks that are sought to be removed, and blocks that are newly proposed in the building, in the total FSI and the building are all furnished in the impugned order itself in detail. My lord, I will not trouble my lord with all. Same, my lord, as your lordship, sir.
You should be able to point out
Yes, my lord.
the last sentence that you just read out now.
Yes, my lord.
The details of the blocks that are already built,
Yes, my lord.
blocks that are sought to be removed,
Yes, my lord.
and blocks that are newly proposed,
Yes.
including the total FSI and the building area, are all furnished. So
Yes.
therefore, if
I
you
will-
are able to point out
Yes, my lord.
that some modification is sought
In the first.
in the first
19
phase
acre.
of the development,
Yes.
and they have sought to
Change
actually
the-
even alter the park area, open space area,
Yes, my lord. I will, my lord, point out. I will. Yes, my lord.
and I don't think they have done anything in respect of the towers that are already
Towers, no,
constructed.
it is not.
Nothing they have not done.
No, no, it is not our case, my lord. It has been done. My lord, now you, that
the
is,
Park and open spaces.
yes, yes,
Which were earlier marked.
yes, my lord.
If that is sought to be
Change it, my lord.
used for some other purpose,
Yes.
for parking
Yes, my lord.
and other things,
That I will,
you should be able to point out.
I'll point out. Now, my lord, may I request, my lord, page 35.
Yes.
That was the first one, page 35, 6.9. The RERA Act was enacted with the primary object of, lordship got it?
Yes.
Enacted with the primary objective of reforming real estate culture, including engaging in greater transparency, citizen-centric accountability, and financial discipline. It emphasized the consumer protection and attempts to bring out efficiency and transparency. My lord, on the RERA Act, my lord, the court goes into all those questions, and my lord relies upon the judgment of various courts. Now, my lord, section 4 of the RERA Act is looked into. Now, your lordship may kindly turn to 42, my lord. After the judgments, my lord, the discussions. 42.
Yes.
As per section 14(2) of the Act, the promoter is prohibited from making any other alterations or addition to the sanctioned layout plan and specifications of the building or common areas within the project without the previous written consent of at least 2/3 of the allottees, other than the promoter who had agreed to take apartment in such building. Section 89 of the Act also provides that Act shall have overriding effect notwithstanding anything inconsistent contained in any other law for time being in force. Thus, it can be seen that section 14(2) of the Act is a clear and categorical embargo on the promoter from making any additions or alterations to the project once agreements have been entered into with the prospective buyers without previous written consent at least of two-thirds of the allottees. My lord, again, my lord goes into the section and my lord. My lord, page 52, the findings. Page 51 onwards. On the page 51, 6.23, last para. 6.22, we have already extracted the definition of common area to include all the community and commercial facilities provided in the real estate project. Thereby, the entire building number 18 is a common area. It is pertinent to state here that the entire township is developed as a gated community and each building does not have any access road which is gifted to the local authority. On the contrary, promoter has undertaken upon itself to develop it as a complex with shared facilities and amenities. Therefore, even by going by the arguments of so and so, that each of the buildings should be considered as a separate phase by itself, and the clubhouse and commercial complex comprised in block building number 18 is a common area as it is represented as a club and commercial facility for the 7 buildings, which are originally termed as phase 2. Thus cannot be altered without the consent of 2/3 owners in respect of each of the 7 towns. It must be seen that very purpose of the act is to prevent the promoters from holding out one thing and thereafter carrying out another. Any purchaser of the apartment in all these 7 buildings of phase 2 agreed for a particular price, but taking into account the number of residential towers which are coming up within the gated community. If there are going to be more number of towers than the original one, which was promised, the entire land topography and occupancy changes. So, my lord, if I am not able to establish also that there is no changes, the court says, because in the first plan, X number of residents will come. In the change plan, more numbers of residents will come. Entire topography will changes. That is what is here. My lord, first I will, my lord, substantiate, my lord, as your lordship said. The price of the original apartment is agreed upon considering the original master plan, which is held out to the buyer. Thereafter, accepting the arguments of learned senior counsel for the third respondent, that an equivalent clubhouse area will be provided in another new building floor of the sports complex could defeat the very purpose of section 14 of the Act. From the wordings of section 14 of the Act, which is a non-obstantial clause, and section 89 of the Act, by which the provisions of the Act are override the other regulation, it could be clear that the second respondent cannot grant modification or revision of the building approval in violation of section 14 of the RERA Act. Rule so and so of the Act states that mere granting approval by itself not mean responsibility or clearance of the aspects of mentioned therein, but does not in any manner enable the second respondent to ignore the mandate of RERA Act and grant permission for illegal modifications, especially when the project is partly executed after registration with the RERA authority and buildings are allotted, sold, occupied by the parties. Therefore, we hold that the impugned planning approval granting modification without the consent of 2/3 of the members of the allottees of each of the 7 buildings in phase 2, to which the block in question is held out, is common area that is being community facility for clubhouse and commercial facility has illegal and is liable to be quashed. Then, my lord, they go into the question of the contract, my lord, which is entered into between the parties and why that contract could not be looked into. Because though the terms and conditions might be in favor of the promoters, why that cannot be looked into was also gone into. And my lord, the court has given a finding, my lord, that the plan has to be, which is modified, has to be quashed. Now, my lord, I will, my lord, point out what are the changes, my lord, in respect of 2011 plan and 2015 plan, my lord, has your lordships, my lord, directed. I will, my lord, point it out. My lord, let the BDA also come, my lord, forward and say whether the plan has now been again modified or not, or the developer himself, my lord, come out, my lord, and say whether the plan again has been modified or not. Hey, my lord, meanwhile, make one request, my lord. As far as this is concerned, my lord, as far as the plan is concerned, for quashing of the modified plan, I will, my lord, submit. As far as the CH-8s and parks are concerned, there is no dispute. Now they say parks, they're ready. Let them, my lord, at least BDA, my lord, take action, my lord, in accordance with law, if there are any illegal structures are there. If they say, my lord, there is some illegal structures, that can, my lord, looked into pending, my lord, disposal of this writ petition. Because, my lord, it is our endeavor to enjoy it, not, my lord, after 10 years.
The problem is that other person who has put up the construction,
yes, my lord,
he is not ready to remove it.
No, there is no other person. What they say now is, I have given a leave and license agreement to run a clubhouse in the civic community site. He has, my lord, utilized the park area. The license which is given is only for the clubhouse which is in the civic community side, but he has utilized the park area. Therefore, I am not liable. That is the stand of the developer.
What he has done in the park area?
My lord, he has, my lord, to run a bar and restaurant, put tables and utilizing it.
That can be removed.
That can be removed. There is no problem.
I
My
have
lord,
also made a statement, my
and
lord,
my
sub
lord, his
16
statement
for itself.
is, there is a commercial appeal, which a commercial case which is filed, and there is an injunction order. Injunction order is in respect of the civic community side, not in the area of the park. And my lord, he cannot enter or give a leave and license agreement in respect of the park area. Park area is with the BDA. He has no right if he has given so.
I
My
have
case
not
is,
given any
yeah, if
agreement
he is
with
not
respect
given,
to the park
if he
area.
has not given, well and good. We will leave it to that. He is not given. Now, my lord, if the injunction is in respect of a civic community side, that will not come in this court, my lord, directing the park area which is in the custody of the BDA. My lord, for them to take action in accordance with law, if something is there illegal.
I have no
And my
objection.
lord, then my lord, act according to 7.1 and 7.2 is my humble submission.
I have no
My lord, because,
objection
my lord,
for
there
the
are so
BDA to
many.
demolish that, my lords. I have absolutely no objection. My statement is also recorded on 16:4 before this honorable court.
No, that is why I wanted to point out. That person has got a order of injunction.
My lord, that is what I submitted, my lord. That is in respect of CS site where he has, my lord, the developer has given to run up a bar and restaurant. My lord, we will not go into that. As far as civic community also, my lord, I will say, my lord, let it be taken up later, my lord. As far as parks, let us at least enjoy. My lord, we have kids there. We are in an apartment. My lord, it is not a 3,000 square feet apartment. It's all 1,200, 1,500 square feet apartments, 2-bedroom apartments. My lord, if me and my family members or all the family members, kids are not permitted to enjoy the park, then, my lord, we are bound, my lord, in this 1,000 square feet house. Therefore, my lord, my humble request to your lordship is, at least, my lord, the park which has already been relinquished, let it be, my lord, handed over to the association as per 7.1 for maintenance purpose. As far as other issues are concerned, my lord, I will file an affidavit of that. This is my humble submission.
The other two towers, construction is complete.
No, my lords. Construction is yet to commence.
Only
Six
only
towers are
Six towers are
six towers are complete.
Huh?
6 towers are complete.
Huh.
4 associations are formed.
All the 6 towers are completed.
6 towers are complete.
And you have sold it also.
Yes.
We have sold it.
Then
2 other towers have to come up, my lords. This is a project where 8 towers are to be constructed.
8 towers.
8 towers.
Not in the first plan, second plan 8, first only 6A.
No, I'm asking only about the 19 acres and all.
19 acres, all the 6 towers.
Yes,
6
yes.
towers have
All 6 towers are constructed.
Yes, my lord.
Then what is the difficulty? Why are you saying that association has not been formed in 2 other?
In 2, they have not yet formed because the builder has to form it. He is not forming it. He is delaying it only for the purpose of not handing over this park in CSI.
There are residents.
Yes, they are residents. They are staying there. They are staying there. He has sent a mail. We will do it after 6 months. My lord, now what they say is 2 more towers have come because of the modification of the plan. Let these 2 towers also be constructed. Then we will hand it over.
We are not concerned with the other part, additional
Yes, ma'am.
area. We are only concerned with this 19 acres, 28 guntas.
Please.
If all the 6 towers are constructed and it is occupied, then in terms of the approval given by RERA, you will have to fulfill all the conditions.
Please.
Including formation of the association.
Please.
We are not going to wait for the.
But the apex body, my lords, the 6 association should form the
Yes,
apex.
We will do it.
You form the other 2 associations.
We
They
will do
will
it.
form the apex body.
Please.
We have no dispute to that.
Please take instructions.
Please.
The dispute is only in respect of the parks and the open spaces. And if you are intending to do something else, that will not be permissible.
I understand.
But in respect of joining the other area by making the road access as is shown in the earlier plan, and it will be a second phase. There can be no difference of opinion
The only
of complying with all the conditions that were imposed while the plan was sanctioned for the first phase. If this one is taken as a second phase, you do whatever you want there.
Please.
Then you take the approval of the associations and you can merge
fact,
them and you can have one apex body.
In fact, the size area of the park, my lords, has increased. Area of the park, my lords, has increased. Area of the civic
Oh,
community sites have also increased.
No, no. Simply by saying, see, now you are going to get additional area and therefore you are going to get more park, more open spaces. It may be so,
I understand.
but we are actually not concerned with that.
Please,
After completing all that project, the second phase, you may put a proposal to the apex body that now, since we have additional developed area, and if the two are merged, it will be in the best interest of the residents. And with their approval, you can go ahead.
please, I'll take
Don't
instruction.
do anything, try to modify anything in respect of the plan that was already sanctioned in the year 2011. That you can't do now.
Please,
Even if it is in respect of park and open spaces.
please.
Learned counsel for the petitioner submits on instructions that at the instance of the ninth respondent, the Bangalore Development Authority has approved a further modified plan. Full stop. Learned counsel for the eighth respondent and learned counsel for the respondent BDA are requested to secure instructions in this regard and make submissions. Full stop. If it is a fact that the further modification has been approved by BDA, copy of the same shall be placed before this court. Full stop. Next para. Learned counsel for the petitioner submits that similar grievance vented out at the hands of the Welfare Association, Residents Welfare Association at Chennai has been decided by the division bench of the Madras High Court in the case of Chennai Hiranandani Residents Welfare Association versus the Secretary, Housing and Urban Development Department, State of Tamil Nadu and others in writ appeal number 3328 of 2023, dated 8/4/2024. Full stop. You are given a copy?
I have given.
A copy of the same is served on the learned counsel for the ninth respondent. Full stop. Next para. The learned counsel for respondent number 9 is further requested to secure instructions with respect to the submissions made by the learned counsel for petitioner and clarify as to whether any change was proposed and approved in the original extent of 19 acres and 28 guntas, including the park and open spaces and civic community areas. Full stop. Next para. Release this matter on 26th of June.
I'll also, my lord.
Huh?
I'll also find out, my lord, what is the change.
Yes.
May request for 28th, my lord, subject to the convenience.
28th.
My lord, we have filed a report, my lord, the affidavit as directed by your lordships on the last occasion. Saying that, my lord, all the
Starting only, learned counsel for the petitioner submits that in terms of the directions issued by this court on 11/6/2024, an affidavit of the president of the petitioner association is filed along with a communication dated 16th of June 2024. Full stop. Learned Counsel submits that in terms of the communication in document number 1 filed along with the affidavit, the other 3 apartment owners association have given their consent in writing that all the 4 apartment owners association will take over the parks and open spaces.
Civic community.
Civic community ಬಗ್ಗೆ there is no relinquishment deed.
No relinquishment. For only maintenance. sir.
Only in terms of the provision.
Provision, yes.
We will consider.
Yes.
And they also state that they have no objection if the 2 other apartment owners association.
Yes, we have no objection.
That
Other-
also
yes.
they have stated.
Yes, yes.
Yes.
ಏನ್ ಹೇಳಿದೆ? Are willing to jointly take over maintenance of parks, common areas for amenities and civic communities. Full stop. The learned counsel would therefore submit that having regard to the relinquishment deed executed by the 9th respondent, handing over all the 5 parks to the Bangalore Development Authority, the Bangalore Development Authority should be directed to hand over parks to
For maintenance.
the associations
For maintenance.
for maintenance. Full stop.
One submission, my lords.
Area, my
My-
lord, there is a-
One submission, my lords. So far as the 5 parks now which they are referring here, it comes within the larger project area of 33 acres.
Can it be?
That, my lords, is the relinquishment deed, page number 318, annexure R.
How can you execute a relinquishment deed in respect of park which is not even found in the?
That is the rectification relinquishment deed, my lords, which is referred to as annexure R.
In the original 19 acres, 28 guntas.
Please, ma'am.
How many parks are there?
5 parks. Park of 5. The measurements are different.
Huh?
Measurements.
5 parks are there.
Measurements are different.
Measurements are varying, my lords.
Measurements are varying.
That, my lords, will get it at page
In the
320.
rectification deed itself, it is mentioned.
Huh?
In the rectification deed itself,
Hmm.
it is mentioned that the earlier areas which is there and now what is rectified, it is mentioned.
Earlier it was lesser.
It was a lesser extent, now it is a larger extent.
Because now 33 acres came now, my lord. Therefore, the CA site also has to, my lord, increase in the park size also.
Therefore, even if it is restricted
To the 19 acres park, yes.
the original relinquishment
Yes,
deed,
yes, ma'am.
you are happy.
Yes, ma'am, I am satisfied. I am
Yeah,
satisfied.
My lords, then, very well, I'll.
Perfect. Next para. However, learned counsel for the 9th respondent submits that the 5 parks which are handed over to the Bangalore Development Authority in terms of the rectified relinquishment deed would include the park and open spaces of the second phase of the development,
Total area.
which will now have a total extent of 33 acres.
33
and not,
acres,
19
29
acres and 28 guntas.
Yes.
Full stop. At this juncture, learned counsel for the petitioner would submit that the petitioner association and the other three associations will be satisfied
Yes,
if the park and open spaces as relinquished in the original relinquishment deed is handed over to the association for maintenance.
yes.
Learned counsel for the respondent, for respondent number 9 is directed to secure instructions and make submissions.
Please,
If you agree with for that one, the matter can be decided.
their basically their grievances to tower should not.
No, we will not. I will, my lord, convince, we will not.
Why unnecessarily
Yes,
want
we
to
will, yes.
Blow out the small requirement into a larger dispute?
If my lord park and civic community is given, handed over, I will, my lord, convince my clients, my lord, whether we will, my lord, withdraw.
In terms of the original relinquishment deed, if it is handed over, it is enough.
Please.
My lord, there is a further direction, my lord, which they have not, BBMP has not yet filed their report. There is already. But there is a direction for the BBMP to consider our representation and file a report before this court. There is a direction.
What is your?
My lord, our grievance was that there is illegal constructions, my lord, in the development which has taken place, and we had given a representation. This honorable court, my lord, in the first order, directed the BBMP, my lord, to consider the representation and file a report before this court.
Our unauthorized construction.
In the, my lord, in the plan which is sanctioned, illegal constructions have been made, not according to the plan. Therefore, my lord, we gave a, my lord, representation to the.
What type of illegal construction?
My lord, commercial complexes have come up. The community stores have come up, not in accordance with the plan.
Convenience
And
stores,
which
my lord,
convenience
are-
stores which is run by the builder at his fancy prices.
Convenience
So
stores,
therefore,
my
my
lord,
lord-
are shown in the plan.
There is a difference in saying illegal construction has come up and while saying the part of the building is used for purpose for which it was not sanctioned.
My lord, both are there.
There are two different things.
Yes.
I don't think they have put up any additional construction.
My lord, according to us, my lord, that is the complaint which was given to the BBMP. This court, my lord, therefore told them to file a report. Now let them file a report, my lord, has compliance with this direction issued by this court. I am not, my lord, trying to seek anything further. There is already a direction in this matter to file a report. Let them, my lord, file a report.
When was it directed?
My lord, the first order, my lord, cause list allo tosta ide, saying that report has not been filed anta.
Respond number 4,
Yes, my lord.
23-2.
23-24. That will help, my lord, for your lordships, my lord, to decide the case whether, my lord, that report has to be filed before this court, my lord, for the consideration of this court to. It is not to pass any order, my lord. The report to be filed before this court. That is all, my lord, is. Yes, you reject it. You file a report saying, my lord, they should, my lord, file a report or at least their objections.
Wants us to do investigation.
The BBMP, my lord, is a body which has to, my lord, look into the grievance. They cannot, my lord, collude with the developer and say, yes.
If you are able to point out from the representation.
Yes, my lord.
You have already given it.
Yes, my lord.
That this is the allegation that you have made, specific allegation. Then we can direct them. I don't find any such direction here.
I will, my lord, anyway, my lord,
Everything 23-2 only, I don't find such a direction.
pending further consideration, it is open for respondent number 2.
To consider the representation.
Consider the representation.
Report file ಮಾಡಿ ಅಂತ ಎಲ್ಲೂ ಇಲ್ಲ ಅಲ್ಲ.
If this such consideration, report to be filed, last line.
ಯಾವುದು?
ಅದೇ same order ಅಲ್ಲಿ, last line ಅಲ್ಲಿ, if there is such consideration, report to be filed.
There is such consideration.
Let them say, my lord, we are not considering. If that is their stand, let them say that, sir.
If you are able to point out from that
So
representative.
anyway, my lord, I will, my lord, point out in the affidavit now, which I will file, saying that what are this thing. I will point out that also, my lord, in the affidavit. My lord, in the page 61, my lord, we have said convenience stores has come up. That is a representation which has been given.
ಅದೇ ಹೇಳ್ತಾರೆ.
Is
See,
there?
please understand, you are not talking of additional illegal construction. By saying so, you are only saying a portion of the building which was supposed to be utilized for some other purpose is being now utilized for as a convenience store.
Yes, not only that, my lord, that's a 6-page representation with the entire details.
Problem ಏನಾಗುತ್ತೆ ಅಂತಂದ್ರೆ, if you go deeper and deeper into this one, this court has to say something regarding the zonal regulation itself.
My lord, that
There is no such provision in the act.
Yes,
which would enable the handing over of the civic community sites to the association. It is impermissible.
my lord, that is in respect of, my lord, plotted development.
Please show from section 17.
My lord, section 17 is, my lord, in respect of plotted development.
There is no other development that is permissible under the act.
Section 14 of the Town and Country Planning
Please
Act.
show.
That, under that, my lord, plan is been given.
Please show, sir.
I will, my lord, that also, my lord, I will also. 17, my lord, as for, I will also, my lord, I will look into it.
Very moment you say civic community, it should be available for the general public.
Yes, my lord. My lord, civic community, that is why, my lord, first I read rule 6.1, which is, my lord, in the revised master plan.
Zonal regulation ಎಲ್ಲ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. There is no such substantive provision under the act.
Correct, my lord. It is.
ಯಾರಾದ್ರೂ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರೆ,
Yes, my lord.
all these permissions given
Yes, ma'am.
will go.
Yes. Absolutely.
ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇರೋದು, if you go deeper and deeper, it will create more problems.
We are, my lord, we are not even bothered.
If they really wanted to make provision for gated community, appropriate amendment should have been brought to the provisions of the act. Madilla.
My lord, what your lordships are now trying to say is, my lord, is in respect of only plotted development, there is no concept of gated community.
Correct.
My lord, in respect of development rights where a plot, my lord, it is defined development rights which are given for a residential complex. My lord, that there is a concept of gated community. That is my lord, I will, my lord, by judgments which was challenged, division bench has held so. I will, my lord, produce that. Where, my lord, Justice Nagaratna, my lord, had passed the order when here, that was challenged, my lord, before a division bench.
A residential apartment complex.
Yes, my lord.
Is permissible.
Yes, ma'am.
There is no difficulty.
Yes, ma'am.
Alli, there is no concept of civic community sites at all.
Yes, my lord. In the town and country planning.
Understand?
Yes, ma'am. In the town and country planning.
So once you say
Yes.
civic community, parks, open spaces, then naturally section 17 will get attracted.
We'll have to try to convince your lordship that we come under section 14, not under section. I will have to try to convince your lordship that we can come under section 14, not under section 17, because section 17 is only. 14 ಅಲ್ಲಿ change of land use and development rights ಕೊಡೋಕೆ ಇದೆ. 14 ಅಲ್ಲೇ plan sanction ಮಾಡೋದು.
That has not got anything to do with the sanction of a development plan, sir.
My lord, subject to correction, my lord, I will just look into it, but section 14. Enforcement of master plan regulation.
ಅದು ಮಾಸ್ಟರ್ ಪ್ಲಾನ್ ಮಾಡೋದು.
My lord, clause 2 ಅಲ್ಲಿ no such change land use, no such change in land use or development.
You are reading 14A.
Allala, 14, not 14A. 14. Enforcement of master plan regulation clause 2.
Correct.
No such change in land use or development as is referred to in subsection 1 shall be made, except with the written permission of the planning authority, which shall be contained in the commencement certificate.
That has not got anything to do with approval of the plan.
My lord, approval of the plan.
No change will be permissible.
Yes, my lord.
From what has been designated in the master plan.
Or development. The word used is.
If a area is designated for a certain purpose.
Yes, ma'am.
It should be used only for that.
That is in respect of change of land use.
You are reading subsection 2.
Subsection 2, I am relying on, my lord, or next. No change of land use or development as is referred to in subsection shall be made except with the written permission of the planning authority. So, my lord, my.
It will give a right to the authority to do anything contrary to the.
Not contrary to the, now if the area is earmarked as.
17 says.
Yes, ma'am. Now you
all roads, parks, Open spaces, civic communities have to be relinquished.
My lord, section 17 deals with, the lordship may kindly turn to section 17.
Yes.
Sanction for single plot or subdivision.
Erduno.
Single plot or
Eradu
subdivision.
ide alli.
Oh, the sanction of single plot.
That is the provision for sanctioning.
I will-
Section
I will-
14 is not the provision for sanctioning.
I'll look into it. I'll look into it.
Section 17 is the only provision
Yes, ma'am.
which enables the planning authority to give its approval for
Yes.
formation of a layout, a larger layout or a single plot layout.
Yes, my lord.
Eradu include
If you
agide.
go by section 17, my lord, as your lordship says, my lord, then civic community cannot be.
14
and-
you don't find anything like, it's only regarding the implementation of the master plan.
Master-
Ashte.
Yes.
It is only section 17 which enables the planning authority to sanction the plans.
Yes.
Ali, there is no such provision.
Yes, ma'am. Adrallo, 17 was the civic community cannot be handed over to the
ಇಲ್ಲ.
association. It should go to the BDA,
ಹೌದು.
the planning authority should go to the.
Once my lord, the relinquishment is in favor of the state.
ಅದೇ
They cannot claim exclusive right, my lord, that will
ಅಲ್ಲ
defeat the
ಇವರೇ
purpose.
ಪ್ರಾವಿಷನ್ ಮಾಡಿದಾರಲ್ಲ.
ಮಾಡಿದಾರಲ್ಲ ರಿವೈಸ್ ಮಾಸ್ಟರ್ ಪ್ಲಾನ್ ಅಲ್ಲಿ. ಫಸ್ಟ್
They are
ಅಬ್ಜೆಕ್ಷನ್
trying
ಆಗಿ
to
ಆಮೇಲೆ
make a
ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ.
small deviation. ಅದನ್ನೇ ಹೇಳಿದ್ದು ಯಾರಾದ್ರೂ ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರೆ ಹೋಗ್ಬಿಡುತ್ತೆ.
There is a bar and restaurant which he does not want. He wants me to close it. How can I do it?
If it is in the residential area, it is his duty. If it is in the residential area, ಮನೆ ಪಕ್ಕದಲ್ಲಿ ಬಾರ್ ಅಂಡ್ ರೆಸ್ಟೋರೆಂಟ್ ಮಾಡಿದ್ರೆ can it be, is it permissible? Let him, my lord, file something in writing. Let him not, my lord, submit here.
Highly appreciate you know what is sort of page number 54 and 55. Can I, my lord, going to all this? He says, please, my lord, that the first thing is, my lord, that he wants me to hand over the park and open space. It is the duty of the BDA. I cannot do all that.
No. Park and open spaces was actually required to be handed over to you,
Please,
not BDA.
BDA is not having.
BDA ಗೆ only civic community sites, provision section 17 ನೋಡಿದ್ರೆ. ಇವರು ಝೋನಲ್ ರೆಗ್ಯುಲೇಷನ್ ಅಲ್ಲಿ ಸ್ವಲ್ಪ ಏನೋ
Yes,
ಚೇಂಜ್
ಮಾಡಿದ್ದಾರೆ.
ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಅಷ್ಟೇ.
He wants me to recover some membership fees paid to somebody else. Can I do it?
Let us see. If there is any violation of the plan,
But
You-
I will file.
ಅದೇನಾದ್ರು
a
ಇದ್ರೆ ನೋಡಿ,
report.
please, if it is something.
Yes, what is our
please
request?
point
That
out.
is all.
All right. Yes.
Sorry.
Sorry. Sir, ಪಾಸ್ವರ್ಡ್ ಆಗಿದೆಯಾ? ಸರ್, ಪಾಸ್ವರ್ಡ್ ಮಾಡಿದ್ರೆ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತಲ್ಲ ಮಧ್ಯಾಹ್ನ?
State government arbitrator ಫೈಲ್ ಮಾಡಕ್ಕಾಗಲ್ಲ ಅನ್ನೋ state government employees. State government state ಇಂದ ಯಾರಾದ್ರೂ ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ಇರ್ತಾರಲ್ಲ ಅವ್ರನ್ನ ಮಾಡಕ್ಕಾಗಲ್ಲ ಅನ್ನೋದಕ್ಕೆ
ಈ 7th schedule arbitration cancellation of. No, sir, ಗೊತ್ತಿದೆ sir. ಹೋಗಿರೋದಿಲ್ಲ. ಇಲ್ಲ
ನಿನ್ನೆ ರಾಶಿ ಆಯ್ತು ಅಂತಿದ್ರು. ಆ ಕಡೆಯಿಂದ ಹೊರತಾಗಿ ಕೇಳ್ಸಲ್ಲ. ಬೆಳಿಗ್ಗೆ ಕೊಟ್ಟಿದ್ದೆ.
ಯಾವುದಿಲ್ಲ.
ಅದು ಹಾಕಿದ್ದೀನಿ ಅದೇ ಹಂಗೆ ಬರ್ಬೇಕು ನೋಡಿ DNP ಯಾರು ಹೇಳಿಲ್ಲ ಸುಮ್ಮನೆ ಇದು ಇದನ್ನು ಅಷ್ಟೇ LB ಮೂಡ ಹಾಕಿ ಅವತ್ತಿಂದೆ ಅನ್ಸುತ್ತೆ ಇದು 21ನೇ ತಾರೀಕು ಇದು ಸಪರೇಟ್ ಆಗುತ್ತೆ ಬರೀ CS ಮತ್ತೆ CS ಎಲೆಕ್ಷನ್ ಮಾಡ್ತಿದ್ವಲ್ಲ ಅವತ್ತಿಂದನೇ ಬೇರೆ ಎಲೆಕ್ಷನ್ ತೊಂದರೆ ಇದು ನೋಡಿ ನಂಬರ್ ಏನಿದೆ WP 14271 of 14271 of 24 ಮೂಡಲ್ಲ ಅಡ್ಜರ್ನ್ ಆಗಿದೆ ಅಲ್ಲ ಅಡ್ಜರ್ನ್
14/6 ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ ಬರ್ದಿರ್ತೀವಿ
ಅದೇ ಇರ್ಬೇಕು ಅನ್ಸುತ್ತೆ ಈ ನಂಬರ್ ಇರ್ಬೇಕು ಬೇಡ ಪ್ಲೀಸ್ ಇದು ಇನ್ನೊಂದು ಹೇಳೋದಲ್ಲ ಅದು ಯಾವ್ದು 29A ಏನಾದ್ರು ಮೊನ್ನೆ ಒಂದಾಯ್ತದು DNP ಡಿಸ್ಮಿಸ್ ವಿಡ್ರಾಲ್ ಮಾಡ್ಕೊಂಡ್ರು ಇನ್ನೊಂದಾಗಿದೆ ಅದು ಅದಾಗಿದೆ ಯಾರಿಗಿದೆ ನೋಡಿ ನಂಬರ್ ಹೇಳಿ ಅದು ಹಳೇದಲ್ಲ ಹೊಸದೇ DL ಆಗಿದ್ದು ಅದು ಡಿಸ್ಮಿಸಲ್ ವಿಡ್ರಾಲ್ 29C ಆಗಿದ್ದು ಅದು ವಿಡ್ರಾಲ್ ಅದು ಹಿಂದಿಂದ ಒಂದು ಆರ್ಡರ್ ಆಗಿದೆ ಅದು ನೋಡಿ ಅದು ಇನ್ನೊಂದು 29C CMP ಸರ್ಚ್ ಮಾಡಿ ಅದನ್ನ ಹಾಕಿಟ್ಟು ಬರೋದು CMP ಮ್ಯಾಟ್ರಿಕ್ಸ್
ಹಂಗ್ ಸರ್ಚ್ ಮಾಡಿ ಕೂಡ ಸಿಕ್ಬಿಡುತ್ತೆ ಇದು ನಾನು ಬರ್ಕೊಂಡಿದ್ದೀನಿ ಸಿಕ್ತು ಅಷ್ಟೇ ಹಂಗೆಲ್ಲ ಸರ್ಚ್ ಮಾಡಿ ಸಿಗೋದಾಗ ಎಲ್ಲ ಹುಡುಕರು ಕೊಡ್ತಾ ಇದ್ದಾರೆ ಯಾರಿಗಾಗಿದೆ ಏನು ಅಂತ ಗೊತ್ತಿಲ್ಲ 125 126 ಎರಡು ನಂಬರ್ ಕೊಟ್ಟು ಕಳಿಸ್ತೀನಿ ನಾನು ಅವ್ರಿಗೆ ನೋಡಿ ಡಿಸ್ಮಿಸ್ ಆಗಿರೋದಲ್ಲ ಡಿಸ್ಮಿಸ್ ಹೌದು ಡಿಸ್ಮಿಸ್ ಆಗಿರೋದೆ ಅದೆಲ್ಲ ಡಿಸ್ಮಿಸ್ ಆಗೋದೇ ಇಲ್ಲ
ವಿಡ್ರಾ ಮಾಡ್ಕೊಂಡ್ರಲ್ವಾ ಇದು ಮೊನ್ನೆ ವಿಡ್ರಾ
125 ಎಲ್ಲಿ ವಿಡ್ರಾ ಮಾಡ್ತಿದ್ದಾರೆ ಯಾವ್ದೋ ಡೇಟ್ ಕೊಟ್ಟನಪ್ಪ ಅವ್ರಿಗೆ ಡಿಸ್ಮಿಸ್ ಆಗಿ ವಿಡ್ರಾ
ನೆನ್ನೆನೇ ಇದ್ದಿದ್ದು
ನೆನ್ನೆ ಅಲ್ಲ ಬಿಡಿ
CMP 73 ಇನ್ನು ನೀವು ಯಾವ ಕೊಟ್ಟಿದ್ದೆ ನಂಬರ್ ಯಾವ್ದಾದ್ರೆ
125 ಕೊಟ್ಟೆ ನಾನು 12/6
ಯಾವ್ದು
12/6
ಗಿತ್ತಾ
125 ನಾನು ಕೊಟ್ಟಿದ್ದೆ
ಅದು ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ಟೈಮ್ ಫಾರ್ 1 year ಟು ಅಪಾಯಿಂಟ್ ಆರ್ಬಿಟ್ರೇಟರ್
ಅದೇನೆ
ಅಂಡರ್ ಸೆಕ್ಷನ್
ಮಾಡಕ್ ಬರಲ್ಲ ಅಂತ ಹೇಳಿ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ವಾ
ಅಂಡರ್ ಸೆಕ್ಷನ್ ಏನದ
29A
ಅದೇ ಬಿಡಿ
ಅದು ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ
ಡಿಸ್ಪೋಸ್ಡ್ ಆಫ್
ಮಾಡುತ್ತಾ
DL ಗೆ ಅದೇ ಮ್ಯಾಟರ್ ರೈಟ್ ಸೇಮ್ ಮ್ಯಾಟರ್
ಡಿಸ್ಮಿಸ್ ಡಿಸ್ಪೋಸ್ ಆಫ್
ಡಿಸ್ಮಿಸ್ಡ್ ಅಲ್ವಾ
ಎರಡು ಡಿಸ್ಮಿಸ್ 125 150 ನಾನು ತಗೊಂಡಿದ್ದು ವಿಡ್ರಾಯಲ್ ಅಲ್ಲ
ವಿಡ್ರಾಲ್ ನೆನ್ನೆ ಆಗಿದೆ
ನಿನ್ನೆ ಯಾವ್ದು
ನೆನ್ನೆ ಒಂದು CMP 73/24 ಸೇಮ್ ಮೇಂಟೆನೆನ್ಸ್ SLP ಸೇಮ್
73 ಡಿಸ್ಪೋಸ್ ಆಫ್ ಮಾಡಿದ್ದಾರೆ
ಮೆಮೊ ಫೈಲ್ ಮಾಡಿದ್ರಲ್ಲ
ವಿಡ್ರಾಯಲ್ ಆಗಿಲ್ಲ
ಮೆಮೊ ಫೈಲ್ ಮಾಡಿದ್ವಿ
ಅದೇ 29A ಮೇಲೆ ನಾವು ಅಲ್ಲಿ ಹೋಗ್ತೀವಿ ಅಂತ ಹೇಳಿ ಮೆಮೊ ಫೈಲ್ ಮಾಡಿದ್ರು ಅದಕ್ಕೆ ವಿಡ್ರಾ ಆಗಿಲ್ಲ ಅದನ್ನು ವಿಡ್ರಾ ಆಗಿಲ್ಲ 73 ಕೊಟ್ಟಿಲ್ಲ 125 126 ಅದಕ್ಕೂ ಇನ್ನೇ ಸ್ಟಾರ್ಟಿಂಗ್ ಅಲ್ಲಿ ಒಂದು ಮಾಡಿದ್ರು ಅದೆಲ್ಲ ಫ್ಯಾಕ್ಟ್ಸ್ ಎಲ್ಲ ಹಾಕಿದ್ದಾರೆ ಪೂರ್ತಿ ಫ್ಯಾಕ್ಟ್ಸ್ ಏನೇನು ಹಾಕಿದ್ದಾರೆ ಹಳೇದು ಅದಕ್ಕಿನ್ನ ಹಳೇದೊಂದು ಫುಲ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಮೇಡಮ್ ಏನೋ ಇಲ್ಲಿ ಬರ್ತಾ ಇದ್ದೀರಾ ಹೋಗಿ ಅಲ್ಲ ಹಿಂಗಿಂದ ಹಿಂಗ್ ಬಂದ್ರಲ್ವಾ ಅದಕ್ಕೆ ಈ ಕಡೆ ಎಲ್ಲ ಬರ್ತದೆ ಕೊನೆಗೂ ಹತ್ತದ್ರ ನೋಡಿ ಮುಂದಕ್ಕೆ ಬಂದ್ಬಿಟ್ಟಿದೆ ಮುಂದಕ್ಕೆ ಬಂದ್ಬಿಟ್ರೆ ಅವರು ಹಿಂಗ್ ಹೋಗ್ಬಿಟ್ಟಿದೆ
ಬೆಳಿಗ್ಗೆ ಬರ್ಬೇಕಾದ್ರೆ ಅಡ್ಡ ಆಯ್ತು ನಾಳೆ ಹಿಂದಿನ ಸರಿ ಮುದ್ದೆ ತಂದ್ಬಿಡ್ತೀರಾ ವೆರಿ ಗುಡ್.
ತಟ್ಟೆ ಪಟ್ಟೆ ಏನ್ ಬೇಡ್ವಾ?
ನಾವು 3 ಜನ ಇರ್ತೀವಿ. 3 ಜನಕ್ಕೂ ಹಂಗೆ ಅಷ್ಟೇ ಕಟ್ಕೊಂಡ್ಬರ್ತೀವಿ.
3 ಜನಕ್ಕೆ 3 ಮುದ್ದೆ ಕಟ್ಬೇಕಾ? ಅದನ್ನ ಹೇಗೆ ಮಾಡ್ಬೋದಾ?
ಕೆಲಸ ಈಸಿ, ಅದು ಇಟ್ಬಿಟ್ರೆ ನೀರ್ ಕುದಿಯುತ್ತೆ, ಇಟ್ಟ ಒಂದ್ ಸ್ವಲ್ಪ ಹೊತ್ಬಿಟ್ಟು ಬೇರೆ ಏನಾದ್ರು ಬಾಕ್ಸಿ ಕಟ್ಟೋದು ಏನಾದ್ರು ಈಸಿ ಅಂತ ಅಲ್ಲ, ಕೆಲವು ಸತಿ ಬೋರ್ ಹೊಡೆದ್ರೆ ಕೇಳ್ದೆ ಮನೇಲಿ ನಂಗೆ ತಿಂಡಿ ಬೇಡ ಹೊಟ್ಟೆ ಸರಿ. ಇನ್ ನಮ್ಮ ಮಗಳು
ನಿಮ್ಮಂದು ಹೊಟ್ಟೆ ಸರಿ ಇರಲ್ಲ.
ನೆನ್ನೆ ನಾನ್ ವೆಜ್ ಮುಗಿರ್ತವಲ್ಲ ಅವಾಗೆಲ್ಲ ಬೇಡ ಸರಿ. ಆ ಚಿಕ್ಕವಳು
ಅಂದ್ರೆ ಏನು ತಿನ್ನೋದೇ ಇಲ್ವಾ? ಖಾಲಿ ಹೊಟ್ಟೆ ಇರ್ತಾರ?
ಏನು ಕಾಫಿ ಬಿಸ್ಕೆಟ್ ಅದ್ರಲ್ಲೇ. ಚಿಕ್ಕವಳನ್ನ ಕೇಳಿದೆ, ಅವಳು ನಂಗೇನು ಬೇಡ, ತಿಂಡಿನೇ ಬೇಡ, ಹೊಟ್ಟೆ ಬ್ರಂಚು ಹೆಂಗಾದ್ರು ಆಡೋದು ನನ್ಗೊಬ್ಳಿಗ್ ಮಾಡ್ಬೋದು ಅದಕ್ಕೆ.
ಈಗ ಪಾಲಿನ ಹೋಯ್ತು ಈಗ ಡೇಟ್ ಮುಗೀತಾ?
ಇವತ್ ಬರ್ಬೇಕು ವಾಪಸ್. ನಾನು ಇವತ್ ಬರ್ಬೇಕಿತ್ತು. ಬೆಳಗ್ಗೆ ಎದ್ದಾಗ ಅದೇ ಮಾಡ್ಕೊಂಡೆ, ಇವತ್ ಬಂದು ನಾಳಿದ್ದು ಆಫೀಸಿಗೆ ಬರ್ಬೇಕಾಗಿತ್ತು.
ಈ ದುಡ್ಡು ಹೋಯ್ತಾ?
ಇದು ಇಲ್ಲ, ಇದು ಬಂದಿದೆ 60% ಬಂದಿದೆ.
ಆದ್ರೂ ಹೋಯ್ತಲ್ಲ.
ವೆಕೇಶನ್ ಇಲ್ಲ, ಪರ್ಮಿಟೆಡ್ ಎಲ್ಲ ಆಗಿದೆ. ಸ್ಟಾಂಪಿಂಗ್ ಅಂತ ಬಂದಿಲ್ಲ, ವೀಸಾ ಆಗಿದೆ, ಸ್ಟಾಂಪ್ ಆಗಿ ಬರುತ್ತೆ. ಪಾಸ್ಪೋರ್ಟ್ ಮೇಲೆ ಒಂದು ಸ್ಟಾಂಪ್ ಆಗುತ್ತೆ, ನಾವು ಕೆನಡಾ ಹೋಗ್ತಾ ಇದೀವಿ ಅಂತ. ಅದು ಬರ್ಲಿಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಇನ್ನೊಂದು ಕಂಟ್ರಿ ಹೋಗುತ್ತೆ, ಡೆಲ್ಲಿಯಲ್ಲಿ ಅಂತ ಇದ್ರದ್ದು ಆಫೀಸು, ಅಲ್ಲಿಗೆ ಹೋಗಿ ಬರ್ಲಿಲ್ಲ. ರೀಸನ್ ಯಾಕೆ ಅಂತಂದ್ರೆ ಮಕ್ಕಳೆಲ್ಲ ಇವಾಗ ಅಡ್ಮಿಷನ್ ಅಂತವ್ರದೆಲ್ಲ ವಾಪಸ್ ಕಳಿಸ್ತಾರೆ ವೀಸಾ, ನಾನು ಬರ್ಲಿಲ್ಲ.
ಅವ್ರು ಕೊಡ್ಬೇಕಾ ವೀಸಾ? ಕೆನಡಾ ಅವರಲ್ಲ ಕೊಡೋದು ವೀಸಾ?
ಕೆನಡಾ ಇದು ಎಂಬಸಿ ಒಂದು ಆಫೀಸ್ ಇರುತ್ತೆ, ಡೆಲ್ಲಿಯಲ್ಲಿ ಇದೆ, ಬೆಂಗಳೂರಲ್ಲಿ ಇದೆ, ಚೆನ್ನೈಯಲ್ಲಿ US ಇದೆ, ಕೆನಡಾ ಅಲ್ಲಿಗೆ ಹೋಗಿ ಬರುತ್ತೆ.
ಇಲ್ಲಿ ಪರ್ಮಿಟ್ ಮಾಡಿಲ್ಲ ಡೆಲ್ಲಿಯಲ್ಲಿ. ಅವ್ರು ಕೊಟ್ಮೇಲೆ ನೀವು ಹೋಗ್ಬೋದಾ? ಏನ್ ಕಂಡೀಷನ್ ಗ್ರೌಂಡ್ಸ್ ಮೇಲೆ?
ಕಂಡೀಷನ್ ಏನು ಇಲ್ಲ,
ಮತ್ತೆ ಯಾರು ಬೇಕಾದ್ರೂ ಹೋಗ್ಬೋದಲ್ಲ, ವೀಸಾ ಕೊಟ್ಮೇಲೆ ಹೋಗ್ಬೋದು.
ವೀಸಾ ಆಗಿದೆ, ಸ್ಟಾಂಪ್ ಆಗ್ಬೇಕು. ವೀಸಾ ಅಂತಂದ್ರೆ ಯಾವ ಕಂಟ್ರಿಗೆ ಬೇಕಾದ್ರೂ ಹೋಗ್ಬೋದಲ್ಲ ವೀಸಾ.
ಓಕೆ,
ಕೆನಡಾಗೆ ಹೋಗ್ತಾ ಇದೀನಿ ಅಂತ ಅನ್ನೋದಕ್ಕೆ ಪಾಸ್ಪೋರ್ಟ್ ಅಲ್ಲಿ ಒಂದು ಸ್ಟಾಂಪ್
ವೀಸಾ ನೀವು ಹೋಗ್ಬೇಕಂದ್ರೆ ಆ ಕಂಟ್ರಿದ್ದೇ ಹೇಳ್ಕೊಡ್ಬೇಕು. ನೀವು ಏನು ಟೂರಿಸ್ಟ್ ಆಗಿ ಹೋದ್ರೆ ಏನು ಪ್ರಾಬ್ಲಮ್ ಇಲ್ಲ, ನೀವು ರೆಸಿಡೆಂಟ್ ಆಗಿ ಸ್ವಲ್ಪ.
ನಾನ್ ಯಾಕೆ ರೆಸಿಡೆಂಟ್ ಆಗಿ ಹೋಗ್ಲಿ?
ಟೂರಿಸ್ಟಾ?
ವಿಸಿಟರ್.
ವಿಸಿಟರ್ ಎಷ್ಟು ದಿನಕ್ಕೆ?
ಪಾಸ್ಪೋರ್ಟ್ ಇರೋರು.
ಅದಕ್ಕೆ ಆ ಪರ್ಟಿಕ್ಯುಲರ್ ಕಂಟ್ರಿ ಒಂದೇ ಇರೋದ್ರಿಂದ ನೀವು ಆ ಕಂಟ್ರಿ ಅವ್ರು ಕೊಟ್ಟು ಅವ್ರ ಕಂಟ್ರಿ ಕೊಡ್ತಾರೆ ನಿಮ್ಗೆ.
ಸ್ಟಾಂಪಿಂಗ್ ಏನೇ ಆಗ್ಲಿ ಸ್ಟಾಂಪ್ ಆಗಿ ಬರ್ಬೇಕು. ಸ್ಟಾಂಪಿಂಗ್ ಅಲ್ಲಿ ಬರ್ಲಿಲ್ಲ,
ಈಗ
ಬಂದಿಲ್ಲ, ಇವತ್ತು ಬಂದಿಲ್ಲ.
ಈಗ ಹಿಂಗ್ ಬಂದ್ರೆ
ಹಿಂಗ್ ಬಂದ್ರೆ ನಾವು ಹೊಸ ಪರ್ಮಿಷನ್. ನಾನು ಅವಾಗ ವೆಕೇಶನ್ ರಜಕ್ಕೆಲ್ಲ ತೊಂದರೆ ಆಗಲ್ಲ ಹಿಂಗ್ ಅನ್ಕೊಂಡಿರೋ ಪ್ಲಾನ್ ಮಾಡ್ತಾರೆ.
ಇನ್ನೂ ಬಂದ್ರು ಹೋಗ್ಬೋದಾ?
ಇನ್ಮೇಲೆ ಬಂದ್ರು ಅಂದ್ರೆ ಇಲ್ಲಿ ಮತ್ತೆ ಆಫೀಸರ್ ಪರ್ಮಿಟ್
ಅಲ್ಲ, ಹೋಗ್ದೇನೋ ಇರ್ಬೋದು.
ನಮ್ ಇಷ್ಟ.
ಆಫೀಸರ್ ಪರ್ಮಿಷನ್ ಕೊಡೋದು
ಅದಾಗಿತ್ತು,
ಎಲ್ಲ ತಗೊಂಡಿದ್ರಾ?
ಎಲ್ಲ ಆಗಿತ್ತು, ರಜಾ ಗ್ರಾಂಟ್ ಆಗಿತ್ತು ಎಲ್ಲ.
ರಜಾ ಹಾಕೊಂಡು
ಇಲ್ಲ ಹಾಕ್ಲಿಲ್ಲ, ರಜಾ ಹಾಕಂಗಿಲ್ಲ. ಅಯ್ಯೋ ಇದು ಕೊಡ್ಬೇಕು, ಏನು ಬೋರ್ಡಿಂಗ್ ಪಾಸ್ ಕೊಡ್ಬೇಕು, ಅವೆಲ್ಲ ಇದೆ, ಸುಮ್ನೆ ಅಲ್ಲ. ನಮ್ಮ ಆಫೀಸ್ ಅವ್ರು ಎಲ್ಲ ಜುಟ್ಟು ಹಿಡಿತಾರೆ ಚೆನ್ನಾಗಿ.
ಊಟ ಕೈ ಹಾಕ್ತಿದ್ರೆ ನಾನು
ಇಲ್ಲ ಇರ್ಲಿ.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 16 ಏನಾಯ್ತು ಮೇಡಮ್? ಅಡ್ಮಿಷನ್ ಫಸ್ಟ್ ಮ್ಯಾಟ್ರ್ ಕೇಳಿ ಮೇಡಮ್. ಕೋರ್ಟ್ ಆಫೀಸರ್ ಎಷ್ಟಿದ್ರೆ
My lord, I appear for
Yes, madam.
respondent number 2 in this matter, my lord.
Huh? Yes, madam.
My lord, I appear for respondent number 2 in this matter, my lord. Other connected 3 matters also. There are another 3 connected matters are there in this matter, my lord.
Between the same parties.
No, there are, Paramount has filed several other cases, different facts,
Arising out of different.
different contracts. Yes,
Arising out of different.
different
contracts.
contracts, not with this contract.
Yes, any other submission you want to make? Morning you sought for a
My lord,
Passover.
he is on the way. My lord is in the downstairs, my lord. In another 5 minutes, my senior will come. Thank you.
Another 5 minutes, maybe colleague.
You'll be coming to the court?
Yes, my lord. Yes, my lord.
Let him come then.
Please.
Pandrala.
Please.
Yes. Any objection?
Yes, my lord.
Yes.
I filed my objections also, my lord.
Yes.
As per the Supreme Court order, my lord, they cannot seek for appointment of arbitrator, my lord. There is a GCC. Under that GCC, one moment, my lord.
The Act for Arbitration.
Copy. Judgment copy.
Yes.
My lord, as per clause 64 of the general conditions of the contract, my lord, the demand for arbitration is to be made by the contractor, my lord. So as per the clause 64, 3 subclass A, my lord, the arbitral tribunal shall consist of a panel of 3 gazetted railway officers, my lord. My lord, in the judgment para number 38, my lord, page 31, my lord. There is an express provision in the modified clauses of GCC as per clauses 64.3A2 and 64.3B. The arbitral tribunal shall consist of a panel of 3 gazetted railway officers and 3 retired officers, retired not below the rank of senior administrative grade officers. When the agreement specifically provides for appointment of arbitral tribunal consisting of 3 arbitrators from out of the panel serving or retired railway officers, the appointment of the arbiters should be in terms of the agreement as agreed by the parties. That being the conditions in the agreement between the parties and the general conditions of the contract, the High Court was not justified in appointing an independent sole arbitrator. So, my lord, the application of the petitioner is to seeking appointment of sole arbitrator, my lord. But in the contract signed between the railways and the contractor, clearly specify that there should be a panel. Appointment of sole arbitrator cannot be made, my lord.
There is a subsequent judgment of the Honorable Supreme Court having regard to the amendment brought to section 12 and the introduction of the 7th schedule
Please, my lord.
to the Arbitration Act.
Please.
None of the retired employees or serving employees of the respondent can be appointed as an arbitrator. That is the judgment. So you have to appoint an independent arbitrator only. That is the position now. See, I have held in Globe Asia Pacific Limited versus Union of India, 2023, 8 SCC. Please note down. Page 226. Having regard to insertion of Schedule A and the amendment brought to the provisions contained in Section 12, it was held that the principles of impartiality and independence cannot be discarded at any stage of the proceedings. Specifically, at the stage of constitution of the arbitral tribunal, it would be incongruous to say that party autonomy can be exercised in complete disregard of these principles, even if the same has been agreed prior to the disputes having arisen between the parties. Further, having regard to the express provisions now contained in subsection 5 of section 12, that notwithstanding any prior agreement to the contrary, any person whose relationship with the parties or counsel or the subject matter of the dispute falls under any of the categories specified in the 7th schedule shall be ineligible to be appointed as an arbitrator. This is the position.
My lord, here, my lord, the petitioner is not seeking fresh appointment, my lord.
No, even if he is seeking, it will not be permissible. Because they have to file an affidavit. Whoever is acting as an arbitrator has to file an affidavit.
Please, ma'am.
And they have to say,
They are
I
impartial.
am not in any way related to the parties
No, that
or
is-
the council.
It is mandatory.
So the moment they say, I was an employee of this
Railway.
party, the vigors of Schedule 7 will get attracted. That is the position. This amendment was brought in the year 2015.
Please, my lord. But in this case, my lord, already an arbitral tribunal was appointed. It was
It's
constituted.
not permissible, sir.
Please, my lord.
Because what is most important is impartiality.
My lord, but they had filed the claim petition and already it was in progress.
Even if it is a fact that the arbitrators may not be partial to one side, but the law now requires that no such person will be appointed as an arbitrator. That is the law. Berkeley. First paragraph hakunde, second paragraph. In the memorandum of writ petition, it is stated that a claim was raised at the hands of the petitioner in terms of letter dated 24/12/2017. Full stop. By another representation dated 19/5/2018, the petitioner sought appointment of a sole arbitrator other than any person employed in the railways full stop. After enormous delay, the first respondent, general manager, Southwestern Railways, responded on 19/6/2019. Calling upon the petitioner to go for conciliation in terms of the arbitral clause. Full stop. The petitioner responded by stating that conciliation after lapse of 2 years may not be feasible, and therefore once again requested for appointment of a sole arbitrator. Full stop. Nevertheless, respondent number 1 gave a written communication on 15/11/2019 nominating 4 retired officers for constitution of the arbitral tribunal and called upon the petitioner to suggest 2 names out of the 4. Full stop. The petitioner suggested only one name, one person out of the 4. And the first respondent once again called upon the petitioner to suggest another name. Full stop. The petitioner, under protest, suggested another name by communication dated 22/1/2020. Full stop. It is contended that the first respondent disregarded the request made by the petitioner to appoint a sole arbitrator and proceeded to constitute an arbitral tribunal consisting of 3 members. Full stop. The presiding arbitrator sent instructions to the parties for conducting the arbitration, in terms of communication dated 14/5/2020. Full stop. The petitioner gave a written reply on 29/5/2020, refusing to accept the appointment of the arbitral tribunal consisting of 3 members and requested for appointment of a sole arbitrator. Full stop. Next para, to cut short the facts, it is clear from the memorandum of writ petition that the petitioner did not accept the arbitral tribunal constituted by the first respondent, and the petitioner is before this court seeking appointment of a sole arbitrator. Full stop. Next para. Learned counsel for the respondent railways would submit that having regard to clause 17(1) of the contract, provision is made for appointment of a gazetted railway officer and therefore even if this court were to appoint a sole arbitrator, it should be one of the gazetted railway officers. Full stop. Next para. in a recent decision of this court in the case of Surya Wires Private Limited versus Karnataka State Rural Livelihood Promotion Society in civil miscellaneous petition number 367 of 2023 dated 7th of June 2024. This court has held as under paragraph number 4 extract note. Para 5 ಅಲ್ಲಿ ರಿಪೀಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. A guested officer of the railways cannot be appointed as an arbitrator in view of the admitted relationship of employer and employee between the said officers and the respondent railways. Full stop. Para 6. Adunna hakombi. What is the claim amount?
Around 1 crore.
1 crore. So we'll appoint a former judge of this court. We'll appoint Justice P. Vishwanath Shetty. Huh?
Please.
Yes. Yes.
My lord, some connected matters are there, my lord.
Huh?
Same parties, some connected matters are there, CMP.
Please give the
262.
we will have it listed the day after tomorrow.
Please.
ನಾಳೆ ಲಿಸ್ಟ್ ಮಾಡ್ಸೇವು. Yes.
Serial number 25, K.V. Narasimhan. 25.
For petitioner, madam.
Appear for the respondent in the connected. Appear for the respondent.
Yes.
My lord, here is a case where in a small site of 30/40 divided by 2, that is 15/40, a construction was started and a neighbor complained that on the left side of the property, there is no setback left. So construction should be stopped and there is an order of stay for further construction. I would like to make a submission that first of all, on the left side of the property.
Have you got a sanction plan?
No, madam. I have, that is exactly the reason. This matter was heard earlier and referring to bylaw number 7.2 of the Bangalore building bylaws. My lord, which says that if a site of a particular measurement, the plan is.
Karnataka Municipal Corporations Act ಅಲ್ಲಿ bylaws ಒಂದಿದೆ ನೋಡಿ ಲಾಸ್ಟ್.
ಅಲ್ಲ ಬ್ಯಾಂಗ್ಳೂರ್ ಬೃಹತ್ ಬ್ಯಾಂಗ್ಳೂರ್ ಮಾಲಿಕ.
ಅದೇ ಈ ಬುಕ್ ಅಲ್ಲಿ ಇಲ್ಲ, ಅದ್ರಲ್ಲಿದೆ PBMP ಆಕ್ಟ್ ಅಲ್ಲಿ.
I have a copy. Yes, sir.
ಕೊಡಿ. Yes.
7.2 may kindly be seen. That 7.2, that no sanction plan, it starts with the is required.
No plan shall be sanctioned. for a residential detached building
Yes,
on a plot measuring less than 50 square meters
square meters.
or having width less than
Width.
6 meters.
Yes.
In
Here is a,
specific cases of sites for housing schemes of EWS, LIG, slum clearance and improvement schemes, as well as reconstruction in case of densely populated areas, the plot subdivided due to family partitions, the authority may relax the above conditions.
yes.
Andre-
Therefore,
Andre,
yes, ma'am.
this would mean normally plans will not be sanctioned. If you submit a plan for a land which is less than 50 square meters
Yes,
or having a width of less than 6 meters,
less than 6.
plan will not be sanctioned. Relaxation is given in certain cases, which means you have to still apply.
My lord, there is an
There is
application.
no, sir, there cannot be a provision which would enable you to put up construction without sanction plan. Not possible.
My lord, the application for plan sanction was filed and endorsement is issued. Kindly see the first petition. my lord. The endorsement issued by the that they called upon the petitioner to furnish certain details.
He is your neighbor?
He is my neighbor.
He is your neighbor.
He is my neighbor.
Hmm.
The endorsement is placed before the court at annexure G. When this was brought to the notice of the court directed me to file the sanction approval for the layout and pay this WP 4703. Annexure G, page 29.
One Nima petition.
Yes.
Connected.
Even in statement of objection.
Annexure G.
Annexure G. In this ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಸೋ ಅಂಡ್ ಸೋ ಅವರು ಅಂತರ್ಜಾಲ ಮುಖೇನ ಈ ಕಚೇರಿಗೆ ಉಲ್ಲೇಖವೊಂದರಂತೆ ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುತ್ತೀರಿ. ಅಂದ್ರೆ ಸ್ವತ್ತಿಗೆ ನಕ್ಷೆ ಮಂಜೂರು ಆತಿಗಾಗಿ ತಮ್ಮ ಮನವಿಯ ಮೇರೆಗೆ ಸ್ಥಳ ಪರಿಶೀಲಿಸಲಾಗಿ ಉಲ್ಲೇಖ 2ರಂತೆ ಮಾನ್ಯ BDA ರವರ ಕಾರ್ಯಪಾಲಕ ಅಭ್ಯಂತರರು ಪಶ್ಚಿಮ ವಿಭಾಗ ರವರು ರಾಜರಾಜೇಶ್ವರಿ ಬಡಾವಣೆಯವರು ಪ್ರಾಧಿಕಾರದಿಂದ ಸ್ವಾಧೀನಪಡಿಸಿಕೊಂಡು ಜಮೀನುಗಳಲ್ಲಿ ಹಾಗೂ ಹಂಚಿಕೆಯಾದ ಸರ್ವೆಗಳಲ್ಲಿ ಹೊಸದಾಗಿ ಖಾತೆಯಲ್ಲಿ ಕಟ್ಟಡ ನಕ್ಷೆಗಳ ಮಂಜೂರಾತಿಯನ್ನು ನೀಡದಂತೆ ತಿಳಿಸಿರುತ್ತಾರೆ. ಮುಂದುವರಿದು ಉಲ್ಲೇಖ 3ರಂತೆ ಕರ್ನಾಟಕ ನಗರ ಮತ್ತು ಗ್ರಾಮಾಂತರ ಯೋಜನೆ ಕಾಯ್ದೆ ಯೋಜನಾ ಪ್ರಾಧಿಕಾರದಿಂದ ಬಿಡುಗಡೆಗೊಳ್ಳದಿರುವ ನಿವೇಶನಗಳಿಗೆ ಖಾತಾ ನಿವೇಶನ ಇದು ದಿಸ್ ಈಸ್ ಐ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ಎ ಮೆಮೊ ವಿತ್ ದ ಕಾಪಿ ಆಫ್ ದಿ approval issued by the BDA. My lord, this is an approved layout. In the approved layout, now the whole objection of the other side is that on the left side there is no setback left. Therefore, construction is illegal. That is one aspect of it. Now kindly see table number 9, table number 4, my lord. Table number 4 of that bylaw.
Allah, we can't go into all that aspect because you have not even got a plan sanctioned.
No, I applied for the plan, sanctioning the plan. They asked me to furnish certain documents. That is furnished.
Yes.
They are not issuing it.
Correct.
They are not issuing.
You have challenged it.
My lord, that is now challenged.
Can't say there is a deeming sanction plan. Not possible.
My lord, a submission was made by the BBMP that they are in the process of considering the issuance of plan or the issuance of permission to construct without plan. That was his submission. Kindly see the earlier, another writ petition,
That
my
is
lord.
not permissible, sir.
That was
That the clause that you read now from the
Yes.
building bylaws,
less than 4
it will not enable the authority to say, all right, we will not sanction plan, but go construct. Ang sadhyane illa.
My lord, less than 4 meter width. It does not require a
Provision-
setback.
Provision says, no plan shall be sanctioned if the area is lesser than this much, 50 square meters, or the width is less than 6 meters.
My lord, that goes.
But exception is carved out, saying it is still permissible to sanction in certain cases. Therefore, it was for you to convince. See, I've got the property after partition. I have no other plot to put up construction. So you kindly sanction the plan.
That application is there, which
You
is
have
not-
filed.
Yes,
It is not considered.
they have not considered
Then you
it.
should have challenged it.
My lord, now
You should have
that,
sought for a direction.
now that I have challenged it in the another writ petition. There are 2 writ petitions. And my lord, the whole,
We'll direct them to consider them.
my lord, whole contention of the other side is regarding the setback. Because on the left side, the setback need to be lived. I rely on the building bylaws, the table number 4. Kindly see table number 4 in that. That the depth of the site in meters up to 6. My lord, for residential, front there is a 1 meter setback. For the rear, there is no setback need to be left. Would your lordship kindly proceed on to the right side of it? Width of the site in meters, residential, left up to 6 meters, left side, no setback is left. That is because the site is less than 4 meter in width.
Correct.
If a setback is left, that nothing,
You
they cannot
build it.
construct it.
Yes, yes.
That is the reason why this table is drawn.
We will direct them to consider your plan, get the approval, then proceed for construction.
My lord, time bound.
Yes, yes. We will
Because
direct-
I've already lost, my lord, when the construction was halfway through. The writ petition is filed by a neighbor only to spite. And this small plot of 15 by 40, a mother gives it to the daughter for her welfare.
My lord,
Yes.
my lord, what BDA has been approved is a 30-40 site, my lord. It has been divided among them, my lord. Even then, after their
Did
division.
you understand
I understood.
what was read out?
Yes, my lord, understood. That creates a bar on this table, I understood. But what my submission is, my lord.
Read this 7.2, which was read earlier.
I understood, my lord. It creates a bar on sanctioning the plan. There is exception.
Partition ಎಲ್ಲ ಆಗಿದ್ರೆ
Understood.
ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ ಅಂತ ಕೇಸ್ಗಳಲ್ಲಿ ಪ್ಲಾನ್ ಅಪ್ರೂವ್ ಮಾಡಬಹುದು ಅಂತಿದೆ.
Yes, my lord. But
ಲೆಟ್ ದೆಮ್ ಗೆಟ್ ದಿ ಅಪ್ರೂವಲ್.
But what?
ಅವ್ರು ಯಾವ ತರ ಸ್ಯಾಂಕ್ಷನ್ ಮಾಡ್ತಾರೋ ಆ ತರ ಕನ್ಸ್ಟ್ರಕ್ಟ್ ಮಾಡ್ಲಿ.
Yes, my lord. But what my
cannot object.
Yes, my lord. But what my contention is, my lord, even then the setback which they have read out in table number 4, my lord, the left side need not leave the setback.
Yes.
My lord, the site approved by the BDA is for 30-40. For their convenience, they have divided among them, my lord, into 15 half.
Opinions ಅಲ್ರಿ.
My lord, even
ಇರೋದೇ ಹಂಗೆ ಏನ್ ಮಾಡ್ತಾರೆ?
But my lord, my lord, they have to get a sanction. Even for that, they have to get
That
a
is what I
sanction
am
from
directing.
Karnataka
I will
planning.
direct the BBMP to consider the application and give the sanction in accordance with the bylaws.
Even under Karnataka planning act, they have to.
Please leave it to them, sir. Let them consider.
Probably.
You cannot foreclose their rights just
Okay.
because you are a neighbor.
And this,
Every owner has got the right to put up construction, but in accordance with law.
Yes, ma'am.
You can't say, no. There is no provision itself. Don't allow them to put up construction. ಹಂಗೆಲ್ಲ ಹೇಳಕ್ಕಾಗಲ್ಲ ನೀವು.
ಇಲ್ಲ, my contention is
Purple.
that if setback has to be.
The petitioner in WP number 23281 of 2023 is the complainant. And a neighbor of the petitioner in the connected writ petition.
Yes.
We'll stop. The grievance of the petitioner is that the said neighbor who was arrayed as respondent number 5 in his writ petition is putting up construction without obtaining a sanctioned plan at the hands of the competent authority, namely the BBMP. And he is putting up construction without leaving any setbacks. Full stop. During the course of the proceedings, the officers of the BBMP have issued notice to the fifth respondent under section 248 of the BBMP Act 2020, calling upon him to answer as to why action should not be taken for illegal, unauthorized construction and for violation of the provisions of the building bylaws or the BBMP. Full stop. The fifth respondent thereafter filed the connected writ petition WP number 4703 of 2024. Challenging an endorsement dated 5/8/2023 issued by the Assistant Director of Town Planning, Rajarajeshwari Circle, BBMP. Full stop. In the endorsement, it is stated that on an application filed by the fifth respondent herein seeking sanction of a plan for construction of a residential building, instructions are received from the executive officer of the BBMP directing not to register any khatas in respect of
BBMP.
certain areas in Rajarajeshwari Nagar, since the sites were not released for allotment. Full stop. Next para. Learned counsel for the fifth respondent submits that it is clear from the impugned endorsement that the petitioner had in fact filed an application seeking building license and approval of a plan for construction. Full stop. Nothing about nothing is said in the endorsement regarding the plan application filed by the petitioner, and no reasons are assigned for rejection of the application. Full stop. On the other hand, attention of this court is drawn to clause 7.2 of the Bengaluru Mahanagara Palike bylaws, 2003, which provides as follows. 7.2 extract. the learned counsel would further draw the attention of this court to table 4 in the building bylaws and submits that insofar as sites which have a depth of less than 6 meters there is no need for leaving any setback in the rear side and on the left side of the site. Full stop. Setback of 1 meter is required to be left on the front portion of the site and 1 meter on the right side of the site. Full stop. Learned counsel would therefore submit that since the application filed by the fifth respondent has not been considered by the competent authority, necessary directions may be given to the said authority to consider the application and approve the plan in accordance with the provisions contained in the bylaws. Full stop. Next paragraph. Having regard to the submissions made by the learned counsel for respondent number 5, who is also the petitioner in the connected writ petition, and having regard to the provisions contained in the bylaws, more particularly clause 7.2, it is clear that in normal circumstances, approval for construction of a building shall not be granted if the land measures less than 50 square meters or has a width of less than 6 meters. Full stop. However,
50 square meters. The word used is
50.
Yes.
However, exception is carved out in the very same provision in favor of sites carved out for the benefit of low income group, economically weaker section, slum clearance and improvement schemes, as well as reconstruction in case of densely populated areas and plot subdivided due to family partitions.
Yes.
Full stop. The case of the fifth respondent is that the original plot measuring 30 into 40 feet has been partitioned.
Released, my lord. Portion of it is released from the mother.
Between the family members.
Family members.
And half portion of the property has been released in favor of the fifth respondent herein under a registered document. Full stop. Next para. If such is the case, the assistant director of town planning or the competent authority cannot decline to sanction the plan in favor of the fifth respondent here. Full stop. ಖಾತಾ ರಿಜಿಸ್ಟರ್ ಆಗಿದೆ ನಿಮ್ದು?
ಇದೆ, ಅದೆಲ್ಲ ಕೊಟ್ಟಿದ್ದೇನೋ. They asked me for all these, that was, and they also directed me to furnish the details of the release of the sites. That is also filed and copy is filed in this writ petition. Kindly see the memo, my lord, dated 5th June 2024, wherein this approval is issued by the BDA to the layout plan. 5th June 2024.
The fifth respondent has also furnished a copy of
Approval by the BDA for the layout, in which
approval granted to the layout plan at the hands of the Bangalore Development Authority. Full stop. The Assistant Director of Town Planning is required to consider all these documents. Full stop. Moreover, comma, as rightly submitted by the learned counsel for the fifth respondent, comma, ಅಲ್ಲ ಈ ಖಾತಾ ನಿಮ್ಮ ಹೆಸರಲ್ಲಿ ಆಗಿದೆಯಾ?
ಆಗಿದೆ.
Where is it?
ಖಾತಾ ಅಲ್ಲಿ
Annexure D.
D ಅಲ್ಲಿದೆ ತೋರಿಸು.
The Bangalore Development Authority, sorry, BBMP has already registered the khata in the name of the petitioner, as could be seen from Annexure D in WP number 4703 of 2024. Full stop. Therefore, on an application filed by the fifth respondent seeking sanction of the plan for construction, the endorsement issued by the competent authority cannot be sustained. Full stop. Reasons assigned in the impugned endorsement is that directions have been given by the executive engineer not to register the khata. Full stop. It is not the case of the fifth respondent that she approached the BBMP authorities for registration of khata. Full stop. She has approached the competent authority while furnishing the khata certificate that she requires approval of a building plan. Full stop. In that view of the matter, the impugned endorsement issued by ಎಲ್ಲಿದೆ ಅದು?
That is Annexure G. Second rest
dated 5/8/2023 at Annexure G requires to be set aside. Full stop. Next para. Consequently, writ petition number 23281 of 2023 stands disposed of. Full stop. Next para. WP number 4703 of 2024 is partly allowed while setting aside the impugned endorsement at Annexure G dated 5/8/2023 issued by the Assistant Director of Town Planning. Assistant Director of Town Planning, Rajarashwa Nagara Subdivision, BBMP. Full stop. Next. Specific directions are issued to the second respondent, Assistant Director, Town Planning, Rajarajeshwari Circle, BBMP, to reconsider the application filed by the petitioner in WP number 4703 of 2024, having regard to clause 7.2 of the building bylaws and table 4, clause 7.2 and table 4 of the building Bangalore the Bangalore Mahanagara Palike building bylaws, 2003. Full stop. Necessary orders shall be passed as expeditiously as possible and at any rate within a period of 6 weeks. Please, the date of receipt of a copy of this order.
My lord, and
Yes,
one
my
more
request
direct.
For 8 weeks, my lords, 8 weeks.
My
on
lord,
the date.
my lord, maybe one direction may be given, my lord, till the getting a sanction plan, they're not to, they're make.
My lord, that authorities have already informed me.
Not to put
I have not,
construction.
I have not proceeded.
Needless to observe that the writ petitioner in WP number so and so shall not proceed with the construction without obtaining the sanction plan.
Serial number 29, Venugopal MS. Non-filling of
Petitioner in this case.
My lord, survey report is ready, my lord. I'll file in the registry tomorrow itself. Kindly have this matter day after tomorrow. Other.
Learned counsel for the respondent BBMP submits that the inspection report is ready. Full stop. Learned counsel is requested to file the same in the office.
Yeah, I'll
by
file
tomorrow,
I'll serve and file.
while serving a copy on the learned counsel for petitioner. Full stop. Next para. Release this matter on Mikida 26th and Rakido.
26th.
26th. Right, 26th.
Please.
Deeply obliged.
Serial number 30, Akash VT.
Appears for petitioner. My lord, as per now, I have an
Inspection
instruction.
report.
I have an instruction from my client, my lord. The inspection is not conducted yet.
Not conducted.
Not conducted. And there is an IO, my lord. Same may be extended.
Sanjeev ಅವರೇ ನಿಮ್ದೆ
Matter, my lord, the report was ask them. The report is to be submitted. The report is to be submitted in this matter. It will be submitted.
ಅಲ್ಲ ಇನ್ಸ್ಪೆಕ್ಷನ್ ಹೋಲ್ಡ್ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ ಇನ್ನು. Time and date was fixed.
My lord, may I request, my lord, if my lord could fix a date, my lord, I'll see that they go and inspect and file a report.
ಏನಪ್ಪ ಎಷ್ಟು ಸರಿ ಇದೆ
Very
ಮಾಡೋದು
difficult, my lord. I've been asking them, my lord. In fact, from 3 days about this matter, I've been asking. None of them get the response. I've told the commissioner also, my lord. The lordship may fix a date, my lord. I'll see that it will be done. They will inspect it, my lord.
As a last opportunity, at the request of the learned counsel for the respondent BBMP, the concerned revenue inspector is directed to conduct the spot inspection.
Yes.
In the presence of the petitioner.
It is.
On 24th of June 2024.
Yes.
At 10:30 AM. Full stop. The petitioner is also directed to be present at the spot on the date and time fixed by this court. Full stop. Next para. Release this matter on 1st of July 2024 to enable the submission of the report. Yes.
My lord, I owe him.
Interim order granted earlier stands extended till next date.
Serial number 31. Vikhar Ahmad, yes.
I appear for the petition in the matter, my lord. I've been served with a copy of the report, my lord. Report kottidare. It is in conformity with my petition itself.
It is in conformity.
With the petition that I filed. What
Ah.
has happened is, my lord, it is a area, a house, my lord. Can I kindly see my petition?
No, is there any difference?
No, my lord, absolutely no difference in terms of measurements.
Then?
What has happened is the nature of usage is what they are contending, my lord, in the notice sent to me. The building measures 2,450 square feet, my lord.
There is no difference about that.
There's no dispute, my lord.
Ah.
The report given to me also 2,450 square feet, my lord.
Ah.
In the notice given to me, it is their contention that the entire 2,450 square feet is used for commercial purpose. But however, the report that has been filed, my lord, it's very clearly seen that is a house. A house in Enagide, one small room measuring 800 square feet was at one point in time used as a home office, my lord. ಅದಕ್ಕೆ separate electricity bill ಇದೆ, ಅದಕ್ಕೆ separate connection ತಗೊಂಡಿದ್ದೀವಿ. And that is how 1,650 square feet is residential and 800 is.
When was the copy served on you?
My lord, he served by WhatsApp last night, my lord, and this morning also given a copy. Last night by WhatsApp it was served, and this morning a physical copy has been given, my lord.
Because it's not found in the file.
May I pass on a copy, my lord?
No, it has to come. We have directed them to file it in the office.
I believe it was filed this morning, that is why it's not come.
Morning.
This morning they ಹೇಳಿದ್ರು, because last night WhatsApp ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ರು ನನಗೆ.
Release this matter on 26th of June.
Grateful, my lord.
Interim order granted earlier stands extended till the next date of hearing.
It's extended until further orders and something, my lord.
ಹೌದಾ ಹಂಗ ಬೇಡ.
Serial number 32.
Further orders ಅಂತಂದ್ರೆ ಮಾಡ್ಬೇಕು ಇವಾಗ.
Please, my lord.
Yes.
Till next date of hearing.
Yes.
Grateful.
Serial number 32. Sarvana, yes. Inspection report. Serial number 32.
Mr. Pawan Kumar, ಇಲ್ಲಿ. Matter is called out. There is no representation for the petitioner. Release this matter on 26th.
33. Ramakrishna N. Spot inspection.
The respondent lodge, I pray for a short accommodation.
Inspection is held.
Instruction ತಗೋಬೇಕು ಸ್ವಾಮಿ. Short accommodation.
Lama, if they tell us at least that inspection is held, then we can direct you to file it.
Lordship,
Iವರು ಇಲ್ಲ ಅಲ್ಲಿ. Petitioner is also not there. I to release this matter on 26th.
obligate lordship.
Interim order granted earlier stands extended.
Serial number 34. Bayasa BG.
Appear for petitioner in this case, Lord. I am seeking for a 2 days time to file the amended cast title.
In this case, my lord, without any plan, my lord, they have constructed building, 6-floor building, my large building.
Report submit ಆಯ್ತನ್ರಿ.
ಇಲ್ಲ ಸ್ವಾಮಿ.
ಇದಲ್ಲ ಏನಿದು?
ಇದಲ್ಲ.
ಅತ್ತಲ್ಲೂ direction ಇತ್ತು.
This is for violation of the.
But there is no plan itself, my lord. 6-floor building is constructed.
Yes, Lord.
For the owner of the property.
Yes, Lord. I am also the owner of this impeding respondent is also adjacent owner of the property. He has also put up the construction without any plan.
We are not concerned with that, sir. We are concerned with your building.
Because for he has included as a party. Respondent, impleading respondent has included as a party, he is the adjacent owner. He has also put up the construction.
But
building.
Also, I have produced this
construction without sanction plan.
Please, my 6-floor large
ಅದೇ
building
ತರ
is
ಕಟ್ಟಿದ್ದಾರೆ.
Yen, sir, what is this? What submission are you making?
Because for that entire layout, Lord, B khata is there is no plan for that.
And also it is nearer to HA, sorry, airport.
Like 248 ನಲ್ಲಿ ನೋಟಿಸ್ ಇದು ಕನ್ಫರ್ಮೇಶನ್ ಆರ್ಡರ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ. So earlier than 14/3/2024 there is the interim order from this court.
Want to challenge it before the chief commissioner, you do it.
Till that time, Lord, that interim order may be extended.
On the other hand, my lord, my building is badly affected. There is no, my lord, setback area is left out.
ಏನ್ ಹೇಳ್ತಾ ಇರೋದು?
Well, out challenge.
Sanction plan ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
My lord, residential purpose ಗೆ I have constructed my building. It is only
plan ಇಲ್ಲದೆ construction ನಿಂದು ಅದೇ ಗತಿ ಅಲ್ರಿ.
ಹೌದು.
What are you trying to say?
my lord, at the inception, I have, my lord, complained against the my lord, petitioner to the BBMP.
Why did you complain, sir, when you yourself have put up construction without?
My building only for a,
obtaining-
my lord, residential purpose, my lord.
So it can be allowed.
Fourth floor building is there, my lord.
Huh?
Not a fourth floor building, my lord, it is a
Yes, what I placed
residential.
it before this court.
You have no
They have
sanction plan, you
constructed
can't
building
put
for
up
let out,
anything.
to let out the building, my lord, I have a constructed building.
All
It
we
is
will,
nearer to, my lord, HL.
We will
sorry.
direct them to take action against you also. And we will permit him to go before the chief commissioner. Hogi ಅಷ್ಟೇ.
My lord, when I constructed the building, when I started my construction, no
Both the
one has
buildings will
complained.
go. If it is an unauthorized construction, it cannot be sustained.
May I submit, my lord? When I started construction, there
Dimension
is
of
no,
both the sides are
no
one
one
and
has
same.
complained against my, they allowed me to construct the building. Now, my lord, at the inception, I have raised my,
What kind of submission are you making, sir? Our objection raise ಮಾಡಲಿಲ್ಲ ನಾನು ಕಟ್ಬಿಟ್ಟೆ ಅಂದ್ರೆ ಅರ್ಥ ಏನು?
our building, ಆ time ಅಲ್ಲಿ ನಾವು with inception, I have complained. But BBMP has allowed them to my lord, construct the building, large building, 6
ನಿಮ್ದು
floor.
ಹಂಗೆ ಅಲೋ ಮಾಡಿದಾರಲ್ಲ. ಗೊತ್ತಾಗ್ತಾ ಇಲ್ವಾ ನಿಮ್ಗೆ?
My residential purpose ಕಟ್ಟಿದೀವಿ. ಅವ್ರು ನೋಡಿ 6 floor let out ಮಾಡೋದಕ್ಕೆ
ಯಾವ
ಕಟ್ಟಿದ್ದಾರೆ.
ಕಾನೂನು ಆಗಿರೋದು ರೆಸಿಡೆನ್ಷಿಯಲ್ ಸ್ಯಾಂಕ್ಷನ್ ಪ್ಲಾನ್ ಬೇಡ ಅಂತ? ಎಲ್ಲಿದೆ ಹಂಗಂತ?
No, my lord, ನಮ್ಗೆ
ಅಷ್ಟ್
setback.
ಗೊತ್ತಾಗ್ಲಿಲ್ವಾ ನಿಮ್ಗೆ? ಅವ್ರ ಮೇಲೆ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ರೆ ನಮ್ಮ ಮೇಲೂ ಕಂಪ್ಲೇಂಟ್ ಬರುತ್ತೆ ಅಂತ ಗೊತ್ತಾಗಲ್ವಾ ನಿಮ್ಗೆ?
Against this petition, the respondent also issued 248(3) because for he is an employee of that BBMP, the BBMP has not taken any action. Madam. Kindly see.
What
For
do you
him
want?
also,
You are
for
an
him
employee
also
of
issued this
BBMP.
confirmation order.
ಅದು ನಮ್ಗೆ ಗೊತ್ತು. Employee of building. ಅದು ನಮ್ಗೆ instruction ಗೊತ್ತಿಲ್ಲ.
Confirmation order has been issued, madam. For him also.
ನಾ ಕಾಪಿ ನನ್ಗೆ.
ಮತ್ತೆ ಏನ್ರಿ ಮಾಡ್ತೀರಾ ಈಗ? ಆಕ್ಷನ್ ಇಸ್ ಟೇಕನ್ ಅಗೇನ್ಸ್ಟ್ ಬೋತ್ ಆಫ್ ಯು. You suffer. Perfect. Learned counsel for the petitioner submits that during the course of these proceedings, confirmation order has been issued. Yes, sir. By the second respondent under section 248(3) of the BBMP Act, 2020. Full stop. Learned counsel submits that the petitioner has an efficacious remedy to file an appeal before the chief commissioner. Full stop. Next para. In that view of the matter, the writ petition stands disposed of, reserving liberty to the petitioner to approach the chief commissioner if he is aggrieved of the confirmation order passed by the second respondent. Full stop. 4 weeks time is granted for that purpose and to ensure that if such an appeal is filed, the chief commissioner shall also consider any interim relief that would be sought by the petitioner for stay of the confirmation order. Yes.
But till that time interim. Because
number 35.
Needless to observe that for a period of 4 weeks, the respondents shall not precipitate the matter.
so far as this respondent is already 248(3) has issued. It's an employee of that BBMP, that's why they have not taken any action.
35. Ajay Prabhu M. Awaiting.
You want to file one more writ petition against him, you file. This writ petition is only concerning you, your building. Yes.
My lord, for the respondents number 1 to 4 BBMP, my lord.
Huh?
For the respondents 1 to 4 BBMP, my lord.
Huh?
Building, my lord, has been constructed without obtaining sanction plan.
By the petitioner or the other respondent?
By the petitioner, my lord.
Petitioner is a complaint.
By the respondent, my lord. Subsequently, 248, 123 notices have also been issued, my lord.
No, sir, notice has been sent.
Yes.
It is still not returned. List this matter after service of notice on respondent number 5.
Please, my lord.
Number 36. Andish Patel.
Literally, I've just entered appearance recently, my lord. Some time may kindly be granted, my lord. I'll file the report.
Huh?
Kindly permit me to take handsomest, my lord, for R2. R2. 36.
And summons.
Please, my lord.
You are a complainant.
Please. I am
You are a complainant.
petitioner, my lords.
Are you making allegation against the second respondent?
There is an allegation, my lord, the proceedings is going on.
You are making allegation against the second respondent
Second respondent
for
unauthorized construction.
why have you not taken steps?
My lords, the same address they had given, my lord. I have taken steps. They are
Hmm.
saying that it is insufficient address. In their complaint, there is the address they have shown, my lord. Page number 91, they had given complaint. The same address I have taken. Page number 91. They himself given the address.
Postally cover nodi. Respond number 2 though. ಏನಾಗಿದೆ? Door lock. You please take steps.
Please.
Again.
Please.
A week's time is granted.
Please.
At the request of learned counsel for petitioner to take steps, to take fresh steps.
Please.
For respond number 2. Please.
Kindly extend the interim order. There is
Here
an
interim order.
Lords, I have challenged the
Here interim order.
313
interim order
notice.
has been spent?
Only calling for documents, my lord.
There is no interim order.
कि मंजुनाथ गोड़ा के
For petitioner, my lord. Press time for take steps for Art 3, my lord. 2 days time, could my lord. 2 days time for.
I have instructed the concerned officer. I'm awaiting instructions from him. Pertains to illegal construction only.
A week's time is granted. At the request of learned counsel for petitioner for taking steps for service of notice on respond number 3.
Lordship, serial number 32, my lordship. Serial number 32, I apologize, I was not here. In that, they have availed the benefit of OTS scheme that may be disposed of.
They have complied with the demand notice.
32 na?
32, my lordship.
32 ಅಲ್ಲಿ learned counsel for the petitioner submits that the prayer in the writ petition has become infructuous, since the petitioner availed
Compiled the
OTS, the benefit of the OTS scheme.
ಇಲ್ಲ ಇದು OTS ಅಲ್ಲ ಡಿಮ್ಯಾಂಡ್ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ರು ದುಡ್ಡು ಕಟ್ಬಿಟ್ಟಿದೆ.
They have paid the amount, my lordship.
The property tax demand notice issue ಮಾಡಿದ್ರು. We have complied with that notice.
ಪೂರ್ತಿ ಅಮೌಂಟ್ ಕಟ್ಟಿದ್ದೀರಾ?
ಅದು
As per my instruction, they have availed OTS. Anything will be.
And has paid the arrears of tax to the respondent BBMP. Full stop. Next para. Consequently, the writ petition stands disposed of in view of the petitioner paying up the arrears of tax to the respondent BBMP.
Number 38.
I am for the respondents 1 and 2, my lord. A writ of mandamus is sought as against third respondent, my lord, because third respondent is being put up construction by encroaching the property, my lord. Writ of mandamus. We will take action against the respondent 3, my lord, based on the complaint given by the petitioner. Annexure G, my lord.
ಏನ್ ಮಾಡಿದಾರೆ ಇದುವರೆಗೂ?
ಅಲ್ಲ 27(3) ನಲ್ಲಿ ಕೊಟ್ಟಿದ್ದ ಎಲೆಕ್ಷನ್ ಪ್ರೊಸೆಸ್ ಇತ್ತು. ವಿಲ್ ಟೇಕ್ ಆಕ್ಷನ್ ಬೈ ಕನ್ಸಿಡರಿಂಗ್ ದಿ ಅಪ್ಲಿಕೇಶನ್. 27/3/24, the complaint was lodged against the third respondent, my lord, before the concerned.
27/3.
Yes, my lord. Due time, my lord, there is a election process there. That is the reason. We will take action. Apart from that, my lord, the petitioner has filed a suit also against him. He got the interim order.
List this matter after service of notice on respondent number 3. Full stop. In the meanwhile, learned counsel for the respondent BBMP is requested to secure instructions from the respondent officers regarding the action taken
Please, my lord.
on the basis of the complaint given by the petitioner.
My lords, with respect to the office objection, I have produced the enlarged copy, annexure B.
You have produced.
I have produced. It may be over.
Learned counsel for the petitioner submits that he has furnished an enlarged copy of annexure B. Yes.
Number 39, N. Kumar.
My lords, interim order.
I appear for petitioner, my lord.
Interim order.
Yenanta?
Not to put up further construction.
Huh?
Not to put up further construction in Schedule B property.
Interim order granted earlier stands extended till next day.
Great.
I appear for petitioner, my lord, serial number 39, my lord. This petition file, my lord, challenging the endorsement issued by the Tumkur City Corporation, my lord, where my application,
J.
my annexure J is my online copy, my lord. They want signature on the input order, my lord. Kindly see annexure N and this thing, my lord, where it is a downloaded copy, my lord. It's an online copy. It bears no signature, my lord.
Regarding annexure J is over.
My lord, the petition is filed where my application seeking building permission is refused, my lord. But earlier, my lord, the property was owned by one Ranganath Lord, my lord. As per annexure A and B, my lord, the 20 guntas of land has been converted.
Tumkur City
for
Cooperative. Learned counsel Shri A. Nagarajappa is requested to take notice for both the respondents. Learned counsel for petitioner is directed to serve 2 sets of copies of the petition along with annexures on the learned counsel for the respondent. Full stop. Release this matter on 26th of June.
40 Sarvana S.
Appearing for third respondents counsel,
senior
fourth
con-
respondents counsel.
The senior counsel is held up in one Dharwad matter, my lords. May I request for tomorrow or day after tomorrow?
It is against an interim order. Now
Okay.
the authorities under the Sauharda Act held that dispute in respect of enrollment of members at the instance of another primary member is maintainable. As against that order, Miller, they are before your lordships.
At the request of learned counsel for the petitioner,
Nale Beda, next week alone.
release this matter on 26th of June.
Very good.
Interim order may be kindly.
Year interim order.
Other not to publish calendar of events first, ಇನ್ನೇನಿಲ್ಲ. Because 560 members na exclude ಮಾಡಿ election ಮಾಡ್ಬಿಡ್ತಾರೆ.
Yes, sir. That interim order is there, that may be continued. Now I cannot able to say it could be vacated and.
ಅಲ್ಲ ಅದಲ್ಲ. We will have it in 2 days time.
ಅದಕ್ಕೆ ಹೇಳಿ.
If calendar of events are not permitted to be announced, then you will also be in difficulty.
I would be in difficulty, but personally I would have got some difficulty.
It's all right.
That is the reason I am.
All right. Interim order granted earlier stands extended till the next date.
41, Abhishek Uddar, waiting the petitioner.
Matter pertains to the implementation of the order passed by the second respondent.
List this matter after service of notice on respond number 3.
Serial number 42.
A notice has been sent.
Kamruddin.
42 minutes, I appear for respond.
Matter after service of notice.
Minutes, I appear for respond number 4.
Huh?
Yesterday I filed wakalat. My name may be shown.
ತೆಗೆದಾಕ್ಬಿಡಿ. Learned counsel Shri
S. Rajshekar.
S. Rajshekar
Please.
has entered appearance for
Respond number 4.
respond number 4. ಏನು implementing application ಹಾಕಿದ್ರೆ ನಾವು ಡೈರೆಕ್ಟ್ ಮಾಡಿದ್ದ
Pursuant to the
Yes, my lord, you are directed to implement the respondent number 4.
office to verify and show the name of the learned counsel in the cause list.
Please.
Release this matter on 26th
Kindly
of June.
extend the interim order as well.
Interim order granted earlier stands extended till next date of hearing.
Please.
Pleasure.
Serial number 43.
And for the petitioner, my lord, in this, actually, that notice has been issued by the respondent. And the online notice has been, demand notice issued. That is what I filed before this honorable court, my lord. And here with the petitioner challenging the demand notice issued by the third respondent, my lord, building license and sanction plan to the petitioner dated 28/3/2024, my lord.
Annexure C.
Yes, my lord, I am challenging that. My lord, petitioner has filed an applications before this respondent number 3 dated 27/10/2023 before town planning authority, my lord, for sanctioning of building license and this one. So they had been issued demand notice annexes 3. Exorbitant amount has been claimed by the respondent number 3. Hence, I came before this honorable court.
Labor cess amount.
Yes, my lord. Labor cess amount is also 1% they are claimed. The demand notice issued by the respondent town planning department of BBMP, my lord, charge 1% of labor cess in a manner that is not sanctioned by law, my lord. The petitioners are not liable to pay upfront labor cess and service charges on labor cess, my lord. And also,
Is it only regarding labor cess?
not
or,
my lord, not only
next
labor.
page.
Yes, not only,
Next page.
yes.
Complete details are given.
Yes, ma'am. Complete details of actually in the, not only labor cess, but also under annexes.
For fresh sanction plan.
Yes, my lord. And for that, my lord, had been produced before this honorable court. Numerous judgment has been dealt with this honorable court.
Which is the type of order you want?
My lord.
Which is the type of order you want?
Yes, my lord. It has been reissued, my lord, and with regarding to the order has been,
Page number 64.
yes.
Huh?
Yes.
Same. Learned AGA takes notice for response number 1 and 2. Learned counsel Sri KB Munesh Kumar is requested to take notice for response number 3 and 4.
My lord.
Learned counsel for petitioner is directed to serve 2 sets of copies of the petition along with annexures on the learned counsel for the respondent BBMP and a copy on the learned AGA.
And stay might be granted, my lord.
Same type, whatever.
Yes,
page
my
number.
much obliged. Much.
Yes.
Hearing interlocutor application. Serial number 44.
Hearing for the
Oh,
third
I
respondent, my lord. I filed the IFR vacating the interim order, my lord. Loan matter, my lord.
Huh?
Loan matter, concurrent finding is there, my lord.
A client is not
for the
responding to
society.
phone call, my lord.
Please,
Let us
Not
wait.
for the society.
bank, my lord.
Bank.
Please, my lord.
Huh.
No memo for retirement
Retirement is already filed, my lord.
You know?
Memo for retirement.
Retirement is already filed, my lord.
You know?
Client is not responding to my phone call, my lord. We already filed memo of retirement, my lord.
Namangala Pudadilla. Some alternative arrangement has to be made. We can't go on issuing a notice to the parties. I'm not going to do that. You will have to ensure that some alternative arrangement is made. Otherwise, you will continue to be on record. We will dismiss the writ petition for non-prosecution. That's all. I'm not going to allow you to retire like that.
Short date.
Allah, interim order ಕೊಟ್ಟಿದ್ರಾ?
Please, my lord.
He is not complied with the ಮುಗಿತಲ್ಲ ಅಲ್ಲಿಗೆ.
ಅಲ್ಲ, operating portion full interim order.
Huh?
Stay of the order. Execution ಹಾಕಕ್ ಬರ್ತಾ ಇಲ್ಲ. Recovery proceeding at least interim order.
7,92,000 is already paid, my lord.
2020.
Please, my lord. Overdraft loan ತಗೊಂಡಿರೋದು. Till date ತನಕ ಅದು
7,50,000. The petition.
7,92,000.
ಓಡಿ ಲೋನ್ ತಗೊಂಡಿ ಸ್ವಾಮಿ. ಫಸ್ಟ್ ಇಯರ್ ಅವರು ಇಂಟ್ರೆಸ್ಟ್ ಕಟ್ಟಿ ರಿನ್ಯೂ ಮಾಡ್ಕೊಂಡ್ರು. ನೆಕ್ಸ್ಟ್ ಇಯರ್ ಇಂದ ಪೇನೇ ಮಾಡ್ಲಿಲ್ಲ ದುಡ್ಡು. ಫಸ್ಟ್ ಇಯರ್ ಓವರ್ ಡ್ರಾಫ್ಟ್ ಲೋನ್ 7,50,000 ತಗೊಂಡಿರೋದು ಸ್ವಾಮಿ. ಫಸ್ಟ್ ಇಯರ್ ಇಂಟ್ರೆಸ್ಟ್ ಪೇ ಮಾಡಿ ಓಡಿ ಲೋನ್ ನ ರಿನ್ಯೂ ಮಾಡ್ಕೊಂಡ್ರು. ನೆಕ್ಸ್ಟ್ ಇಯರ್ ಇಂದ ಪೇಮೆಂಟೇ ಮಾಡ್ಲಿಲ್ಲ. ಇವಾಗ ನಾನು 7,50,000 ದುಡ್ಡು ತಗೊಂಡಿದ್ದೀನಿ, ಆಲ್ರೆಡಿ ಇಷ್ಟು ಅಮೌಂಟ್ ಕಟ್ಟಿದ್ದೀನಿ, ಇನ್ನು 50,000 ಕೊಡ್ಬೇಕು ಅಂತ ಹೇಳಿ ಕಂಟೆನ್ಷನ್ ತಗೊಂತಾ ಬಂದಿದ್ದಾರೆ. 2 ಕಡೆನೂ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ ಸ್ವಾಮಿ. ಡಿಸ್ಪ್ಯೂಟ್ ಅವಾರ್ಡ್ ಆಗಿತ್ತು, ಅಪೀಲ್ ಹಾಕಿದ್ರು, ಅಪೀಲು ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ ಸರ್.
My lord, annexure G12.
ನಾನು ಸ್ಟೇಟ್ಮೆಂಟ್ ಜೊತೆಗೆ ಇವಾಗ ಎಷ್ಟು ಡಿ ವಿ ಇದೆ ಅನ್ನೋದು ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿದ್ದೀನಿ ಸ್ವಾಮಿ. ಯಾಸ್ ಅನ್ 3621 17 lakhs ಡ್ಯೂ ಇದೆ ಸ್ವಾಮಿ. ಇನ್ನ
17 lakhs.
ಪ್ಲೀಸ್ ಮೇಡಮ್. ಇಂಟ್ರಿ ಮಾಡಿರೋದಕ್ಕೆ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕಿ ರಿಕವರಿ ಮಾಡಕ್ಕೂ ಆಗ್ತಾ ಇಲ್ಲ ಸರ್. ಇಂಟ್ರಿ ಮಾಡಿರೋದಕ್ಕೋಸ್ಕರ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕಿ ರಿಕವರಿನೂ ಮಾಡಕ್ ಆಗ್ತಿಲ್ಲ.
Learned counsel.
My lord, short date may be given, my lord. I will make alternative.
For the third respondent, Cooperative Bank submits that on a submission made by the learned counsel for the petitioner, that the petitioner was sanctioned a loan of rupees 7,50,000 and he has already paid about 7,92,900, comma, interim stay was granted by this court. Full stop. Learned counsel submits that the dispute was raised by the third respondent and an award has been passed by the competent authority. Full stop. Learned counsel submits that as on date of renewal.
Yeah, that's my lord. 36/21, my lord.
36/6/2021.
17,20,285.
The outstanding amount was rupees
17,20,285, my lord.
285. Full stop. Next para. Although learned counsel for the petitioner submits that he may be permitted to retire from the matter, comma, this court has declined the submission made by the learned counsel for petitioner. Full stop. Next para. This matter on 26th of June 2024 to enable the learned counsel for petitioner to take instructions and submit regarding any deposit that could be made by the petitioner, or to ensure that alternative arrangement is made by the petitioner in the place of the learned counsel who is on record. Full stop. Yes.
Interim order may be extended.
Interim order granted earlier stands extended till next date of hearing.
45. Rajendra Kumar Subbi, EP.
Your Lordship, one IA has been filed for modifying the order dated 31/3/2022. Confining the order only to the in respect of the petitioner, not against the entire against whom the order has been passed for recovery of the money, misappropriation of the money. Petitioner has
You are
informed-
appearing for the petitioner,
Your Lordship, I am the impleading applicant here.
impleading the applicant.
I am the, originally I was the complainant in this case. Thereafter, Your Lordship, some inquiry has happened and some office bearers have been found that they have misappropriated 54,62,000 loan
Your
amount.
application has been considered,
Impleading application has been considered.
then you are respondent now.
Yeah, I am the
It was
respondent.
allowed.
Yeah. Yes,
Huh?
yes, Your Lordship. On earlier occasion.
IA number 1 and 2 of 2024. When was it allowed? It was not allowed.
It was allowed on last occasion, Your Lordship. And I have been impleaded also.
So it's not carried out the amendment.
Advocate for the petitioner has informed me that they have no objection to this application. I have been informed like that.
Office shall take note of the orders passed by this court on 21/3/2024, allowing IA number 1 of 2024 and permitting the impleading applicant to be arrayed as respondent number 4. Full stop. Learned counsel for the petitioner has also not carried out the amendment in the cost title.
No, I carried out amendment. I filed amended.
ಮಾಡಿದ್ದೀರಾ?
ಮಾಡಿದ್ದೇನೆ, ಇಲ್ಲಿದೆ.
ಮತ್ತೆ ಯಾಕೆ ಹಿಂಗ್ ತೋರಿಸ್ತಾ ಇದಾರೆ?
Amended
Impleading
cost title, my lord, also I have filed. It's filed on 2nd January 2024.
Immediately I've done.
Two applications were filed, is it?
Yes, your lordship.
Two separate,
Two separate, one for implementing, another for modification of the interim order.
all right.
Amendment ಆಗಿದೆ. I have carried out. madam. Reading it.
ಏನಿಲ್ಲ? Stop. The learned counsel for petitioner has also carried out the amendment in the cost title.
Filed amended
Therefore,
cost title also. madam.
Shri H. Tejasvi shall be shown as respondent number 4.
Yes.
And not as impleading applicant. Then
This application, we have filed
for
for
modification,
of the interim order passed by this honorable court.
what modification?
13/3/2022, there was a order, ex parte interim order.
Hmm.
We want the modification confining the same only with respect to the petitioner hearing, not against everybody. Because of that, this order, the respondent authorities are not able to take any recovery, the money from the office bearers of the society, your lordship, cooperative society.
Prayer, my lord, is to restrict only to the petitioner, my lord, for which, my lord, I have absolutely no objection. To be restricted to only the petitioner, the interim order.
You are the cooperative development officer.
ಹೌದು. ಹೌದು. Misappropriation is done by the office bearers of the society. Lord, that entire order has been stayed.
Berkeley. Order on IA number 1 of 2024. Filed by respondent number 4.
In fact, in my interim prayer, it is there, my lord, insofar as petitioner is concerned, probably by mistake. It should have been typed.
This application is filed by the newly impleaded respondent number 4, seeking modification of the order dated 31/3/2022, whereby this court had passed an ad interim order of stay of the operation and execution of the impugned order dated 6/10/2020 at Annexure E, until further orders, to enable the consideration of promotion of the petitioner. We'll stop. Next para. Learned counsel for respondent number 4 submits that the interim order of stay passed by this court has been taken advantage of by the persons against whom allegations are made regarding misappropriation of funds. Full stop. The learned counsel would therefore submit that this court should restrict the interim order of stay only in respect of the petitioner. Full stop. Next para. The submission made by the learned counsel for respondent number 4 is accepted. IA number 1 of 2024 is accordingly disposed of, while restricting the interim order of stay granted by this court on 31/3/2022 only to the petitioner.
Only insofar as petitioner is concerned.
and not in respect of the other persons against whom action is sought to be taken in accordance with law. Yes.
Bless your lordship.
What more remains, madam? We can dispose of the petition itself. He is not a member or a director of the society.
That order needs to go, my lord. That
Huh?
order, the order has to be quashed,
That's
so
what.
far as I am concerned, my lord. So he may,
Please
she
take instruction.
may not have any objections for that.
Yes. Release this matter on 26th of June,
26th, not 27th or.
27th. All right.
46, order pass, serial number 47, TV Narasimhan.
Appearing for petitioner, my lord. 6 for small accommodation, my lord.
Huh?
6 for small accommodation. Petitioner.
Partly respondent. This is the case, my lord, last attention. The corporation, Hassan Municipal Advocate was asked to furnish whether the convention hall, which could be permissible in the residential zone or not. That information they have to draft to our office, my lord, it is yet to be.
Who is appearing for
Mr. Ravi Shankar appearing.
Ravi Shankar?
Yes, he is the panel advocate for municipal.
Number 3, my lord. Respondent number 3.
There is no representation for
And my application for modification of interim order is also pending. Where I was I am restrained from running my show, my lord, because of an
so
interim.
Ravi Shankar.
A. Ravi Shankar for R4 and 5.
For our 4 and 5 minutes.
Huh.
That's seniors and legs in the other court, my lord. They kindly have done some other.
Where is the zonal regulation?
They have filed it in the counter, my lords.
They have filed.
Yes, my lords.
Namagan copy kottilla.
They have served the copy. One more copy is there. I'll serve it on them.
Yeah, please give it.
So joint copies are also.
March. And he's got any copy.
Learned counsel for response number 4 and 5 has produced the zonal regulation along with a memo dated 11/6/2024. Full stop. A copy of the same has been served on the learned counsel for petitioner. Full stop. However, learned counsel is requested to serve a copy of the zonal regulation on the learned counsel for the contesting respondents. Full stop. Release this matter on 26th.
My lord,
of
kindly extend the interim order, my lord.
Interim order granted earlier stands extended till the next date of it.
Some copies of
Likewise.
Serial number 48.
I appear for the petitioner in this. There's an impleading application as well as vacating application. Your Lord. I may be permitted to file my objections. It may be kindly taken up on Tuesday or Wednesday. My lord.
I'm appearing for the respondent number 5. I am filed the wakalat on 11th June, my lord. Objection in this matter, not to question the provision of cooperative society in section 12(5)(6).
So what has happened is Annexure 8, page number 14, an order under 12(5) came to be passed saying that release certain villages from your jurisdictional operational area so that they can form a new cooperative society in a different village. We have no objection with regard to the formation, your lordships. But one aspect has to be considered: what happens to the loans which have already been availed by this society to the members? Because 12(5) or 12(6), it does not say what happens to the loans. Now, if they go there, the loans which almost around 30 lakhs loans will become defunct, your lordships. I cannot recover it from them because they will become members of a different society. The entire village will go to a different society and they become members of a different society.
Maybe.
Unless they clear the loans here, my lord, they cannot become a member in the other society. It is a fully covered by judgment, my lord. I have produced the copy also.
File my objections. It may be taken up on Tuesday, your lordships.
Yaudar judgment?
My lord, along with my vacating application, my lord, this court has already held, my lord, the existing society cannot stop the other societies, my lord. This is dated, my lord, 6 February 2024, my lord, WP number 100696 of 24. I just read the very small order, my lord. The petitioner, who is the promoter of the cooperative society in question, submitted an application in the.
I think that it is followed another
Yes, yes.
order.
Order.
I have passed that order.
Yes, my lord. So, my lord.
ಅದನ್ನ ತಗೊಳ್ಳಿ ಅದು I think I've discussed in more detail there.
Yes, my lord. 104197 of 21. That is also referred here, my lord. It is referred, and my lord, it
Please take a
says.
copy of that also.
Yes, my lord.
Learned counsel for
I am filed impleading applicant, my lord.
for the impleading applicant in IA number 1 of 2024 submits that this court in WP number 104197 of 2021 has held that there is no bar on the number of cooperative societies that can be registered in an area. Full stop. The said decision has also been followed in a subsequent case in WP number 100696 of 2024. Full stop. Learned counsel submits that a copy of the order in WP number 100696 of 2024 has been furnished along with the application for impleading.
Vacating.
Vacating.
Vacating interim.
For vacating in IA number 2 of 2024.
Yes.
Next, learned counsel for the petitioners is required to go through the said judgments and make submissions. Full stop. Release this matter on 26th of June, 27th. 27.
Submission, my lord. I filed a wakalat for respondent number 5, but our name is not showing in the cast item. 11th.
Learned counsel Shri
Sandesh TB.
Sandesh D.
TB.
TB. B for Bangalore. Submits that he has filed wakalat for respondent number 5. Full stop. Office is directed to verify and show the name of the learned counsel in the cause list.
The interim order may kindly be extended.
Interim order granted earlier stands extended till next date of case.
Serial number 49.
These matters, your lordships are directed to this today, your lordship. These are election matters where your lordship said your lordship would be pleased to dispose it off from the stage at which it was interfered with. Those matters, your lordship.
One matter we have disposed of.
ಯಾವುದು dispose ಆಗಿಲ್ಲ. ಎಲ್ಲ 6 matter ಇವತ್ತೇ ಇದೆ. 3 matters were old filed previously. 3 matters recently were filed.
Yes. Lord, one request, Lord, there is earlier they sought for clarification in earlier 3 writ petition. The state has held that from where even the rule 13D2A in respect of only the society which is come before this court. So the state has held that the rule 13D2A also flows from where it was stopped. Because of that reason, Lord has said that it has to be part. On that occasion, Lord, may I request one thing, Lord? And
you will restrict it only to this the Lord. Petitioners who have come before this court.
Please.
Now they have filed an application for amendment.
Not amendment.
Amendment.
Subsequent.
They have only brought it to the notice.
Subsequent.
Lord, at page 49, my lord, first petition. Page 49, my lord, the first, the reply given by the state at page.
ನೀವು application ಹಾಕಿರೋದು ಯಾವ petition ಅಲ್ಲಿ?
1522 of 2024.
ಅದು ಕೊಡ್ರಿ. ಮೆಮೊನು ಅದರಲ್ಲೇ 15322.
Even the government has filed the same annexure, your lordships, by way of.
ಅದೇ
49.4.
Annexure R is the.
These writ petitions have been filed by members of various cooperative societies aggrieved by the impugned government order bearing number CO 34 CLM 2024 Bengaluru dated 5/6/2024.
Page 53.
We'll stop. Next para. The impugned government order was issued on 5/6/2024. Permitting the holding of elections to the cooperative societies which were earlier interfered due to the parliamentary elections and the notification of the model code of conduct. Full stop. However, it is contended that in the impugned order, government order,
Or 3, 4, 5.
certain conditions are imposed which are detrimental to the interest of all such cooperative societies who had commenced the process of election much prior to the issuance of the model code of conduct. Full stop. Learned senior counsel Sri Jaikumar S. Patil, appearing on behalf of some of the petitioners, had pointed out that some of the petitioner societies and the members had earlier filed such writ petitions being aggrieved of
Notification. date-
Another notification dated 21/3/2024. Full stop. Learned Senior Counsel points out to an interim order passed by this court on 25/4/2024 in WP number 11962 of 2024, clubbed with WP number 10141 of 2024 and 10280 of 2024, and submits. That in paragraph number 1 of the notification, it was directed that the existing board of management would continue till 6/6/2024, and the question of appointing arbitrator, administrator or special officer would not arise. Full stop. However, the submission of the learned senior counsel was also recorded that the work involved as contemplated under Rule 13-D(2) of the Karnataka
Capital E.
Cooperative Societies Rules, 1960 would be around 60 days, and accordingly, even after 6/6/2024, the benefit at paragraph number 1 of the notification dated 21/3/2024 needs to be extended till the actual holding of election. Full stop. For easy reference, the entire order dated 25/4/2024 is extracted herein below. Purti extract ಮಾಡ್ಕೊಂಡು. In view of the directions issued by this court, the Additional Chief Secretary of the Department of Cooperation made a written communication dated 23/5/2024 to the State Cooperative Election Authority clarifying that it would not be permissible to permit the continuation of the election process during the operation of the election code of conduct, model code of conduct. Full stop. Nevertheless, it was also clarified that if the process of election were set in motion in accordance with law, having regard to Rule 13(D)(5) and (3), in all such societies, the process will be permitted to be continued from the stage when it was interfered. Full stop. Next para. Learned senior counsel submitted that in spite of such an assurance given by the state government, nevertheless, in the impugned government order dated 5/6/2024, it is directed that elections can continue for those societies where calendar of events are issued, and other societies ought to restart the election process after considering the year 2023-24 AGM and complying with Rule 13D. Full stop. Learned senior counsel therefore submitted that the state government should not be permitted to approbate and reprobate according to its convenience. Full stop. Next para. However, during the course of these proceedings, the state government has issued a corrigendum order dated 13/6/2024, clarifying its earlier government order dated 5/6/2024. Full stop. It has been clarified that in all cases where the process of election were commenced and halted as on 21/3/2024, it would be permissible to continue from the stage where it was stopped due to the issuance of the notification at the hands of the state government. Full stop.
First point is only for returning officer issue ಮಾಡಿರೋದಷ್ಟೇ.
Calendar of event is.
Calendar of events only by the returning officer.
Next para. Nevertheless, learned senior counsel submitted that the position again remains that only in cases where the returning officer had published the calendar of events, it would become permissible to commence from the stage when which the election process were halted. Full stop.
The Rule 14(3), form number 12, returning officer issue. 14(1).
Learned the senior counsel would therefore submit that having regard to the fact that the petitioners had earlier opposed this court and a specific direction was issued by this court in respect of the petitioner societies, and it was clarified by the state government that it will permit the continuation of the election process in respect of the petitioner societies from the stage when which it was halted, this court should clarify the modified government order so that the process of the elections insofar as the petitioner cooperative societies are concerned shall proceed from the stage when which it was halted.
Calendar of
Full
events
stop.
already been announced.
Next para. Having regard to the submissions made by the learned senior counsel and having found that insofar as the petitioner cooperative societies are concerned, specific directions were issued by this court seeking clarification at the hands of the state government. And the state government, through the additional chief secretary, Department of Cooperation, has specifically stated in the communication dated 23/5/2024 that the petitioner societies will be permitted to continue from the stage when which the election process were altered. Full stop. Next para. At this stage, learned AGA submits that the if this court were to issue directions clarifying the government orders, including the corrigendum order dated 13/6/2024, the benefit should be restricted only to the petitioner cooperative societies, since specific directions were issued by this court only in respect of the petitioner cooperative societies. Full stop. Next para. The submission made by the learned AGA is accepted. Full stop. Next para. Consequently, the petitions are disposed of with a specific direction to the
Written election officer.
State Cooperative Election Authority and the returning officers,
Election of.
election officers to continue.
Returning officer, calendar of events ಆಗಿರೋದ್ರಿಂದ.
ಆಗಿಲ್ಲ ಇನ್ನ ಆಗಿಲ್ಲ.
Lord, my request, my lord, R3 and R4 may be directed to continue the election.
Other cooperative election authority and regional commissioner.
Regional commissioner. He is the election officer.
And the regional commissioner, Bangalore division and election officer and Apex Cooperative Societies election officer to continue the process of election insofar as the petitioner cooperative societies are concerned from the stage when it was halted in view of the issuance of the model code of conduct and the notification and government order dated 21/3/2024. Full stop. It is specifically clarified that although the returning officer had not issued the calendar of events insofar as the petitioner cooperative societies are concerned, nevertheless, the process of election shall commence from the stage when it was halted, only insofar as the petitioner cooperative societies are concerned, ordered accordingly.
Lordships,
Lord, may I request?
15/6/78, your lordships, it should be respondent number 5 society. Because in 15/6/78, the petitioner is a delegate. Response, Apex society, federal society na respondent ಮಾಡಿದ್ರು. ಬೇರೆ ಬೇರೆ petition ಅಂದ್ರೆ rank of the party ಬೇರೆ ಬೇರೆ.
society ಇರೋದು.
3 society.
ಹೇಳ್ಬಿಡಿ, please tell the names. Please tell the names of all the 3 societies.
15/222, the society is Karnataka State Cooperative Consumer Federation in 15/222, man. In 15,678, it is Shumoga, Davangere and Chitrudurga District Cooperative Milk Producers Union. And in 15,653, it is Karnataka State Cooperative Housing Federation.
All right. Yes. Writ petition infructuous ಆಗ್ತದೆ ಸ್ವಾಮಿ, ಅದೊಂದು clarity. The 3 writ petition has become infructuous because they have challenged the earlier notification 21. Anyway, all the 6 are disposed of. Published, yes. All right, all other matters next week. Lordship, number 35, number 35. Lordship, there was specific direction for the BBMP to obtain the instructions, my lordship.
May I make one request?
So hence, my lordship, be listed on next week.
Serial number, my lords, 54. Lords, that 1970, my lords, they have sold as my lords plots. Now the Udupi Urban Development Authority is not approving the single layout plan. Lords, on the last date of hearing, directed the Udupi Urban Development Authority to look into section 17 of my lords, Karnataka Town and Country Planning Act and
objection made, I copy it beyond the notice.
ಹಾಕಿದ್ದಾರೆ ಇವತ್ತು. My only request is my lords, next Monday or Tuesday.
ಯಾವ್ದು ಡೇಟ್ ಕೊಡಕ್ ಆಗೋದಿಲ್ಲ ಈಗ. ಒಂದ್ರಲ್ಲಿ ಕೊಟ್ರೆ ಎಲ್ಲಾದ್ರಲ್ಲೂ ಕೇಳ್ತಾರೆ. I have directed that all those matters which are not reached today will be listed next week. 35, my lords. Huh?
Serial number 60. People property father asking to get WCG. I need to give you.
Early, next week. Serial number 35, my lordship. I was held up for other court, my lordship. ಯಾವ್ದು?
35.
I was held up for other court, hence I could not make submission. As my lordship, the last time occasion, last occasion direction. Awaiting service of.
But there was a specific direction for the BBMP. This is a where my lordship, but demolition process has been taken up by the BBMP. They have to intimate regarding that, my lordship.
ಅದಾಗ್ಲೇ ಹೇಳಿದೀವಲ್ಲ. Let us see, let it come up next week.
Serial number 53 null interim order may kindly be extended.
ಬೇಡ, no, those matters which have not reached, there is no need for extending, please.
ನಂತರ ಡೇಟ್ ಕೊಡ್ತೀನಿ.
ಡೇಟ್ ಕೊಡಕ್ಕೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ ಡೈರೆಕ್ಷನ್ಸ್ ಕೊಡ್ತೀವಿ ಅಷ್ಟೇ, ಅವ್ರಿಗೆ ಹೇಳಿದೀವಿ. ಸೀನಿಯರ್ ಡಿವೈಸ್ ಬರುತ್ತೆ, ಟರ್ನ್ ವೈಸ್ ಬರುತ್ತೆ, ಡಿ ಗ್ರೂಪ್ ಮಾತ್ರ. ಆರ್ಡರ್ ಸರಿ ಎಲ್ಲ ಇದೆ ಬರುತ್ತೆ ಸರ್, ಅದು ಟೆಂಟೇಟಿವ್. ಹೇಳಿದ್ನಲ್ಲ ಸರ್, ನಾಟ್ ನೆಸರಿ, ಅದು ನೀವು ಮೆನ್ಷನ್ ಮಾಡೋದು ನೆಸರಿ ಇರಲಿಲ್ಲ.
ಡೇಟ್ ಕೊಡ್ತಾರೆ ಅಂತ ತಿಳ್ಕೊಂಡಿದ್ದೆ. ಹೋಯ್ತಾ ಇದು? Same society.
ಇದು ಡಿಸ್ಪೋಸ್ ಆಫ್ ಲಾಸ್ಟ್
ಇದು petition number 360.
ಏನ್ ಮಾಡ್ತಾರೆ ಅದು? ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಇರುತ್ತಲ್ಲ, ಅದೇನು ಅಂತ ಸರ್? ಅದೇನು ಸರ್? ಅದೇ ಹೇಳ್ಬೋದಾ?
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರುತ್ತೆ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಡೇಟ್ ಕೊಡೋದಿಲ್ಲ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಷ್ಟೇ.
ಬಟ್ ಬರುತ್ತೆ ಅಲ್ಲಿ ಕಸಿನ್ದು ಸರ್, ನನ್ನ ಕಸಿನ್ ಪರ್ಸನಲ್ ಕೇಸ್, ಖಾತೆ ಟ್ರಾನ್ಸ್ಫರ್ ಅಷ್ಟೇ.
ನೆಕ್ಸ್ಟ್ ವೀಕ್
ಯಾಕಂದ್ರೆ ಬಿ ಗ್ರೂಪ್ ಮೂವ್
ಫೋನ್ ಮಾಡಿದ್ದಾರೆ. ನಾನು ನೋಟಿಸ್ ಬೋರ್ಡಲ್ಲಿ ಕೂಡ ಬರ್ದಿದ್ದೀನಿ, ಬರ್ಲಿಲ್ಲ.
ಯಾವ್ದು ಸೀರಿಯಲ್ ನಂಬರ್?
ಸೀರಿಯಲ್ ನಂಬರ್ 34 ಇದೆ.